Next, page, Defining Epochs. Henny Stridham and Christopher Jevers. 1.1 Introduction examines historical periods shaping the modern state system. Focuses on the evolution of international organizations and legal frameworks. 1.2 The beginnings of the modern state system. 1.2.1 The period from 1500 to 1648. Rise of sovereign states. Decline of feudalism and the Holy Roman Empire's influence. Growth of centralized monarchies. 1.2.2 The period from 1648 to 1815. Treaty of Westphalia, 1648, established principles of sovereignty and non-interference. Expansion of European colonial empires. Emergence of the balance of power doctrine. 1.2.3 The period from 1815 to 1914. Congress of Vienna, 1815, sought to restore stability post-Napoleonic Wars. Concert of Europe, aimed at maintaining peace through diplomacy. Industrial Revolution and rise of nationalism. 1.2.4 The World Wars and thereafter. 1.2.4.1 Outbreak of World War I rooted in militarism, alliances, imperialism, and nationalism. Ended in 1918 with Treaty of Versailles. 1.2.4.2 Wilson's 14-point plan and the establishment of the League of Nations. Woodrow Wilson's 14 points advocated self-determination and collective security. League of Nations, 1919, first global organization for peace, but lacked enforcement power. 1.2.4.3 The mandate system established by League of Nations. Transferred control of former Ottoman and German territories to Allied powers. 1.2.4.4 The build-up to World War II. Failure of the League of Nations to prevent aggression. Rise of totalitarian regimes, Nazi Germany, Fascist Italy, Imperial Japan. 1.2.4.5 Establishment of the United Nations. United Nations, 1945, formed to prevent future conflicts. Key organs, General Assembly, Security Council, ICJ. 1.2.4.6 The Cold War between the East and the West. US versus USSR, ideological and geopolitical struggle. Formation of NATO and the Warsaw Pact. 1.2.4.7 The United Nations and decolonization. UN played a role in granting independence to former colonies. Recognition of self-determination as a principle of international law. 1.2.5 The rise of international organizations. 1.2.5.1 19th century developments. Early international conferences and treaties, for example, Geneva Conventions. Growth of legal frameworks for war, trade, and diplomacy. 1.2.5.2 The League of Nations and the interwar period. First attempt at a global peacekeeping body. Failed due to lack of universal membership and enforcement power. 1.2.5.3 The United Nations and the Bretton Woods institutions. Bretton Woods Conference, 1944, created IMF and World Bank. Aimed at economic stability and post-war reconstruction. 1.2.5.4 The rise of regional, international, organizations. Examples, European Union, EU, African Union, AU, ASEAN. Strengthened regional cooperation in trade, security, and governance. 1.2.5.5 After the Cold War. Growth of global governance and international law. UN peacekeeping expanded. Increased focus on human rights, environmental issues, and economic development. 1.3 If you select critical perspectives. Debates on the effectiveness of international organizations. Criticism of Western dominance in global governance. Issues of sovereignty versus international intervention. Next, page, Study Notes, Defining Epochs. 1.1 Introduction. Jeremy Bentham, 1789, coined the term international law in an introduction to the principles of morals and legislation. Initially referred to relations between states, replacing the older law of nations. States remain the primary subjects of international law, with relations being bilateral, between two states, multilateral, among several states via treaties or international organizations. International human rights law, post-World War II, suggests individuals may be subjects of international law. However, human rights protection remains a domestic public law matter. Individuals claim rights under national law, even when treaties apply. Public versus private international law. Public international law governs state relations, focus of this study. Private international law, conflict of laws, resolves legal conflicts in private law across different jurisdictions. Westphalian System, 1648, introduced three enduring principles. 1. State sovereignty. 2. Legal equality of states. 3. Non-intervention in domestic affairs. Despite criticism of the state-centered model, no alternative has dominated, Koskinian argument. 1.2 The beginnings of the modern state system. Sovereign statehood remains the core principle of international relations and the foundation of international law. States as primary actors, lawmakers, enforcers, and adjudicators of international law. Eurocentric origins of early international law due to conditions in Europe post-1500s. End of feudalism led to demise of feudal overlords in their private dominions. Rise of the state as a res publica, a public entity with central governance. Shift from private rule to governance in the public interest. Emergence of international relations. Sovereign states formed alliances and engaged in external relations for mutual interests. Roman law and international law. Jus gentium versus public international law. Some claim international law evolved from jus gentium, but this is debated. Roman jus civile, applied only to Roman citizens, excluding outsiders. Jus gentium, a general law for all within Roman territory, facilitating private and commercial transactions. Unlike public international law, jus gentium was a precursor to private law, not a framework for state relations. Next, page 1.1 Introduction. Term international law coined by Jeremy Bentham in an Introduction to the Principles of Morals and Legislation, 1789. Initially applied only to relations between states, replacing law of nations in the 19th century. Main subjects of international law: states, with relations being bilateral or multilateral, for example, treaties, international organizations. Development of human rights law post-World War II led some to argue individuals are international law subjects. Counter-argument: human rights protection remains a domestic public law matter. Individuals claiming rights under international treaties do so through national legal systems. Distinction between public and private international law. Public international law, focus of this text, governs state relations. Private international law, conflict of laws, resolves private legal conflicts across borders. State sovereignty remains central, no alternative to statehood has replaced it. Westphalian institutions, derived from the Peace of Westphalia, 1648, emphasize state sovereignty. Legal equality of states. Non-intervention. 1.2 The beginnings of the modern state system. Statehood is the foundation of international relations and lawmaking power. Eurocentric origins, emerged from the end of medieval institutions, feudal system centralized states. Shift from feudal overlords to centralized state governance. Rise of sovereign states engaging in external relations. 1.2.1 The period from 1500 to 1648. Economic expansion and territorial discoveries integrated Europe into a global economy. Key players in early state formation: Portugal, centralized government, maritime expansion, African/Indian Ocean trade. Spain, unification of Castile and Aragon, colonization of the Americas. European colonial expansion. Portugal and Spain engaged in the slave trade. Portuguese power declined, 1580, Spain took control, 1668, Portugal regained independence. Spanish decline due to economic mismanagement and conflicts with England, France, Netherlands. Religious conflicts and state sovereignty. 30 Years' War, 1618 to 1648, devastated Europe, 60 to 70% population loss in some areas. Protestant Reformation, 1517, challenged Catholic Church authority. Conflict between Catholic versus Protestant states influenced international law. 1.2.2 The Peace of Westphalia, 1648, ended 30 Years' War, marking a shift in international relations. Established the Westphalian system. Sovereign states with full control over internal affairs. Equality of states, regardless of religion. Non-intervention principle. Key legal principles emerging from Westphalia. 1. Religious tolerance. Civil and political rights should be independent of religious beliefs. 2. Sanctity of treaties. Agreements must be honored in good faith. 3. Peaceful dispute resolution required waiting periods and collective action against violators. 4. Balance of power. No state should dominate others, emphasized peaceful coexistence. 1.3 Key legal thinkers. Francisco de Vitoria, 1483 to 1546, discussed the Jus gentium, Law of Nations, in relation to world citizenship. Francisco Suarez, 1548–1617, distinguished between Jus gentium inter se, international law between states. Jus gentium inter se, similar national legal principles. Comparative law. Alberico Gentili, 1550–1608, early advocate of secular international law. Hugo Grotius, 1583–1645, father of international law. Tajiri Belliaci Passes, 1625, addressed just war theory and laws of war. Juan Bello. Mare Liberum, 1609, established freedom of the high seas, now in UN Convention on the Law of the Sea, 1982. Other influential thinkers. Cornelius van Binkershoek, 1673–1743. Richard Sich, 1590–1660. Samuel Pufendorf, 1632–1694. Conclusion. Modern international law evolved from state sovereignty and historical conflicts. The Westphalian model remains the foundation of international law, emphasizing state sovereignty, legal equality of states, non-intervention. Key legal principles developed through historical events and intellectual contributions, shaping contemporary international law. Next page. 1.2.2 The period from 1648 to 1815. Post 1648, European power struggle dominated by Netherlands, Britain, and France. Netherlands gained independence from Spain, 1609, formal recognition in 1648. Strong economy, military, and maritime power. Dutch East India Company, 1602, facilitated trade, especially in the East Indies. France replaced Spain as hegemonic power in Europe. Peace of Westphalia, 1648, and Treaty of the Pyrenees, 1659, expanded French influence. French language became dominant in diplomacy and education. France versus Britain. Conflict over maritime and overseas territories. American War of Independence, 1775 to 1783. British colonies in North America, with French support, gained independence, 1776. Formation of United States of America, a new subject in international law. 7 Years' War, 1756 to 1763. Britain defeated France, gaining North American and Canadian territories. Rise of the nation-state. New concept of a voluntary political association under a common government. Interchangeable use of nation and state in international law. U.S. political structure based on popular sovereignty, unlike monarchies. Napoleonic Wars, 1803 to 1815. Napoleon Bonaparte, 1799, seized power in France. Expanded French rule across Europe, creating an empire. Counter-coalition by Britain, Russia, Prussia, Austria ended French expansion. Battle of Waterloo, 1815, led to Napoleon's defeat. Congress of Vienna, 1815. Great powers, Britain, Russia, Prussia, Austria, met to restructure Europe. Aimed to maintain peace by preventing any single state from dominating. No formal institution for regular meetings, instead, an ad hoc coalition. 1815 to 1870, 20 meetings, successfully preventing major wars for 3 decades. 1850 onwards, European power balance unraveled, leading to conflicts. 1.2.3 The period from 1815 to 1914. Challenges to Vienna settlement. Ignored key issues of national liberation, national unification, and liberal governance. 1848 revolutions fueled nationalist movements across Europe. Unification of Germany, 1864 to 1871. Led by Otto von Bismarck through wars against Denmark, Austria, and France. Creation of German Empire, 1871, shifted European power balance. Increased military competitiveness led to World War I, 1914 to 1918. Concert of Europe. Work due to shared moral standards, diplomacy, and accommodating conflicts. France was included in 1814 peace talks despite its losses, ensuring stability. 1870 Franco-Prussian War. France humiliated, lost Alsace-Lorraine to Germany. Resulted in Franco-German hostility, fueling future conflicts. European alliances and militarization. Germany-Austria alliance isolated Russia. France-Russia alliance, 1894, countered Germany. Britain joined France and Russia, 1907, forming Triple Entente. Berlin Conference, 1884 to 1885. Called by Bismarck. Regulated colonial acquisitions in Africa. 14 European powers attended, but no African representatives. Berlin Act, 1885. Article 34. Colonial powers must notify each other of new acquisitions. Article 35. Required establishment of authority in occupied areas. Congo Free State. King Leopold II of Belgium claimed Congo as personal property. Extractive, exploitative rule despite international recognition. Colonial justifications. Terran alliance theory. Non-European territories deemed unowned under international law. Ignored existing African political systems. Protectorate treaties. Not considered binding in international law. Allowed European powers to justify occupation without legal accountability. Next page. 1.2.3 Acquisition of rights by colonial powers. If colonial powers did not acquire rights through treaties, then occupation must have been the true source of acquisition. Article 35 of the Berlin Act linked occupation with the obligation to establish an authority to protect existing rights and trade freedoms. Colonial arrangements and their effects on indigenous populations remained an international issue even after the UN Charter's trusteeship system was established. Western Sahara Case, 1975, ICJ. Morocco and Mauritania objected to Spain granting independence to Western Sahara, arguing the territory belonged to them when Spain colonized it in the 1880s. The ICJ was asked whether Western Sahara was Terran alliance at the time of colonization. ICJ rejected Terran alliance. The region was inhabited by organized tribes under chiefs capable of representing them. Spain had entered agreements with local chiefs rather than claiming sovereignty over an unoccupied land. The ICJ reaffirmed that sovereignty acquisition was generally through agreements with local rulers, not unilateral occupation. Such agreements were considered derivative sources of title, not original titles based on Terran alliance. This further exposed the inconsistencies of the Berlin Act's occupation principle. The ruling confirmed that treaties between colonial powers and African rulers were valid under international law, meaning non-compliance amounted to a treaty breach. 1.2.4 The World Wars and Thereafter. 1.2.4.1 Hague International Peace Conferences, 1899 and 1907, 1899 Conference, Tsar Nicholas II, Russia. Aim to limit war, reduce armament spending, and promote lasting peace. 26 states attended, 6 non-European, no African sovereign nations invited. Key outcomes. Convention for the Peaceful Settlement of Disputes. Convention on the Laws and Customs of War by Land. Convention adapting the Geneva Convention to maritime warfare. Hague Declarations, banned projectiles from balloons, asphyxiating gases, and expanding bullets. 1907 Conference. Revised 1899 Conventions. Incorporated Hague Declarations into the 1907 Convention on the Laws and Customs of War on Land. Introduced new conventions on hostilities, naval warfare, and an international prize court, never materialized. 1.2.4.2 Outbreak of World War I. Hague Conferences codified international law but did not prevent Britain's scorched earth policy in the Boer War or the outbreak of World War I. War was triggered by the assassination of Archduke Franz Ferdinand, Austria, by a Serbian nationalist on June 28, 1914. Austria declared war on Serbia. Russia mobilized. Germany supported Austria. Germany attacked France. Britain entered the war. Japan joined Britain in August 1914. The Ottoman Empire joined Germany and Austria-Hungary in October. Root causes. Mistrustful alliances. Germany, Austria-Hungary, Ottoman Empire versus France, Britain, Russia. Nationalist tensions and militarization. France-Germany arms race. No consensus on arms limitation at the Hague Conferences. Lack of diplomatic alternatives. 1.2.5 Wilson's 14-point plan in the League of Nations. After 20 million deaths in World War I, global focus shifted from war aims to preventing future conflicts. A liberal international order replaced power politics and military expansionism. Key points from Wilson's 14-point plan, January 8, 1918. Open diplomacy. Peace agreements should be public. Disarmament. Point 4. National armaments should be reduced to the lowest level consistent with domestic safety. Colonial claims adjustment. Sovereignty disputes should consider the interests of local populations. Evacuation and restoration of occupied territories. Creation of the League of Nations, an association to guarantee political independence and global peace. The League of Nations, established by a Treaty of Versailles, June 28, 1919, entered into force January 10, 1920, Part 1 of the treaty, contained the Covenant of the League of Nations, 26 articles. Key articles. Article 8, Disarmament Commitment. Article 10, Collective Security, League members must act against external aggression. Article 11, any war/threat of war was a concern for the League. Articles 12 to 15, peaceful dispute resolution through arbitration/judicial settlement. Article 14, established a Permanent Court of International Justice, PCIJ, predecessor of the ICJ. Article 16, violating covenant obligations led to economic sanctions, trade/financial restrictions, potential military action. Post-World War I disarmament efforts. Article 159 of the Treaty of Versailles required Germany to demobilize and reduce its military. 1926, Germany joined the League of Nations. 1928, Kellogg-Briand Pact, Pact of Paris, signed by 64 states. Article 1, outlawed war as an instrument of foreign policy, still legally binding today. _ These events shaped modern international law, disarmament policies, and the foundations of the UN Charter. Let me know if you need more details on any section. Next. Page 1.2.4.3 The Mandate System. Article 22 of the Covenant of the League of Nations established a mandate system for administering the former colonial territories of defeated powers. Mandate territories were placed under the guardianship of designated states to be guided toward political self-determination. Key principles of Article 22. Former colonies were not yet capable of self-governance. Their well-being and development were a sacred trust of civilization. Administration was entrusted to advanced nations, with mandates varying by the population's development stage. Criticism of the mandate system. Rather than granting real sovereignty, it created new forms of subordination. Territories became part of an economic system controlled by the mandate powers. The system influenced later international financial institutions like the World Bank and International Monetary Fund to regulate relations between developed and developing nations. Categories of mandates. A mandates. Former territories of the Ottoman Empire recognized provisional independence with administrative oversight by Great Britain and France. B. Mandates. Central African territories administered by Britain, France, and Belgium. Conditions. Freedom of conscience and religion. Equal opportunities for trade. Prohibition of slave trade, arms trafficking, and liquor trade. C. Mandates. Southwest Africa, Namibia, and several Pacific islands. Administered under the laws of the mandatory power as an integral part of its territory. Southwest Africa was placed under South Africa, which exercised full administrative and legislative control. Led to disputes, notably the Southwest Africa cases before the International Court of Justice. _ 1.2.4.4 The build-up to World War II. The League of Nations failed as a guarantor of peace, lasting only 20 years before World War II. Four main aggressor states emerged in the 1930s, pursuing expansionist policies under dictatorial regimes. Germany, Adolf Hitler; Italy, Benito Mussolini; Japan, military government; Soviet Union, Joseph Stalin. Germany's expansionism. Hitler's Nazi Party came to power in 1933, aiming to expand Germany's borders. Justifications. Harsh conditions imposed by the Treaty of Versailles. Desire to unite ethnic Germans in Austria, Czechoslovakia, and Poland. Key events. 1935, Hitler repudiated the disarmament clauses of Versailles. 1935, Hitler and Stalin signed non-aggression pacts, secretly dividing Eastern Europe. 1939, Germany and the USSR invaded Poland, triggering World War II. Japan's militarization. 1931, Japan invaded Manchuria against government orders. 1932, military took control, establishing a militarized state. 1937, began the Second Sino-Japanese War, seeking dominance over China's resources. Italy's aggression. 1922, Mussolini established a fascist dictatorship. 1935, Italy invaded Abyssinia, Ethiopia, installing the Italian king. 1936, Germany and Italy formed the Berlin Axis alliance, later joined by Japan in 1940. Outbreak of World War II. 1939, Germany invaded Poland, prompting Britain and France to declare war. 1941, Japan attacked Pearl Harbor, bringing the United States into the war. 1945, the U.S. dropped atomic bombs on Hiroshima and Nagasaki after Japan refused to surrender. Failure of the League of Nations. Inability to act against aggressive Axis powers. Factors weakening the League. U.S. never joined, pursuing isolationism. USSR expelled in 1939 after invading Poland. Economic decline after the 1929 stock market crash reduced the Allies' ability to counter aggression. Historian Paul Johnson called this period the high noon of aggression, argued that totalitarian states ignored international law, pursuing power based on military strength. Next page. 1.2.4.5 Establishment of the United Nations. Objective: prevent a repeat of the failures of the Versailles Settlement and create a stable post-war order. Key conferences and agreements. 1941 Atlantic Charter, secret meeting between Roosevelt, USA, and Churchill, UK, outlining principles for peace. No territorial expansion. Territorial changes only with the consent of affected peoples. Right of peoples to choose their government. Free trade and economic cooperation. Freedom from want and fear. Freedom of the high seas. 1942 United Nations Declaration, signed by the USA, USSR, UK, China, and 22 other states, pledging unity against the Axis powers. 1945 Yalta Conference. Agreed to disarm Germany and divide it into 4 zones of occupation: USA, UK, France, USSR. Planned war crimes trials for Nazi and Japanese leaders. 1945 San Francisco Conference. 50 states drafted the United Nations Charter, establishing the UN. Nuremberg, 1945, and Tokyo, 1946. Tribunals prosecuted war crimes committed by Nazi and Japanese officials. _ 1.2.4.6 The Cold War between the East and West. Origins: post-World War II breakdown in U.S.-USSR relations due to ideological clash, capitalism, USA, versus communism, USSR, competing security concerns and efforts to expand spheres of influence. Key divisions and conflicts. Germany, split into East Germany, communist, USSR aligned, and West Germany, capitalist, US/UK aligned, until reunification in 1990. Korea, split into North Korea, communist, and South Korea, capitalist, in 1948, remains divided. Africa, rebel and liberation movements received military and financial aid from either the US or USSR. Nuclear arms race and strategy of deterrence. Use of nuclear weapons in Hiroshima and Nagasaki led to a shift in military strategy. Mutually assured destruction, MAD. Both sides stockpiled nuclear weapons, ensuring that any conflict would lead to global annihilation. Cuban Missile Crisis, 1962. U.S. discovered Soviet nuclear missile sites in Cuba, October 14, 1962. President Kennedy demanded removal and imposed a naval blockade. USSR initially resisted but eventually withdrew missiles, avoiding war. The Organization of American States, OAS, condemned Cuba for endangering regional peace. _ 1.2.4.7 The United Nations and Decolonization. UN role in decolonization. Articles 1 and 55 of the UN Charter emphasized equal rights and self-determination, led to independence movements in former colonial, mandate, and non-self-governing territories, resulted in a significant increase in UN membership with newly independent developing nations. Impact on South Africa. Apartheid policies conflicted with UN principles on self-determination and racial equality. UN imposed sanctions and international isolation on South Africa from 1945 to 1988. South Africa's refusal to abandon apartheid led to a long confrontation with the UN, eventually contributing to the end of minority rule. Next page. 1.2.5 The rise of international organizations. Definition: international organizations have become key actors in international society and are now recognized as subjects of international law. Growth factors: increasing interactions between states and the complexity of international issues. Traditional bilateral and ad hoc relations became outdated. Part of a broader transformation of international law from coexistence to cooperation. Theoretical perspective: growth is often attributed to necessity rather than an ideological commitment to global government. Distinction: international organizations composed of states, non-governmental organizations, NGOs, composed of private individuals or organizations but perform some public functions. _ 1.2.5.1 19th century developments. Early development, focused on regulating river traffic and other practical issues. 1815 Central Commission for Navigation on the Rhine, Congress of Vienna, First international organization. Objective: ensure free navigation, remove tolls and obstacles. Still exists today, now based in Strasbourg, France. Inspired other European river commissions. Other early international organizations. 1885 International Commission of Navigation of the Congo, Berlin Conference, aimed at free navigation of the Congo Basin but never became operational. Rail transportation, communication, and health services saw similar administrative organizations emerge over the 19th century. Significance: early organizations focused on low politics, technical and administrative matters. This changed with the League of Nations after World War I. Underscore 1.2.5.2 The League of Nations and the Interwar Period. Establishment: created after World War I to promote international cooperation and peace. Inspired by Woodrow Wilson's 14-point speech. Failures and contributions. Generally considered a failure in maintaining peace. However, it played a key role in shaping international organizations. Innovations of the League. First comprehensive international organization aiming to organize global affairs. Open to all self-governing states, dominions, and colonies sought universal membership. Shift from low politics, administrative cooperation, to high politics, peace and security. Introduce new intervention mechanisms for international organizations. Legacy. Despite its collapse, its structures and functions influenced the United Nations, UN. Many organizations created under the League continued, for example, the International Labour Organization, ILO. Next page. 1.2.5.3 The United Nations and the Bretton Woods institutions. Continuation of the League's idea. Despite the League of Nations' failure, the idea of a general international organization for peace and security remained. Negotiations for the United Nations, UN, began before World War II ended. Major powers, led by President Roosevelt, initiated discussions, culminating in Dumbarton Oaks Conference, August 1944, drafting of the UN framework. San Francisco Conference, April 1945. 50 nations finalized the UN Charter. Key differences between the League and the UN. Same goal, maintenance of international peace and security. Different approach, the UN gave great powers permanent membership and veto power in the Security Council. Impact of the Cold War. Limited UN effectiveness in some areas but prevented another world war. Played a major role in decolonization. Despite challenges, international organizations continued to gain influence. Expansion of international organizations under the UN. 15 specialized agencies, including ILO, FAO, ICAO, IFAD, IMO, UNESCO. Bretton Woods institutions, July 1944. Economic Framework for Post-World War II Global Financial Stability. Established. International Monetary Fund, IMF. International Bank for Reconstruction and Development, World Bank. Initial negotiations, led by USA and UK, later formalized at Bretton Woods Conference. Underscore 1.2.5.4 The rise of regional, international, organizations. UN Charter and regional organizations. Encouraged regional arrangements for peace and security. Initially focused on economic and social cooperation, later expanded to peacekeeping. Early regional organizations. League of Arab States, 1945, economic, cultural, social, and health cooperation. Organization of American States, OASH, 1948. Origins, First International Conference of American States, 1889 to 1890. Aims, peace, solidarity, territorial integrity, independence. Adopted the American Declaration of the Rights and Duties of Man basis for Inter-American Human Rights System. Europe. Council of Europe, Co., 1949. European Convention on Human Rights, 1950. European Coal and Steel Community, 1951. Prevented Franco-German conflicts by integrating economic sectors. Expanded into the European Economic Community, 1958, and later into the European Union, EU. Other European organizations. Organization for European Economic Cooperation, 1948. Organization for Security and Cooperation in Europe, 1973. Africa. Organization of African Unity, OAU, 1963. Aims, regional solidarity, economic cooperation, decolonization. Emphasis on security but lacked a dedicated human rights framework until 1986. Other regions. ASEAN, 1967, Southeast Asia. SAARC, 1985, South Asia. CARICOM, 1973, Caribbean. _ 1.2.5.5 After the Cold War. Resurgence of regional organizations in peace and security. UN expanded the role of regional organizations in international peace and security. Boutros Ghali's Agenda for Peace, 1992. Earlier regional groups sometimes clashed with UN efforts. Post-Cold War more harmonized cooperation with the UN Security Council, Chapter 8 of the UN Charter. Developments in Africa. OAU's Mechanism for Conflict Prevention, Management and Resolution, 1993. Aimed at anticipating and preventing conflicts. Formation of the African Union, AU, 2002. Committed to peace, security, and stability. Created Peace and Security Council. Established right of intervention in member states in certain circumstances. Europe post-Cold War. European Union, EU, expansion post-Berlin Wall collapse, 1990s. Economic integration. Maastricht Treaty, 1992, created single market and euro currency, 1999. Council of Europe, CO, expansion. Russia joined, 1996. European Court of Human Rights, ECHR, saw major increase in cases since 1989. Next page. 1.3 If you select critical perspectives. Overview. International law's development is linked to the modern state system and shaped by political, economic, social, and cultural conditions. International law must maintain a normative framework independent of state interests to effectively regulate international relations. Critical perspectives on international law fall into two categories. 1. Theoretical and practical critiques. 2. Responses to colonial and post-colonial realities in international law. _ 1.3.1 Positivist approach. Most influential approach since the 19th century. International law consists of rules states have agreed to through treaties, customs, or consent. Focuses on formal rulemaking rather than ethical or moral concerns. Example, Article 2.4 of the UN Charter prohibits force. Strict positivism may see humanitarian interventions as violations. Criticism. Ronald Dworkin, positivism fails to address moral dilemmas in law application. Hans Morgenthau, realism. Legal positivism ignores the gap between theoretical rules and actual state behavior. Law must consider political, social, and economic realities. International politics is driven by national interest defined as power. Political ethics judges actions based on political consequences. _ 1.3.2 Realist approach. Challenges positivism by emphasizing practical realities of power and national interest. Politics operates autonomously from ethics, law, economics, and religion. Warns against equating state interests with universal moral laws. Reckless moralizing in political decision-making. Advocates pragmatic policymaking that considers global power balances. _ 1.3.3 Marxist approach. Views international law is shaped by economic structures, particularly capitalism. Critiques. The idea of national interest as a mask for class and corporate interests. International legal norms serve capitalist power structures, favoring wealthy states and corporations. Acknowledges that international law can still function independently of dominant class interests but remains constrained by them. Challenges the notion of a single international legal system, given global economic fragmentation. _ 1.3.4 Third World Approach to International Law, TWAIL, highlights the colonial roots of international law. Colonial expansion shaped doctrines and rules that justified imperialism. Key concerns. International law's European origins excluded non-European perspectives. Colonial treaties imposed unequal relationships that persisted post-independence. Post-colonial states are subject to legal norms created by former colonial powers. Calls for a rethinking of sovereignty and global governance from a non-Western perspective. Mohammed Bediaoui, international law historically served European, Christian, mercantilist, and imperialist interests. Recent developments. Growing interest in African approaches to international law. Conferences, for example, 2017 Roundtable, 2018 Kebim Bay Conference, exploring African perspectives. _ 1.3.5 Feminist approaches to international law. Critiques international law for being male-dominated in both structure and content. Organizational critique. Power structures in international law are controlled by male elites. Men's concerns dominate legal discourse, while women's issues are marginalized. Normative critique. Legal principles privilege male perspectives. Example, the Torture Convention, Article 1.1, uses only masculine pronouns and excludes gender-specific violence. Separation of public, international law, and private, domestic law, spheres disadvantages women. Human rights concerns. Freedom of religion, can be used to justify gender discrimination. Family rights, often protect patriarchal structures that enable gender-based violence. Advocates for a gender perspective in international law to challenge orthodox assumptions. Underscore. 1.3.6 Reflection on critical perspectives. Marxist, Twale, and feminist critiques highlight Western dominance in legal norm setting. However, the increasing role of diverse global actors challenges this view. International Campaign for the Banning of Landmines, 1997, Civil Society Influenced Treaty Adoption. UN 2030 Sustainable Development Goals, Global Civil Society actively shaped policies. Democratic states are increasingly influenced by international and national lobby groups. Underscore. Conclusion. Critical perspectives provide valuable insights into the biases and limitations of international law. Theoretical approaches, positivism, realism, influence legal interpretation and enforcement. Post-colonial, Marxist, and feminist critiques challenge the Eurocentric and male-dominated nature of international law. Emerging movements suggest a shift toward a more pluralistic and inclusive international legal system. Next page. Statehood and recognition. 2.1 Introduction to Statehood. States as central subjects of international law play a dominant role in structuring international legal order, integral to modern legal, political, and social frameworks. Depicted through political geography, territorial states on a map. Challenges to statehood. States and sovereignty under constant debate. Nietzsche called the state the coldest of all cold monsters. Brierley, 1924, referred to the state as an idolent theatri. South Africa's role in statehood development. One of the first African states recognized, Statute of Westminster, 1931. League of Nations mandate over Southwest Africa, now Namibia. Apartheid government's refusal to relinquish control influenced self-determination principles. Attempted creation of Bantustans, nominally independent states, failed due to lack of recognition. 2.1.1 Defining statehood. No universally accepted definition of statehood. Various reasons for definitional challenges. Political considerations. Structural nature of the state. Montevideo Convention, 1933, provides four widely accepted criteria. 1. A permanent population. 2. A defined territory. 3. A government. 4. Capacity to enter into relations with other states. Debate over Montevideo criteria. Declarative theory of statehood. States exist if they meet the Montevideo criteria. Constitutive theory of statehood. States exist only if recognized by others. Montevideo criteria used to describe rather than prescribe statehood. 2.1.1.1 A defined territory. States are territorial entities. Defined territory includes land, territorial sea, and airspace. Variation in size. Example, Vatican City, less than half a square kilometer. Some states are non-contiguous, for example, Alaska and Hawaii is part of the USA. Disputed borders are common, for example, Israel. North Sea Continental Shelf Case, ICJ. No rule requiring fully delimited land frontiers. Example, Albania's admission to the League of Nations. Climate change challenges. Rising sea levels affecting island states. Some scholars argue territory must be reasonably ascertainable. 2.1.1.2 A permanent population. States consist of people. No minimum population requirement. Example, Vatican City, 768 inhabitants in 2006. Legal requirement. Population does not need to be nationals. Must have a legal or political relationship with the state. Some scholars emphasize an organic population distinguishable by identity, culture, and customs. Underscore. This is a structured summary of the first part. Let me know if you want me to continue with the rest. Next page. 2.1.1.3 Effective government. A state requires an effective government, considered by some as the most critical element of statehood. Debate exists on whether government and statehood are distinct or interdependent. ICJ in the Western Sahara case, no international law rule mandates a specific government structure. Effective government implies general control over territory, excluding other entities, unrivaled possession of public power, Craven and Parfit. Recognition of statehood follows once control is established. Example: Apartheid South Africa versus Bantustans. Both had unacceptable governance, violating self-determination. Only Bantustans lacked effective territorial control, affecting their statehood. Underscore 2.1.1.4 Capacity to enter relations with other states. States must have the capacity to engage with other states through treaties, diplomatic exchanges, international court participation. Debate on its significance. Abbas, it is the strongest certification of state sovereignty. Some link independence to this capacity. Island of Palmas Arbitration, 1928, PCA. Sovereignty equals independence. Independence means the exclusive right to exercise state functions over a territory. Crawford's distinction. Formal independence, initial qualification. Actual independence, condition for continued existence. International law protects independence once established. Underscore 2.1.2 The new criteria for statehood. Montevideo criteria, define territory, population, government, relations capacity, are widely accepted. Debate exists on whether additional criteria apply. Crawford's additions. Independence as a fifth criterion, most important. Legal principles. Self-determination. Prohibition on use of force. These may override effectiveness in some cases. Southern Rhodesia, 1960s, met statehood criteria but was disqualified due to self-determination violations. Congo, 1960, lacked effective government but was recognized due to self-determination. Legal principles increasingly influence state creation, reflecting the rise of legality in international law. Criticisms. Expanding criteria undermines legal objectivity. Some proposals, for example, willingness to observe international law, stretch facticity too far. Underscore 2.2 Statehood and recognition. State formation is controversial, largely discussed in terms of recognition. Two main theories. Constitutive theory. Recognition creates statehood. States had full discretion in recognizing new states. For example, apartheid South Africa's Bantustans depended on global recognition. Criticism. Grants too much power to existing states, making statehood political rather than legal. Declaratory theory. Statehood exists once criteria are met, regardless of recognition. Recognition is merely declaratory, not legally required. Evolved from pure factuality to legal status under international law. Crawford, statehood is a legal status, not a mere fact. Recognition serves as evidence, not a condition for statehood. Critiques. Constitutive theory. Too political, allows arbitrary decisions. Leads to ambiguities, for example, entities recognized by some but not all states. Declaratory theory. Strengthens the role of international law. Still complex, realpolitik versus legal principles debate remains. Next page. 2.1.1.3 Effective government. A state must have an effective government, as all other criteria depend on it. Debate exists regarding the distinction between state and government. Government need not follow a specific form, for example, democracy. ICJ in Western Sahara case, no rule in international law mandates a specific state structure. Effective government. General control over its territory, excluding other entities. Craven and Parfit, government must demonstrate unrivaled control of public power. Once control is established, recognition of statehood may follow. Example, apartheid South Africa versus Bantustans. Both had unacceptable governments, violated self-determination. Only Bantustans lacked effective control over their territory. 2.1.1.4 Capacity to enter into relations with other states. A state must have the capacity to engage in foreign relations. Evidence through treaties, diplomatic exchanges, and international court access. Debate on significance. Abbas, capacity to engage in foreign relations is the strongest indicator of sovereignty. Some scholars see independence as part of this requirement. Island of Palmas Arbitration, 1928. Sovereignty equals independence right to exercise state functions exclusively. Crawford. Independence is separate from other criteria but is the most important. Distinguishes formal independence from actual independence. Independence is required for initial statehood and continued existence. International law protects states' independence once established. 2.1.2 The new criteria for statehood. Montevideo criteria, 1933. Define territory. Permanent population. Effective government. Capacity to enter foreign relations. Debate on additional criteria. Crawford adds independence as the most crucial factor. Effectiveness-based criteria can be overridden by legal principles. Self-determination principle. Prohibition of force. Entities violating self-determination, for example, Southern Rhodesia, 1960s, are not states. Others lacking effective government, for example, Congo, 1960, still qualify due to self-determination. Rise of legality and statehood recognition. Criticism. Expanding criteria, for example, willingness to observe international law, blurs factual basis of statehood. 2.2 Statehood and recognition. Debate. How do states come into existence? Recognition theories. 1. Constitutive theory. Statehood depends on recognition by other states. Wagner, 1815. A state becomes an international person only through recognition. Recognition equals tool of statecraft, full discretion for existing states. Example, apartheid-era South Africa's Bantu stance dependent on external recognition. 2. Declaratory theory. Statehood exists when Montevideo criteria are met. Recognition only acknowledges pre-existing statehood. ICJ and Crawford. Creation of states is governed by international law, not politics. Recognition is evidentiary, not constitutive. 2.2.1 The Great Debate on Recognition. Criticism of constitutive theory. Grants existing states too much discretion. Politicizes recognition, making it a power tool. Unclear legal status of unrecognized entities. Criticism of declaratory theory. In practice, recognition still plays a crucial role. Challenges. What are the criteria for statehood? Who determines when criteria are met? Kelson, no absolute legal facts. Facts are established through legal procedures. Possible collapse into constitutive theory if recognition decides when criteria are met. Third way theories. Lauterpact. Recognition should be a duty once statehood criteria are met. Dugard, 1987. UN admission could serve as collective recognition. Neither gained wide acceptance. 2.2.2 Missing perspectives on state emergence. Statehood requires two elements. 1. Constitutive element. Monopoly on military and police power within defined territory. 2. Qualifying element. Legal community linking government, people, and territory. Montevideo criteria align with these elements. Example, Venezuela crisis, 2018-19. Juan Guaido declared himself president. Recognized by 50-plus countries. Lacked effective control, military remained loyal to Maduro. Recognition alone did not grant de facto authority. Recognition and international relations. Recognition allows states to conduct diplomacy. Non-recognized states are excluded from international relations but maintain domestic governance. Montevideo's fourth criterion. Capacity to enter foreign relations follows from an effective government with defined powers. Next. Page 2.2.3 19th century, revolution, recognition, and colonialism. Emergence of modern statehood. The 19th century saw the development of statehood as a key concern in international law. Three major developments. Secession of colonies in the New World, started with the U.S. in 1776, followed by Spanish colonies in Central and South America, prompting legal debates on non-European states. European revolutions, shift from dynastic legitimacy to effective control as the basis for sovereignty. European imperial expansion, colonization of Africa by European powers, for example, British, French, German, Belgian empires. Rise of the constitutive theory of recognition. Henry Wheaton, 1863, argued that internal sovereignty does not require recognition, but external sovereignty does. This justified the exclusion of African entities from statehood, facilitating European colonization. Berlin Conference, 1884-1885. European powers agreed on rules for acquiring new territory, led to formal European sovereignty over Africa and the creation of colonial borders that later defined post-colonial states. 2.2.4 The Interwar period, the Montevideo Convention, and declarativism. Shift from constitutive to declarative theory of statehood. Driven by changes in the international legal order after World War I. The Montevideo Convention, 1933, outlined four criteria for statehood. A. Permanent population. B. Defined territory. C. Government. D. Capacity to enter into relations with other states. Impact on international law. The Montevideo Convention sought to curb great power interference, marked the decline of the constitutive theory and the standard of civilization doctrine. Effect on Africa. Despite declarativism, most African territories remained under colonial rule. The League of Nations mandates and growing anti-colonial movements laid the groundwork for future independence. 2.2.5 Decolonization and political self-determination. United Nations, UN, and the principle of self-determination. Recognized in the UN Charter, 1945, as a means for colonial territories to achieve sovereignty. Post-World War I developments leading to decolonization. Woodrow Wilson's 14 points, 1918, limited self-determination to European nations. League of Nations mandate system, 1919, initiated a process for eventual independence. Growing anti-colonial sentiment, triggered by African participation in global conflicts. UN mechanisms for decolonization. Chapter 11 of the UN Charter obliged colonial powers to promote self-government in non-self-governing territories. 1960 Colonial Declaration affirmed the right to independence and led to rapid decolonization. Western Sahara Case, ICJ, affirmed that self-determination determines sovereignty, not pre-existing colonial claims. Challenges of decolonization and statehood theories. Decolonization altered traditional statehood criteria. Many African states gained independence despite lacking effective governance. Montevideo criteria were relaxed in favor of self-determination. Utai Posedatus principle maintained colonial borders post-independence, solidifying imperial legacies. Unresolved issues. Western Sahara dispute. Morocco's claim persists despite the Sahrawi Arab Democratic Republic, SADR, being an AU member. Recognition debates post-decolonization. Statehood discussions continue in cases like Rhodesia and Bantustans in South Africa. Next page. 2.2.6 Post-Cold War, the revival of recognition. Due to strong political support for decolonization, recognition was largely uncontested for a time. However, events in Eastern Europe, especially the dissolution of Yugoslavia and the statehood claims of Kosovo, Abkhazia, and South Ossetia, have reignited debates on recognition. Kosovo, 2008. Declared independence from Serbia after UN administration. Over half of the world's states have recognized it. Some argue this supports the constitutivist theory of statehood. The US and others deemed Kosovo's recognition as sui generis, implying it was not governed by international law. Alternative justifications include self-determination and remedial secession. ICJ Advisory Opinion, 2010. Examined Kosovo's unilateral declaration of independence, concluded it did not violate international law but avoided broader questions of statehood. Crimea, 2014. Citing Kosovo as precedent, local authorities declared independence from Ukraine. Shortly after, Crimea signed a treaty of accession with Russia. Legal issues. If Crimea was independent before accession, it is legally part of Russia. If it remained part of Ukraine, Russia's actions amount to annexation. Justification based on self-determination is weak. Kosovo was an exception due to Serbia's prolonged mistreatment of ethnic Albanians. No equivalent severe mistreatment of ethnic Russians in Crimea. Only Russia recognized Crimea's independence. UN General Assembly affirmed Ukraine's territorial integrity. Contradictory state positions. The US supported Kosovo's independence but opposed Crimea's. Russia opposed Kosovo's independence but supported Crimea's. ICJ's reluctance to address constitutivist theory in Kosovo's case left the legal landscape unclear. 2.3 Statehood and membership of the United Nations. UN membership consists of original members, states that participated in World War II against the Axis powers, signed the Declaration by United Nations, 1942, and ratified the UN Charter. Examples: US, UK, China, Soviet Union, France. Some original members, for example, Ukraine, Belarus, India, Philippines, were not sovereign at the time. Subsequent members. States joining after the UN's establishment must meet membership criteria under Article 4 of the UN Charter. 2.3.1 The special requirements of Article 4 regulates membership for states joining after the UN's creation. Covers states that were not part of the founding group, gained independence post-establishment, for example, decolonized states. Article 4.1 Substantive requirements. 1. Peace-loving state. Originally, peace-loving did not relate to a state's political system aimed at preventing interference in domestic governance. UN Charter, Article 2.7, now interpreted as compliance with international obligations and peaceful dispute resolution. 2. Acceptance of UN Charter obligations. Requires a formal declaration of acceptance, evaluated based on respect for international law, peaceful dispute settlement, friendly relations with other states. 3. ICJ Advisory Opinion, 1948. Admission must comply strictly with Article 4.1 requirements. No additional conditions can be imposed outside the Article's terms. 2.3.1.2 Procedural requirements for membership. Security Council role. Recommends admission of a state based on compliance with substantive requirements. Decision requires 9/15 affirmative votes, including all 5 permanent members. A single veto from a permanent member blocks admission. General Assembly role. If Security Council recommends admission, General Assembly must approve by a 2/3 majority. Can return an application to the Security Council for reconsideration. Security Council is assisted by the Committee on Admission of New Members, Est. 1946. Security Council Rule 60. Evaluates whether an applicant meets substantive membership criteria. Prevents automatic admission based solely on statehood. General Assembly Rule 136. Determines whether the applicant state meets Article 4.1 requirements. Can refer applications back to the Security Council if necessary. Next page. 2.3.2 Special cases of UN membership. UN membership limited to states. Only states can be UN members. State formations, for example, mergers, secessions, dissolutions, affect UN membership. Recognition issues impact admission procedures. State mergers and retained membership. Germany, 1945 to 1990, split into East and West Germany post-World War II. Both joined the UN separately after agreeing they were distinct states. In 1990, reunification occurred, and the Federal Republic of Germany retained UN membership without reapplying. Secession and new membership applications. Pakistan, 1947, seceded from British India, had to formally apply for UN membership. Eritrea, 1993, gained independence from Ethiopia after a long war, required a formal UN membership application. State dissolution and successor membership. Soviet Union, 1991. Broke into multiple independent states. Russia recognized as the legal successor and retained UN membership. Other breakaway republics applied separately. Yugoslavia, 1991 to 1993, broke into multiple independent states. The Security Council ruled that the former Socialist Federal Republic of Yugoslavia ceased to exist. Federal Republic of Yugoslavia, Serbia and Montenegro had to apply for new membership, admitted in 2000 after fulfilling the UN application process. Smooth secession with UN membership. South Sudan, 2011, declared independence from Sudan after a referendum. Achieved independence with Sudan's consent. Admitted to the UN as the 93rd member without complications. Observer status in Palestinians' UN membership attempt. Observer status for non-members. Granted to non-member states, UN agencies, intergovernmental organizations, and national liberation movements. Palestinians' case. 1974. Palestine Liberation Organization, PLO, gained observer status. 1988, General Assembly recognized Palestine instead of PLO. 2011, Palestine applied for full UN membership under the Montevideo Convention. Challenges to membership application. Ongoing Israeli-Palestinian conflict. Undefined borders. Lack of full control by the Palestinian Authority. Hamas governance of Gaza and refusal to renounce violence. Security Council role. Committee on Admissions could not reach a unanimous recommendation. Without Security Council approval, full membership was blocked. 2012 General Assembly Resolution 6719. Granted Palestine non-member observer state status. Recognized Palestinian self-determination and sovereignty aspirations. Expressed hope for future Security Council approval for full membership. Ambiguity remains on whether Palestine is a recognized state under international law. Palestine and the International Criminal Court, ICC, 2009, Palestine attempted to invoke ICC jurisdiction, request denied due to unclear statehood. 2015. Used Article 12.3 of the ICC statute, accepting ICC jurisdiction. Joined the Rome Statute, allowing ICC investigations into crimes in occupied Palestinian territories. ICC prosecutor deferred statehood determination to UN bodies. Resolution 6719 did not provide legal clarity on Palestinian statehood for ICC purposes. Next. Page. 2.3.3 Suspension of membership rights and privileges. Article 5 of the UN Charter allows for the suspension of a member state's rights and privileges applied when a state threatens international peace and security, leading to enforcement action under Chapter 7 of the UN Charter. Decision requires Security Council recommendation, 9 votes, including all 5 permanent members, per Article 27(3). General Assembly approval by a 2/3 majority, Article 18(2). Effects. The state remains a UN member and must still follow Charter obligations. Rights and privileges can be restored by the Security Council. Practical implementation. UN has never officially suspended a member state. Instead, the General Assembly has rejected the credentials of certain state representatives. Prevents them from participating in Assembly deliberations. Used against South Africa, Portugal, and Israel as a political statement. Legal controversy. Rejecting credentials without a Security Council recommendation bypasses Article 5 and may be seen as an unofficial suspension. Underscore. 2.3.4 Expulsion of a member. Article 6 of the UN Charter provides for expulsion of a member that persistently violates UN principles. Requires the same process as suspension. Security Council recommendation. General Assembly approval by a 2/3 majority. Nature of expulsion. Most severe measure, leading to termination of UN membership, reserved as a last resort, requiring prior attempts to correct the state's behavior through other means. Has never been used, likely because expulsion reduces UN influence over the state's actions. Group pressure and diplomacy may be more effective in changing state behavior. Legal consequences of expulsion. State becomes a non-member and is subject to Article 2(6). The UN must ensure that non-members still follow UN principles where necessary for international peace and security. Expelled state loses charter obligations but remains bound by customary international law. Next. Page. Study notes, International lawmaking as an attribute of state sovereignty. Henny Stridham. 3.1 Introduction to the sources of international law. States create binding laws domestically through the legislature and judiciary, enforced by law enforcement bodies. Sovereignty allows a state to exercise exclusive legal functions within its territory, Article 27 UN Charter. At the international level, lawmaking is also a function of state sovereignty. International law results from a state's legal competency to participate in lawmaking at the global level. Sources of international law determine the legal framework for resolving disputes between states. Sources of international law, Article 38(1) ICJ Statute. Primary sources. A. Treaties, international conventions establishing rules recognized by states. B. Customary international law, general practice accepted as law. C. General principles of law, recognized by civilized nations. Subsidiary sources. D. Judicial decisions and publicist teachings. Other sources of international law. Article 21(1) ICC Statute prioritizes the ICC statute, elements of crimes, and rules of procedure. Secondary sources, applicable treaties, customary international law. General principles derived from national legal systems. Article 7 African Court on Human and People's Rights Protocol applies the African Charter on Human and People's Rights and relevant human rights treaties. Hierarchy of sources. No strict hierarchy in Article 38(1) ICJ Statute, but treaties hold primary significance. ICC Statute establishes a clear order of preference for sources. General principles of international law. Broad category allowing judicial reasoning based on legal principles from domestic and international law. Examples: consent, reciprocity, state equality, good faith, freedom of the seas. Goskinium classification of general principles. 1. Common to national legal systems, for example, sanctity of treaties. 2. Derived from state practice, for example, diplomatic immunity. 3. Fundamental international law rules, for example, prohibition of aggression, jus cogens norms. 4. Fundamental human rights applicable to state relations. Article 38(1) prevents non-liquor, a situation where a court cannot resolve a dispute due to lack of applicable law. Courts may apply ex aequo et bono, Article 38(2) ICJ Statute, if parties agree, though never used. Equity in judicial decisions, used in resource disputes, for example, North Sea Continental Shelf Case, Law of the Sea Convention Article 83. 3.2 Treaties. 3.2.1 Basic concepts in the law of treaties. 3.2.1.1 The capacity to conclude treaties and means of expressing consent. States have the legal capacity to enter into treaties. Consent expressed through signature, ratification, acceptance, or accession. 3.2.1.2 The authority to conclude treaties. Treaty-making authority vested in heads of state, government, or accredited representatives. 3.2.1.3 The entry into force of treaties. Treaties become legally binding upon meeting stipulated conditions, for example, ratification by a specified number of states. 3.2.1.4 Reservations to treaties. States may modify or exclude specific treaty provisions unless reservations are prohibited. 3.2.1.4.1 The Genocide Convention case. ICJ ruling, reservations to the Genocide Convention are valid if not contrary to the treaty's object and purpose. 3.2.1.4.2 Incompatible and impermissible reservations. Reservations incompatible with the treaty's object and purpose are invalid. 3.2.1.4.3 Procedural rules applicable to reservations. Governed by the 1969 Vienna Convention on the Law of Treaties, VCLT. 3.2.1.4.4 Legal effect of reservations. A valid reservation binds the reserving state and modifies treaty obligations accordingly. 3.2.1.4.5 The special case of reservations to human rights treaties. Human rights treaties often restrict reservations to maintain universal application. 3.2.1.5 Interpretation of treaties. Treaties interpreted in good faith according to their terms, context, and purpose. Article 31 VCLT. 3.2.1.6 Position of third states. Treaties do not create obligations for third states without consent. Article 34 VCLT. 3.2.1.7 Invalidity, termination, and suspension of treaties. 3.2.1.7.1 Invalidity. A treaty is invalid if procured through coercion, fraud, or violates Schukagens norms. 3.2.1.7.2 Termination and suspension of treaties. 3.2.1.7.2.1 Material breach. A fundamental violation by one party may justify termination. 3.2.1.7.2.2 Supervening impossibility of performance. A treaty may terminate if its execution becomes objectively impossible. 3.2.1.7.2.3 Fundamental change of circumstances, rebus sextantibus. A radical change in circumstances may justify treaty termination. 3.2.1.7.2.4 Emergence of a new peremptory norm. A treaty ceases to be valid if it conflicts with a new Schukagens norm. _. 3.2.2 Treaties and the United Nations. The UN Charter regulates treaty relations, including registration and compliance. 3.2.3 Treaties and South African domestic law. Treaty implementation requires domestic incorporation through legislation. 3.2.4 Treaties in the constitutional law of select SADC countries. Angola, DRC, Eswatini, Madagascar, Malawi, Mauritius, Mozambique, Namibia, Seychelles, Zambia, Zimbabwe. Treaty implementation varies based on constitutional provisions and dualist or monist legal approaches. _. 3.3 Customary international law. 3.3.1 Requirements for the formation of custom. State practice, objective element, consistent and widespread state behavior. Opinio juris, subjective element, belief that the practice is legally obligatory. 3.3.2 The persistent objector rule. A state consistently objecting to a rule during its formation is not bound by it. 3.3.3 Customary international law and domestic legal systems. Incorporated into domestic law depending on constitutional provisions. _. 3.4 General principles of law. Includes universal legal principles, for example, good faith, pacta sunt servanda. 3.5 Judicial decisions and teachings of publicists. Judicial decisions and scholarly writings serve as subsidiary sources of law. _. 3.6 Sources falling outside the scope of Article 38. 3.6.1 Resolutions of the political organs of the United Nations. Non-binding but influential in shaping international law. 3.6.2 The International Law Commission. Develops and codifies international law principles. 3.6.3 Other forms of standard setting. includes soft law instruments such as declarations and guidelines. Underscore. 3.7 Unilateral acts of states. Unilateral declarations can create legal obligations if made with intent to be bound. 3.8 Debate on the hierarchy of international law norms, jus cogens and obligations erga omnes. Jus cogens norms, peremptory norms overriding conflicting treaties, for example, prohibition of genocide. Obligations erga omnes, duties owed to the international community, for example, prohibition of slavery. Underscore. These notes provide a structured overview of international lawmaking, focusing on its sources, key principles, and legal frameworks. Next. Page. 3.2 Treaties. Treaties play a fundamental role in codifying and developing international law. They are based on state consent and are akin to contracts in private law but regulate public law interests. Categories of treaties. Bilateral treaties, between two states, regulating common concerns, for example, border rivers, trade. Multilateral treaties, involve multiple states, codifying international law, for example, Geneva Conventions, 1949, UN Law of the Sea Convention, 1982, ICPR, 1966, UNFCCC, 1992. Constitutive treaties, establish international entities with legal personality, privileges, and immunities, for example, UN Charter, 1945, WTO Agreement, 1995. The Vienna Convention on the Law of Treaties, VCLT, governs treaties between states. A separate Vienna Convention, 1986, applies to treaties involving international organizations but is not yet in force. Non-written or agreements with non-state actors may still be legally valid outside the VCLT framework. 3.2.1 Basic concepts in the law of treaties. Understanding treaties requires knowledge of their legal mechanics. 3.2.1.1 The capacity to conclude treaties and means of expressing consent. Sovereignty allows states to conclude treaties, VCLT, Art. 6. Consent to be bound must be positively expressed through signature, exchange of instruments, ratification, acceptance, approval, accession or other agreed means, VCLT, Art. 11. Treaty terms or parties' intentions determine the applicable method. Philippines v. China, Arbitral Tribunal. A treaty must clearly intend to establish rights and obligations. Ratification, acceptance, approval, and accession all confirm state consent to be bound. Signature may be subject to later ratification, delaying the treaty's effect. During this period, states must not act contrary to the treaty's purpose, VCLT, Art. 18. The Pacta sunt servanda rule requires good faith compliance once a treaty is in force, VCLT, Art. 26. Domestic law cannot justify treaty non-compliance, VCLT, Art. 27. States must carefully evaluate their ability to comply before consenting to a treaty. 3.2.1.2 The authority to conclude treaties. States act through designated officials when concluding treaties. Authority derives from full powers issued by the state for treaty adoption or consent. State practice, where past dealings imply representation. Official position, where specific officials can act without special authorization. Full powers requirements, must name the representative, treaty title, competent authority's signature, and date. Exceptions to full powers requirement. Heads of state, heads of government, foreign ministers, can act on behalf of the state in treaty matters, VCLT, Art. 7.2. Heads of diplomatic missions, can adopt treaty texts between their accrediting and host state. Accredited representatives at international conferences/organizations, can adopt treaty texts. Acts by unauthorized persons have no legal effect unless later confirmed by the state, VCLT, Art. 8. Restrictions on authority. If a representative's authority is restricted, other states must have prior knowledge for it to invalidate consent, VCLT, Art. 47. States cannot claim treaty invalidity due to domestic legal violations unless the violation was manifest and concerned a fundamental domestic rule, VCLT, Art. 46. ICJ in Cameroon v. Nigeria, 2002. Heads of state are presumed to have treaty-making authority under VCLT, Art. 7.2. A manifest violation must be publicly known. No obligation for states to monitor each other's internal legal changes. A state claiming invalidity under Art. 46 must prove adequate communication and notification of legal restrictions to the other party. Next. Page. 3.2 Treaties. Treaties codify and develop international law. They are based on state consent, akin to contracts in private law but regulating public international relations. Types of treaties. Bilateral treaties, between two states, for example, river usage, trade. Multilateral treaties, involving multiple states, often lawmaking, for example, 1949 Geneva Conventions, 1966 SICPR, 1982 UNCLOS, 1992 UNFCCC, 2000 Convention on Terrorism Financing. Constitutive treaties, create international entities, for example, 1945 UN Charter, 2000 Astronomical Units Constitutive Act, 1995 WTO Agreement. Vienna Convention on the Law of Treaties, VCLT, 1969, applies to treaties between states. The 1986 Vienna Convention on Treaties with International Organizations is not yet in force. Non-written agreements and treaties involving non-state actors are valid under general international law. 3.2.1 Basic concepts in treaty law. 3.2.1.1 Capacity to conclude treaties and expressing consent. State sovereignty gives states the capacity to conclude treaties, VCLT, Article 6. Consent to be bound is required and can be expressed through signature, exchange of instruments, ratification, acceptance, approval, accession. Philippines v. China, 2016, confirmed the importance of clear intent in treaty obligations. Ratification, acceptance, approval, and accession have the same legal effect. Signature may require later ratification, during which the state must not act against the treaty's purpose. VCLT, Article 18. Key treaty principles. Pacta sunt servanda, good faith compliance, VCLT, Article 26. Domestic law cannot justify non-performance, VCLT, Article 27. States must consider treaty obligations carefully to avoid symbolic or politically expedient commitments. 3.2.1.2 Authority to conclude treaties. A state representative must have authority to negotiate/sign treaties. Authority sources. Full powers document, issued by the head of state or authorized official. State practice, past recognition of authority. Official position, heads of state, foreign ministers, diplomatic representatives. ICJ in armed activities, DRC v. Rwanda, confirmed this as customary international law, VCLT, Article 7.2. Invalid acts. If a representative lacks authority, the act is invalid unless later confirmed. Restrictions on authority are only binding if prior knowledge is evident. Article 46 VCLT. Domestic law violations invalidate treaties only if manifest and of fundamental importance. Cameroon v. Nigeria, 2002, ICJ ruled that a head of state's authority limitation must be publicized to invalidate a treaty. 3.2.1.3 Entry into force of treaties. A treaty enters into force when all negotiating states consent, unless otherwise agreed. VCLT, Article 24. If a state consents after the treaty enters into force, it applies only from that date. Non-retroactivity rule, Article 28. Example, Rome Statute, 1998, required 60 ratifications. Entry into force, first day of the month after 60 days following the 60th ratification. Later ratifications, 60 days after ratification, Article 126(2). 3.2.1.4 Reservations to treaties. A state can exclude/modify certain treaty provisions through reservations. VCLT, Article 2(1)d. A reservation is a unilateral statement modifying a treaty's effect. VCLT, Article 19. A reservation is prohibited if a. the treaty explicitly forbids it, b. the treaty only allows specific reservations, c. it is incompatible with the object and purpose of the treaty. Reservations apply only at signing, ratification, acceptance, approval, or accession. Bilateral treaties require mutual agreement. Reservations would make obligations unenforceable. In multilateral treaties, states may accept or reject reservations, affecting treaty relationships. Next page. 3.2.1.4 Reservations to treaties, continued. 3.2.1.4.1 The Genocide Convention Case, 1951 ICJ Advisory Opinion. The 1948 Genocide Convention had no explicit provisions on permitting or prohibiting reservations. Many states entered reservations, leading the UN General Assembly to request an ICJ Advisory Opinion. ICJ ruling. A state making a reservation that is compatible with the treaty's object and purpose remains a party despite objections by some states. Article 24 BVCLT. If a state objects to a reservation, the treaty still enters into force between the objecting and reserving state unless the objecting state explicitly states otherwise. Article 25 VCLT. If no objection is made within 12 months, the reservation is deemed accepted. The ICJ emphasized that the goal was maximizing participation to uphold the treaty's humanitarian principles. Fitzmaurice's interpretation. In the absence of an express contrary intention, a reservation remains operative between the reserving and objecting state. If a reservation is incompatible with the object and purpose of the treaty, the reserving state cannot be considered a party. A state objecting to such a reservation may refuse to recognize the reserving state as a party. States that do not object still recognize the reserving state as a party. Effect on treaty law. Each state autonomously assesses whether a reservation aligns with the treaty's object and purpose. If a treaty explicitly authorizes reservations, no acceptance from other states is required. Article 22 VCLT. If treaty negotiations required full participation among all parties, acceptance of reservations is mandatory. Constituent treaties of international organizations require approval from the organization's competent organ. Rules governing reservations and objections. Acceptance of a reservation by a state allows the reserving state to become a party in relation to that accepting state. Objections to a reservation do not prevent the treaty from entering into force unless explicitly stated. A treaty with a reservation becomes effective when at least one state accepts the reservation. Reservations and objections can be withdrawn at any time, unless otherwise stipulated by the treaty. 3.2.1.4.2 Incompatible and impermissible reservations. Issue: distinguishing between compatible and incompatible reservations remains controversial. The International Law Commission, ILC, addressed this in its 2011 Guide to Practice on Reservations to Treaties, initiated in 1993. The ILC guidelines provide non-binding guidance for resolving gaps in the VCLT regarding reservations and objections. Key issues in determining the validity of reservations. Legal effect of an impermissible reservation, i.e., one incompatible with the treaty's object and purpose. VCLT lacks clarity on the consequences of an invalid reservation. ILC calls this a serious legal gap in treaty law. Two theories on reservation validity. 1. Permissibility approach. Focuses on treaty interpretation and object and purpose. Two-step process. 1. Objective assessment. Is the reservation compatible with the treaty? 2. If incompatible, it is automatically invalid, regardless of acceptance by other states. 3. If compatible, other states may accept or object, for example, for political reasons. 2. Opposability approach. The validity of a reservation depends solely on whether other states accept or reject it. A reservation is valid if accepted by at least one state, irrespective of compatibility with treaty objectives. State consent determines legal validity. Consequences of an impermissible reservation. Two possible legal solutions. 1. The reserving state is not a party unless it withdraws the reservation. 2. Severability. The reservation is removed, and the state remains bound by the entire treaty. This approach is recognized only in regional human rights treaties. Legal challenge. If a reservation was central to a state's consent, severing it could make the treaty binding beyond the state's original intent. ILC Guideline 4.5.1 on impermissible reservations. Reservations that do not meet formal validity and permissibility requirements are null and void. Effect. The reservation has no legal impact, it is invalid, independent of state objections. Avoids making state consent the only factor in determining validity. Ensures Article 19 VCLT is not undermined by state practice. Aligns with human rights treaty bodies and state practice. Next page. 3.2.1.4.3 Procedural rules applicable to reservations. Reservations, acceptances, objections, and withdrawals must be in writing and communicated to contracting states and other entitled states. A reserving state must formally confirm its reservation when expressing consent to be bound by a treaty. The reservation is deemed made on the confirmation date. ICJ ruling in Armed Activities, DRC v. Rwanda. Rwanda issued an executive decree withdrawing all reservations to human rights treaties, including the Genocide Convention. Relevant provisions. Article 17 of the Genocide Convention, UN Secretary-General must notify UN members and non-members of treaty actions. Article 22(3)(a) of the VCLT, a reservation withdrawal is operative only when the contracting states receive notice. ICJ ruled that notification at the international level is required for withdrawal to be effective. Since Rwanda failed to notify the UN Secretary-General, its withdrawal had no effect under international law. 3.2.1.4.4 Legal effect of reservations. A reservation modifies treaty provisions only between the reserving and accepting state, leaving the treaty unchanged for other parties. If a state objects to a reservation but does not oppose the treaty's entry into force, the reserved provision does not apply between the objecting and reserving state. Difference between reservations and interpretative declarations, ILC explanation. Reservations exclude or modify legal effects of treaty provisions for the reserving state. Interpretative declarations clarify the meaning or scope of treaty provisions. If a declaration effectively modifies legal effects, it is treated as a reservation under Article 19 of the VCLT. 3.2.1.4.5 The special case of reservations to human rights treaties. 1951 ICJ Genocide Convention case. Human rights treaties differ from ordinary treaties. States have no individual interests but a collective interest in their purpose. European Commission of Human Rights. Human rights treaties impose objective obligations to protect rights, not reciprocal state-to-state obligations. Inter-American Court of Human Rights. Human rights treaties do not follow traditional multilateral treaty structures but protect individuals from all contracting states. UN Human Rights Committee on the ICPR, 1994 General Comment. Expressed concern over excessive reservations undermining human rights obligations. Article 19C of the VCLT applies. Reservations must be compatible with the treaty's object and purpose. Reservations violating jus cogens, for example, allowing slavery or torture, are impermissible. The committee asserted its role in assessing reservation compatibility under Article 28 of the ICPR severability approach. If a reservation is impermissible, the treaty remains in force for the reserving state without the benefit of the reservation. Followed by the European Court of Human Rights, ECHR. Controversy over reservation assessment authority. Some states argue only state parties can determine reservation compatibility under Article 19C of the VCLT. The International Law Commission, ILC, affirmed that human rights monitoring bodies can assess reservations' permissibility. 2011 Guide to Practice on Reservations to Treaties. However, this does not override state parties' right to accept or reject reservations under Articles 20, 21, and 23 of the VCLT. ILC conclusion. Multiple mechanisms for assessing reservations should coexist to strengthen treaty integrity and universality. Conflicting assessments are preferable to no assessment at all. Next page. 13.2.1.5 Interpretation of treaties. Interpretation of treaties is a controversial issue in international law due to its impact on national interests. General rule of interpretation, customary international law. Treaties must be interpreted in good faith using their ordinary meaning, in context, and considering their object and purpose. The text includes the preamble and annexes. Interpretation should end if the ordinary meaning is clear. Context includes agreements between parties relating to the treaty's conclusion. Instruments accepted by all parties that affect interpretation. Additional considerations. Subsequent agreements on interpretation. State practice establishing common interpretation. Relevant international law. Object and purpose are often vague. Some link it to the principle of effectiveness. Maxim magis valet quam periat. Supplementary means of interpretation, if general rule leads to ambiguity or absurdity. Preparatory work. Travaux préparatoires. Circumstances of the treaty's conclusion. 13.2.1.6 Position of third states. General rule, pacta tertiis nec nocent nec prosunt. A treaty does not create rights or obligations for a third state without its consent. Exception, a treaty can create obligations for a third state if the treaty intends to do so. The third state accepts in writing. Modifications. Obligations require consent of all parties, including the third state. Rights remain unless revocation requires third state's consent. Reparations case, ICJ, 1949. The United Nations had the capacity to bring an international claim against Israel despite Israel being a non-member. This implied an exception to the Pacta Tertiis rule. 13.2.1.7 Invalidity, termination, and suspension of treaties. 13.2.1.7.1 Invalidity. Invalidity of a treaty can only occur under the Vienna Convention on the Law of Treaties, VCLT. Termination, suspension, denunciation, or withdrawal may occur under the treaty itself. The VCLT. Invalidity grounds. Error, if an essential assumption is incorrect, unless the state contributed to it or should have known. Fraud, if induced by misrepresentation, corruption or coercion of a state representative. Use of force in violation of the UN Charter. Conflict with jus cogens, peremptory norms, Article 53 VCLT. Jus cogens norms cannot be derogated from. Examples: genocide, slavery, torture, racial discrimination, aggression. 2006 ILC list, prohibition of aggression, slavery, genocide, racial discrimination, torture, and core humanitarian law norms. 13.2.1.7.2 Termination and suspension of treaties. Covers breach, impossibility of performance, changed circumstances, and new peremptory norms. 13.2.1.7.2.1 Material breach. Bilateral treaties, if one party materially breaches, the other can terminate or suspend. Multilateral treaties. Non-breaching parties may suspend or terminate the treaty unanimously. Suspend the treaty only in relation to the defaulting state. Suspend participation if the breach radically alters obligations. Humanitarian treaties. Breach does not justify suspension if it affects protected persons. Countermeasures. A state may suspend treaty provisions as an enforcement tool under state responsibility law. 13.2.1.7.2.2 Supervening impossibility of performance. A treaty can be terminated or suspended if essential objects are permanently lost or destroyed. Temporary impossibility allows suspension only. Exception: if impossibility arises from the state's own treaty breach, termination or suspension is not allowed. Next page. Study notes on interpretation and termination of treaties. 13.2.1.5 Interpretation of treaties. Treaty interpretation is controversial due to its impact on national interests. General rule of interpretation, customary international law. Treaties must be interpreted in good faith, according to the ordinary meaning of terms in their context and in light of their object and purpose. 3 elements. 1. Text, including preamble and annexes, words given their ordinary meaning. 2. Context, includes agreements and instruments related to the treaty. 3. Object and purpose, assists interpretation, linked to effectiveness principle, magis valet quam periat. Supplementary means of interpretation, VCLT Article 32. Travaux preparatoires, preparatory work, and circumstances of treaty conclusion. Used to confirm or clarify ambiguous/absurd results from general rule. 3.2.1.6 Position of third states. General rule. Treaties do not create obligations or rights for third states without their consent. Pacta tertiis nec nocent nec prosunt. Exceptions. Treaty provisions creating obligations for third states require their written acceptance. Rights assigned to third states cannot be revoked without their consent. ICJ's reparations case recognized UN's legal personality as binding even on non-party states. Israel. 3.2.1.7 Invalidity, termination, and suspension of treaties. 3.2.1.7.1 Invalidity of treaties. VCLT rules on invalidity. States can contest validity only on specific grounds. Error, if it formed an essential basis of consent, unless the state contributed to or should have known about it. Fraud and corruption. Consent obtained through deceit or bribery is invalid. Coercion. Consent forced through threats or use of force violates international law. Conflict with jus cogens. Article 53 VCLT. Treaties violating peremptory norms, for example, genocide, slavery, torture, are void. Jus cogens norms override treaties. They cannot be derogated from except by new peremptory norms. 3.2.1.7.2 Termination and suspension of treaties. Termination or suspension can result from breach, impossibility, change in circumstances, or new peremptory norms. 3.2.1.7.2.1 Material breach. VCLT Articles 60-62, Bilateral treaties. One party's material breach entitles the other to terminate or suspend the treaty. Multilateral treaties, other parties can 1. Unanimously suspend or terminate the treaty, either for the breaching party or all parties. 2. Affected parties may suspend obligations towards the breaching party. 3. Any party may suspend the treaty if the breach radically alters obligations. Material breach includes unjustified repudiation of the treaty, violation of an essential provision affecting the treaty's object and purpose. Countermeasures: affected states may take measures, for example, suspension, to compel compliance. 3.2.1.7.2.2 Supervening impossibility of performance. A treaty may be terminated or suspended if performance becomes impossible due to permanent disappearance/destruction of an indispensable object. Exception: no termination/suspension if impossibility results from a breach by the invoking state. 3.2.1.7.2.3 Fundamental change of circumstances, rebus sextantibus, general rule: change in circumstances does not justify termination. Exceptions: if the original circumstances were essential to consent. If the change radically transforms obligations. Exclusion: boundary treaties are not subject to this rule. State fault: the rule cannot be invoked if the invoking state caused the change. 3.2.1.7.2.4 Emergence of a new peremptory norm, Article 64 VCLT. A treaty becomes void if a new jus cogens norm arises and conflicts with it. Lack of state practice: no known cases where a treaty was invalidated solely on this basis. 3.2.2 Treaties and the United Nations. Registration of treaties. Required under Article 102 UN Charter and Article 80 UN Charter. Ensures open diplomacy, preventing secret treaties. Conflict between treaties and UN obligations, Article 103 UN Charter. UN Charter obligations prevail over other international agreements. 3.2.3 Treaties in South African domestic law. Treaty-making power. Executive negotiates and signs treaties, Section 231(1) SA Constitution. Parliament ratifies treaties, Section 231(2) SA Constitution. Legal effect in South Africa. Ratification binds SA internationally but does not make the treaty part of domestic law. Implementation requires legislation, Section 231(4) SA Constitution. Constitutional Court ruling, Nkobo CJ. Ratified treaties create international obligations but do not automatically become part of SA law. Only incorporated treaties create domestic rights and obligations. Withdrawal from treaties. Democratic Alliance v. Minister of International Relations and Cooperation, 2017. Raised separation of powers issue: should withdrawal require parliamentary approval? Next page. 3.2.1.7.2.3 Fundamental change of circumstances, rebus sextantibus. A treaty cannot be terminated or withdrawn from due to a change in circumstances unless the original circumstances were essential to the parties' consent to be bound. The change radically transforms the obligations to be performed. Exception: treaties establishing state boundaries are not subject to this rule. A party cannot invoke this rule if the change resulted from its own breach of obligations under the treaty or another international obligation. 3.2.1.7.2.4 Emergence of a new peremptory norm. A treaty becomes void if a new jus cogens, peremptory norm, arises that conflicts with it. Based on Article 53 of the Vienna Convention on the Law of Treaties, VCLT. State practice is rare, and no treaty has been invalidated on this basis. 3.2.2 Treaties and the United Nations. Secret treaties contributed to World War I, leading to transparency in treaty registration. Article 18 of the League of Nations Covenant required treaty registration. Article 80 of the UN Charter and Article 102 require treaties to be submitted to the UN Secretariat. Article 103 of the UN Charter: if a conflict arises between a UN member's treaty obligations and UN Charter obligations, the Charter prevails. 3.2.3 Treaties in South African domestic law. International and domestic law processes govern South Africa's treaty-making. National Executive, President and Cabinet, negotiates and signs treaties. Parliament ratifies treaties through a resolution in both the National Assembly and National Council of Provinces. A treaty is binding internationally but has no domestic legal effect unless incorporated into domestic law via legislation. Constitutional Court ruling, for Nkobo CJ. A treaty ratified by Parliament binds South Africa internationally. It does not create rights or obligations domestically unless incorporated into national law. Withdrawal from treaties. Issue arose in Democratic Alliance v. Minister of International Relations, 2016. Regarding South Africa's withdrawal from the Rome Statute, the executive deposited a notice of withdrawal with the UN Secretary-General under Article 127(1) of the Rome Statute. The High Court ruled withdrawal requires parliamentary approval, just as ratification does under Section 231(2) of the Constitution. 3.2.3.1 Exceptions to treaty ratification procedures. 1. Technical, administrative, or executive treaties do not require parliamentary approval, only tabling in Parliament. Section 231(3). Address routine matters. Earth-Life Africa case. Concern bilateral nuclear agreements. Western Cape High Court ruled the agreement with Russia should have followed Section 231(2), not 231(3). The agreement was legally binding and had significant implications. 2. Self-executing treaties automatically acquire domestic legal force if they are not inconsistent with the Constitution or an Act of Parliament. Section 231(4). Concept imported from U.S. law but criticized as unsuitable for South Africa. Case law. Kweliani case. U.S.-South Africa extradition treaty was invalid domestically because it was not enacted into law. Government wrongly argued that exchange of ratification instruments was sufficient. Goodwin case. Contrary ruling found the same treaty self-executing without justification. Constitutional Court's final ruling adopted a third approach inconsistent with Section 231(4), suggested the Extradition Act could suffice as a pre-existing enactment, avoiding the need for separate ratification. This approach was criticized as legally unclear and unsatisfactory. 3.2.3.2 Continuity of treaty obligations despite government change. Section 231(5) of the Constitution, South Africa remains bound by pre-existing treaties despite changes in government. Rationale: the state, not the government, is the legal entity bound by international treaties. Next, page 3.2.3 Obligations erga omnes in international law. Definition and scope. Erga omnes obligations, legal duties owed by states to the international community as a whole. All states have a legal interest in enforcing these obligations. Examples and recognition recognized by the ICJ in the Barcelona Traction case. Derived from, outlawing of acts of aggression and genocide. Protection of fundamental human rights, for example, slavery, racial discrimination. Effect and enforcement. Breach of such obligations affects all states, allowing any state to invoke responsibility. Contrasts with traditional international law, where obligations are typically bilateral. Erga omnes obligations focus on universal enforcement rather than norm hierarchy, unlike jus cogens. Distinction from jus cogens. Jus cogens norms have erga omnes effects but not all erga omnes obligations are jus cogens. Example: ICPRA provisions may be erga omnes but not necessarily jus cogens. 3.2.4 Treaties in the constitutional law of select SADC countries. Most SADC countries regulate treaty making through constitutional provisions. Common practices. Constitutional supremacy clauses affecting treaty status. Parliamentary approval/ratification required but consequences of disapproval often unclear. 3.2.4.1 Angola. Treaties enter domestic law upon official publication and international entry into force. Executive signs/ratifies treaties after legislative approval, especially in key areas, for example, borders, defense. Parliamentary approval required for treaty withdrawal. Treaties violating constitutional principles are subject to constitutional review. President can request prior constitutional review before ratification. International human rights treaties influence legal interpretation and are enforceable in courts. 3.2.4.2 Democratic Republic of the Congo, DRC, Parliament must authorize treaty ratification before executive action. Applies particularly to treaties on peace, defense, commerce, natural resources, finances, etc. Constitutional Court reviews treaty constitutionality. Any person can challenge a treaty's constitutionality, suspending parliamentary approval. Preamble incorporates UN Charter, UDHR, African Charter, and ratified human rights treaties. 3.2.4.3 Eswatini, Swaziland, constitutional monarchy with supreme constitution. Government executes international agreements in the king's name. Ratification requires parliamentary approval, 2/3 majority in joint session. Exceptions: technical, administrative, and self-executing treaties. 3.2.4.4 Madagascar executive negotiates and ratifies treaties, subject to conditions. Certain treaties require parliamentary approval. Treaties must undergo prior review by the High Constitutional Court. Ratified treaties are superior to domestic laws, but interpretation depends on treaty status in other states. 3.2.4.5 Malawi Constitution is supreme in interpreting laws and political disputes. Treaties form part of domestic law only if incorporated by an act of parliament. Courts may use international law in constitutional interpretation. Executive negotiates, signs, and accedes to treaties, with limited parliamentary oversight. 3.2.4.6 Mauritius Constitution does not regulate treaty making, an unusual omission. 3.2.4.7 Mozambique Constitution prevails over all legal norms, including treaties. International law norms equated with legislative acts. Executive signs treaties, but approval/termination of treaties affecting legislative matters is Parliament's exclusive power. 3.2.4.8 Namibia Constitution is supreme, including over international agreements. Treaties automatically become domestic law unless otherwise provided. President negotiates/signs treaties, with National Assembly ratification required. 3.2.4.9 Seychelles Constitution prevails over any conflicting law. Constitution silent on treaty status, likely ranking treaties below constitutional law. Courts may consider international human rights law in interpreting rights provisions. President executes treaties, but ratification requires legislative approval unless otherwise authorized. 3.2.4.10 Zambia Constitution is supreme but treaty status remains unclear. Executive negotiates, signs, and ratifies treaties, but requires National Assembly approval. 3.2.4.11 Zimbabwe Constitution is supreme over all laws and treaties. Treaties bind Zimbabwe only after parliamentary approval and domestic incorporation. President executes treaties based on executive advice. Next, page 3.3 Customary international law. Source of law, recognized under Article 38(1)b of the ICJ Statute. Distinction from treaty law, customary law binds all states. Treaty law binds only parties to the treaty. Evolving role, Friedman, 60 years ago, customary law is too slow-moving for modern international relations. Current relevance, customary norms and treaties interact, leading to codification and development. Consuetudo scripta, increasing overlap between custom and treaty provisions, giving double value to norms. 3.3.1 Requirements for the formation of custom 1. 2 elements required, Article 38(1)b, state practice, objective element, general and representative practice of states. Can include international organizations in some cases. Must be consistent, widespread, and uniform. Opinio juris, subjective element, states must follow the practice out of a legal obligation, not just habit. May be inferred from state silence or failure to react. 2. Evidence of customary law, state conduct indicators, diplomatic correspondence, legal opinions, government manuals. Legislation, judicial decisions, voting on UN resolutions, treaty ratifications. Practice of international organizations. Evidence for opinio juris, public statements, official publications, government legal opinions. National court decisions, treaty provisions, UN resolution conduct. 3. ICJ application of customary law. North Sea Continental Shelf case, custom requires settled practice plus belief in legal obligation. Habitual acts alone do not establish custom. Asylum case, state practice must be constant and uniform. Inconsistent and politically motivated actions weaken customary claims. Nicaragua case, customary rule exists even if some breaches occur. Consistency in state denouncements of rule violations strengthens its existence. Arrest warrant and pulp mills cases, ICJ sometimes bypasses strict evidence requirements. Risk, states may unilaterally shape law by asserting claims without proof of custom. 3.3.2 Criticism and challenges. 1. Western dominance in custom formation. Third World critique, B.S. Chimney, customary law historically favors capitalist states. Courts and scholars neglect Third World state practice. Structural barriers, limited documentation of non-Western state practice. Western states dominate legal publications and ICJ rulings. 2. Accessibility issues, ILC 2019 report, regional disparities in customary law evidence, Western European and others, 102 bibliographic resources, 23-29 states. Asia Pacific, 36 resources, 1455 states. Latin America and Caribbean, 24 resources, 1433 states. Eastern Europe, 14 resources, 923 states. Africa, 8 resources, 554 states. 3. Postmodern reconceptualization of customary law, Chimney's proposal. Shift from hegemonic state practice to deliberative reasoning. Differentiate opinio juris, legal belief, from juridical conscience of humankind. Challenges. Structural power remains unchanged even with new reasoning methods. Hegemonic control persists over defining international norms. Western states still control legal narratives and rulemaking. Conclusion. Customary law remains a vital but contested source of international law. ICJ rulings show inconsistency in custom identification and state practice requirements. Structural inequities limit the influence of non-Western states in custom formation. Proposed reforms face practical challenges in reshaping the balance of power. Next. Page 3.3.2 The persistent objector rule. State practice and opinio juris illustrate state consent in customary international law. A state can exempt itself from a developing customary law rule by persistently objecting while the rule is forming. Persistent objector rule may not apply to jus cogens norms, no derogation allowed, for example, prohibition of genocide. Erga omnes obligations, obligations towards the international community as a whole. Barcelona Traction Case, ICJ. Distinguished between state obligations to the international community, erga omnes, and bilateral obligations. Erga omnes obligations include outlawing aggression, genocide, slavery, and racial discrimination. Example, environmental protection obligations illustrate limitations on the persistent objector rule. 3.3.3 Customary international law in the domestic legal system. Customary international law forms part of South African law. Section 232 of the 1996 Constitution, customary international law is law unless inconsistent with the Constitution or an act of Parliament. Hierarchy. Customary international law greater than common law in judicial decisions. Conflict, Constitution or Act prevails. Court's role. Determine which customary rules apply. Reference international and foreign judicial decisions. SP Patan. A rule must be widely accepted internationally to be part of SA law. Salk Case, SCA. Domestic courts do not develop or expand customary international law but recognize and apply it. 3.4 General Principles of Law. Article 38(1)(c) of the ICJ Statute allows use of general principles of law in dispute resolution. General principles come from legal systems of the world, historically linked to civilized nations. Purpose. Addresses legal gaps not covered by treaties or customary law. Prevents non-decay, finding of no applicable law. Examples applied by ICJ. Unjust enrichment, res judicata, corporate limited liability, estoppel, nemo judex and resu. No case has been determined solely on general principles of law. 3.5 Judicial decisions and teachings of publicists. Article 38(1)(d) of the ICJ Statute. Judicial decisions and publicists' writings are subsidiary means of law determination. These sources interpret rather than create law. Judicial decisions include ICJ rulings, other international tribunals, and national courts. No binding precedent in international law. Article 59 of the ICJ Statute. Decisions bind only the parties involved. However, previous rulings influence later decisions. 3.6 Sources outside the scope of Article 38. Debate on whether Article 38 is an exhaustive list of international law sources. Some argue for an expanded list due to evolving lawmaking mechanisms. 3.6.1 UN General Assembly Resolutions. General Assembly lacks authority to make binding decisions on international law. Binding decisions only in internal UN matters, membership, budget, etc. Resolutions and declarations. Non-binding but contribute to customary international law development. Provide evidence of state opinions, opinio juris. ICJ in nuclear weapons case. Resolutions may show the emergence of opinio juris. Examine voting patterns and content to assess legal impact. Evidentiary weight factors. Unanimity or near unanimity. Repetition in subsequent resolutions. State actions to implement resolutions. 3.6.2 UN Security Council resolutions. Security Council, SC, maintains international peace and security. Binding resolutions under Chapter 7 of the UN Charter. Member states must comply. SC decisions override conflicting treaty obligations. Post 9/11 example. Resolutions 1373, 2001, and 1540, 2004, created counterterrorism obligations. SC acted in a legislative-like manner, expanding interpretation of threat to peace. ICTY and ICT are established under Chapter 7 for humanitarian violations. ICTY ruling. SC's powers under Article 41 allowed tribunal creation. Potential future expansion. SC's role in climate change regulation debated, UN Security Council, 2007 and 2011. Climate change seen as a security threat, Ban Ki-moon, 2011. Next page. Study notes on lawmaking functions in international law. 3.6 Security Council's enhanced lawmaking function in climate change matters. Recognizes legitimacy deficit due to the Security Council's limited membership and dominance of the 5 permanent members. Proposal: General Assembly to first deliberate and agree on resolutions before the Security Council grants binding force. Goals: greater accountability, openness, and inclusivity in the lawmaking process. Ensure broader consensus by involving the General Assembly. Increase coherence in international lawmaking. Enable binding laws on urgent matters like terrorism and climate change. Overriding objections. No opt-outs, persistent objectors, or reservations in the new framework. Implementation possible without charter revision, but changing Security Council membership and voting rights would require charter amendment. _ 3.6.2 International Law Commission, ILC, established in 1948 by the General Assembly under Article 13(1)(a) of the UN Charter, composed of 34 elected members based on expertise in international law. Main functions: research areas of international law, prepare reports and draft conventions with commentaries, facilitate progressive development and codification of international law. Key contributions: Vienna Convention on the Law of Treaties, 1969, Geneva Conventions on Diplomatic and Consular Relations, 1961, 1963, Convention on the Non-Navigational Use of International Watercourses, 1997, Draft Articles on the Responsibility of States for Internationally Wrongful Acts, 2001, Draft Articles on the Prevention of Transboundary Harm, 2001, full list available on the UN website. _ 3.6.3 Other forms of standard setting, soft law, non-binding instruments created by international organizations when a matter is not yet ready for binding treaties. Too controversial for treaty-based regulation. Purpose: imposing flexible, voluntarily accepted obligations to influence state conduct over time. Can evolve into binding norms through customary international law development. Incorporation into treaty provisions. Common terms for soft law instruments. Standard minimum rules, guiding norms, model laws, declarations, recommendations, guiding principles. Notable contributions to environmental law. 1972 Stockholm Declaration on the Environment. 1992 Rio Declaration on the Environment and Development. _ 3.7 Unilateral acts of state. Complex issue in international law, with no universally accepted classification. Key debates: whether unilateral acts can be sources of international law. Distinction between sources of obligation versus sources of law. Sagan-X view. Not all unilateral acts constitute sources of international law. Example: a state's waiver of a diplomat's immunity is not a source of international law but creates an obligation for that state. Relevant case law. 1. Eastern Greenland case, 1931, Norway's foreign minister, Eland, declared Norway would not contest Danish sovereignty over eastern Greenland. Permanent Court of International Justice ruled Norway was bound by the declaration. Outcome: Norway obliged not to challenge Danish sovereignty. 2. Nuclear test case. French president publicly announced discontinuation of nuclear tests in the South Pacific. International Court of Justice, ICJ, ruled that public, intentional declarations create legal obligations. _ International Law Commission on Unilateral Acts. Definition: a unilateral act is a declaration by a state intended to produce legal effects under international law. Capacity to formulate unilateral acts. Heads of state, ministers of foreign affairs inherently have this power. Other officials may have this power if established through practice. Connection to treaty law. Influenced by good faith principle in treaty law. Obligation to honor commitments and ensure international stability. Validity requirements for unilateral acts. 1. Authority must be made by a competent official. 2. Material possibility cannot be impossible or violate peremptory norms, jus cogens. 3. Genuine intent must reflect the true intention of the state. 4. Invalidating factors, similar to treaty law. Conflict with fundamental domestic laws. Error of fact, fraud, corruption, coercion, or threat of force. Violation of a jus cogens norm. Next. Page 3.8 Debate on the hierarchy of international law norms, jus cogens and obligations erga omnes. 1. Hierarchy in international law. Legal norms may be hierarchically ordered to resolve conflicts between them. Examples. Roman law, jus strictum versus jus dispositivum. Natural law theory, superiority of natural law over state will. Contract law, nullity of contracts conflicting with public policy/morality. International law follows similar hierarchical principles. Treaties, older treaties take precedence over newer ones. Lex specialis principle, special treaty rules override general rules. UN Charter obligations prevail over other treaties. Article 103 UN Charter. 2. Jus cogens norms in international law. Article 53 of the VCLT, treaties conflicting with jus cogens norms are null and void. Article 71(1) of the VCLT, consequences of such treaties. 1. Eliminate effects of any acts relying on the invalid treaty. 2. Align relations with peremptory international law norms. No retrospective effect. Article 64 and 71(2) of the VCLT. If a new jus cogens norm arises, conflicting treaties terminate. Rights/obligations under such treaties remain valid unless they conflict with a new norm. Jus cogens norms override. Customary international law rules. Resolutions of international organizations. Conflicts between jus cogens norms remain unresolved, as no hierarchy exists between them. Identification of jus cogens norms requires broad international consensus but not unanimous state agreement. No official list exists, but recognized examples include prohibitions, aggressive force, genocide, torture, crimes against humanity, slavery, piracy, apartheid, racial discrimination, and violations of humanitarian law. 3. Case law on jus cogens. ICJ cases. Nicaragua case, confirmed jus cogens status of prohibition on use of force, Article 24 UN Charter. Armed activities, DRCB Rwanda, 2006. Genocide prohibition as a peremptory norm. Jurisdictional immunities case, Germany v. Italy, 2012. Italy allowed civil claims against Germany for World War II war crimes. ICJ ruled state immunity is procedural, separate from jus cogens violations. National case law. Pinochet case, UK, 1999. British courts exercised universal jurisdiction over jus cogens crimes. Torture. Jus cogens crimes cannot be shielded by sovereign immunity. Limitations on jus cogens in civil cases. No solid basis in international law for denying state immunity in civil suits for torture. 4. Erga omnes obligations. Distinguished from jus cogens. Jus cogens relates to hierarchy, erga omnes concerns scope and procedural enforcement. Origin. Defined in Barcelona Traction Case, ICJ, 1970. Obligations owed to the international community as a whole. Breach allows all states to invoke state responsibility. Characteristics. Unlike traditional bilateral state obligations, erga omnes obligations bind all states equally. Includes obligations against genocide, aggression, slavery, racial discrimination, and fundamental human rights violations. Jus cogens versus erga omnes. Some jus cogens norms have erga omnes effects, for example, prohibition of genocide. Not all erga omnes obligations are jus cogens, for example, ICPRA obligations under customary international law. Next. Page. The Fundamental Principles of the International Legal Order. Henny Stridham and Lawrence Juma. _ 4.1 Introduction. Since mid-20th century, international law expanded to regulate complex global interdependence. Sovereign equality in a state-based system inevitably leads to tensions. International legal order provides a framework for peaceful coexistence and balance of rights/obligations. Core principles of post-World War II international law are largely based on Article 2 of the UN Charter. These principles serve as foundational, normative, and binding rules for lawful conduct in international affairs. 4.2 Sovereign equality. Article 2(1) of the UN Charter, The organization is based on the principle of the sovereign equality of all its members. Sovereignty. The original and exclusive power of a state to establish/maintain political and legal order. Historically, sovereignty helped overcome civil wars, feudal institutions, and unify emerging states. Originality. Sovereignty is inherent in statehood, not granted by a higher authority. Exclusivity. No other state can exercise governmental functions within another state's territory. Article 27 UN Charter prohibits interference in matters within a state's domestic jurisdiction. Sovereignty is a legal concept. Not absolute power but legal independence from other states. Legally constrained by domestic law, internally, and international law, externally. Enables states to participate in lawmaking, law enforcement, and international cooperation. Sovereign equality. Established in 1943 Moscow Conference by the US, UK, Soviet Union, and China. Recognized equal legal status for all states, regardless of size, power, or governance form. Ensures all states have equal rights in participating in international lawmaking, applying international law, adjudicating international legal claims. Principle protects smaller/weaker states by guaranteeing equal legal recognition and treatment. Underscore. Would you like a summary of the remaining sections as well? Next page. The fundamental principles of the international legal order. Henny Stridham and Lawrence Juma. Underscore. 4.2 Sovereign equality, continued. Friendly Relations Resolution, 1970, further clarifies sovereign equality. All states have equal rights and duties, regardless of economic, social, or political differences. Key elements of sovereign equality. States are judicially equal. Each state enjoys full sovereignty. States must respect the personality of other states. Territorial integrity and political independence are inviolable. States have the right to choose and develop their own systems. States must comply in good faith with international obligations and live in peace. The 1970 resolution integrates additional principles like good faith, territorial integrity, and political independence into sovereign equality. Sovereign equality remains fundamental to international law and guides global legal frameworks. This principle ensures stability in international relations and commands broad respect, despite states' differences. Underscore. 4.3 Good faith. Article 2.2 of the UN Charter, all members shall fulfill in good faith the obligations assumed by them in accordance with the present charter. Introduced by Latin American states at Dumbarton Oaks to ensure post-war international cooperation was based on morality, not just legal formalism. Bona fides, good faith, became a key principle guiding state conduct. Ensures UN obligations are fulfilled in a spirit of cooperation, beyond mere textual compliance. Importance of good faith in international law. A lack of consensus on legal obligations or an overemphasis on national interests can weaken international cooperation. Good faith serves as a reminder that treaties require collective commitment, not just legal wording. Application of good faith in international practice. 1. ICJ Advisory Opinion on UN Membership, 1948. Article 4 of the UN Charter allows discretion in determining a state's eligibility. However, any factors considered must be reasonably and in good faith related to Article 4. Prevents states from exploiting selective interpretations to serve national interests. 2. Article 26 of the Vienna Convention on the Law of Treaties, VCLT, Pacta sunt servanda, treaties must be performed in good faith. 1966 ILC Draft Articles. Good faith is a fundamental principle of treaty law. States cannot evade treaty obligations through rigid literal interpretation. 3. ICJ's Israel Wall case, 2004, relied on Article 31 of the VCLT, which mandates treaty interpretation in good faith. Used to confirm that the Fourth Geneva Convention applies to occupied Palestinian territories. Ensures treaties serve their intended purpose, rather than being manipulated for self-interest. 4. Right of passage over Indian territory case, Portugal v. India, 1960. Portugal had sovereign rights over enclave territories but needed transit through India. India controlled access. Dispute arose over whether India could refuse passage. ICJ ruled in India's favor, but dissenting opinion, Judge Fernandez, raised good faith concerns. General principle of treaty interpretation, Article 31 VCLT. Treaties should be fulfilled in the way the parties reasonably expect. Ensures agreements are implemented in good faith, reflecting their intended purpose. Underscore. Would you like a summary of the next section, 4.4 Peaceful Settlement of Disputes? Next page. 4.3 Good faith, continued. Judicial interpretations of good faith. Right of passage over Indian territory case, Portugal v. India, 1960. A state cannot recognize another state's sovereignty over an enclave while reserving the right to sever communication at will. Judge Fernandez, dissenting opinion, such conduct violates good faith, which is a fundamental principle of law. Judge Armand Dugan, dissenting opinion, India was bound to consider each transit request in good faith, without extraneous political motives. Southwest Africa voting procedure case. South Africa's administration of Southwest Africa, now Namibia, under the mandate system was disputed. Judge Clausdad, separate opinion, even if an UNGA resolution is non-binding, South Africa had a duty to consider it in good faith and respond. Judge Lauterpacht, separate opinion, states cannot ignore recommendations but must give them due consideration and provide reasons if they refuse to comply. Good faith in treaty negotiations. 1968 Treaty on the Non-Proliferation of Nuclear Weapons, NPT, Article V. States must negotiate in good faith to achieve nuclear disarmament. 1995 UN Security Council resolution reaffirmed this obligation. ICJ in nuclear weapons case, 1996. The duty to negotiate nuclear disarmament in good faith is more than an obligation of conduct. It is an obligation to achieve a specific result, complete nuclear disarmament. Marshall Islands v. UK, Pakistan and India, 2014. Marshall Islands sued these states for failing to fulfill good faith obligations under Article V of the NPT. ICJ dismissed the case due to lack of a legal dispute between the parties, avoiding a ruling on the merits. Bolivia v. Chile, 2018. ICJ ruled that when states agree to negotiate disputes, they must do so in good faith. Good faith negotiations must be meaningful. States cannot rigidly insist on their own position without considering the other party's stance. Key takeaways on good faith. A fundamental principle that applies to treaties, UN obligations, and negotiations. States must not act in bad faith by selectively ignoring obligations. Non-binding resolutions still require good faith consideration. Good faith in negotiations requires real efforts, not just formal discussions. _ Would you like a summary of 4.4 Peaceful settlement of disputes next? Next page. 4.4 Peaceful settlement of disputes. Legal basis for peaceful dispute resolution. Article 2.3 of the UN Charter. States must settle disputes peacefully to prevent threats to international peace, security, and justice. UN's purpose. Article 1 of the UN Charter. Maintain international peace and security. Settle disputes peacefully and in accordance with justice and international law. Key UN resolutions on peaceful dispute settlement. Friendly Relations Resolution reaffirms the principle of peaceful resolution. Manila Declaration on the Peaceful Settlement of International Disputes guides states on peaceful means of dispute resolution. Methods of dispute resolution under the UN Charter. Article 33 of the UN Charter. Parties to a dispute must first attempt to resolve it through negotiation, inquiry, mediation, conciliation, arbitration, judicial settlement, regional mechanisms or any other peaceful means. Article 37(1) of the UN Charter. If peaceful means fail, the dispute must be referred to the Security Council. Security Council's role, Article 36 to 37. Recommend solutions or settlement terms. Chapter 6 powers do not include binding decisions. Legal debate on Security Council recommendations. Article 25 of the UN Charter. Members must accept and carry out Security Council decisions. ICJ's 1971 SWA/Namibia Advisory Opinion. Article 25 applies to both Chapter 6, Peaceful Settlement, and Chapter 7, Enforcement Measures. Security Council recommendations under Chapter 6 may be binding. Counter-argument. Article 24(2) limits Council powers to those in Chapter 6, 7, 8, and 12. A distinction exists between decisions, Article 25, and recommendations, Articles 36 to 37. Result: whether Chapter 6 recommendations are binding remains debated. Case study: Iran hostage crisis, 1979. Facts: Iranian students seize the U.S. Embassy, holding diplomats hostage. Security Council response. Resolution, December 4, 1979. Demanded Iran release hostages and urged peaceful settlement. ICJ provisional measures, ordered Iran to free hostages. Iran's reaction, ignored both the Security Council and ICJ orders. U.S. response, December 22, 1979, requested the Security Council's intervention. Dispute referral mechanisms in the UN Charter. Article 35, any state can refer a dispute to the Security Council or General Assembly. UN members may bring disputes affecting international peace to the Security Council or General Assembly. Non-UN members may also refer disputes if they accept UN Charter obligations. Article 37 versus Article 35. Article 37, parties to a dispute must first try peaceful means. Article 33, before referring to the Security Council. Article 35, any state, even if not a party to the dispute, can bring attention to a potential threat to international peace. Security Council actions under Chapter 6. Investigate disputes to determine if they threaten international peace. If a threat exists, it may invoke Chapter 7 enforcement measures. General Assembly's role in dispute settlement. Residual competence, Articles 11 to 14 of the UN Charter. Can discuss peace and security issues. Recommend solutions but cannot make binding decisions. Limitations on General Assembly powers. Article 11(2), if enforcement action is needed, the matter must be referred to the Security Council. Article 12(1), the General Assembly cannot make recommendations on disputes already under Security Council consideration, unless the Security Council requests it. Key takeaways. Article 2(3) of the UN Charter mandates peaceful dispute resolution. Parties must exhaust peaceful means. Article 33, before referring disputes to the Security Council. Article 37. The Security Council's Chapter 6 recommendations may or may not be binding. ICJ has ruled both ways. General Assembly has limited authority. It can discuss and recommend but not enforce solutions. Disputes threatening peace may lead to Chapter 7 enforcement actions. Would you like a summary of Chapter 5, Use of Force in International Law? Next. Page 4.5 Prohibition on the use of force. 1. General Principle. Article 2(4) of the UN Charter prohibits the threat or use of force against a state's territorial integrity or political independence, recognized as customary international law and a jus cogens norm, subject to interpretational disputes regarding its application in various situations. 2. Historical development. Covenant of the League of Nations, 1919. Contain procedural measures, Articles 12 to 15. For dispute resolution, failed due to weak enforcement mechanisms and lack of universal membership. Kellogg-Briand Pact, 1928. Treaty of Paris. First Universal Treaty prohibiting war. Article I. States renounce war as a national policy instrument. Article 2. Disputes must be settled by peaceful means. Shortcomings. No enforcement/sanctions mechanism. Prohibition limited to war, excluding other military actions. 3. UN Charter's reinforcement of prohibition. Article 2(4) expands prohibition to all use of force, not just war. Includes the threat of force if the actual use of force would be unlawful. ICJ, Nuclear Weapons Advisory Opinion. Criteria for violation. Action must be against another state's territorial integrity or political independence or be inconsistent with UN purposes. Any cross-border armed force impairing these rights violates Article 2(4). UN Friendly Relations Resolution. Military occupation from force is illegal. Territorial acquisitions by force not recognized as lawful. 4. Case studies. Eritrea-Ethiopia Claims Commission, 1998. Eritrea's attacks on Ethiopia were unlawful, despite claiming Ethiopian occupation. Iraq's invasion of Kuwait, 1990. Clear breach of Article 2(4) due to Iraq's occupation and demands. U.S. operation to kill Osama bin Laden, 2011. Raises debate on whether limited covert military actions violate Article 2(4). 5. Scope and interpretation issues. Scholarly debate on the threshold of force. Core 10 proposes a gravity threshold, assessing effects on the victim state. Article 2(4) violated when 1. Extraterritorial military action occurs. 2. Pre-existing conflict or high tension exists. 3. State authorities authorize action. 4. Security forces, infrastructure, or leaders are targeted. 5. Military confrontation occurs between states. 6. Force used includes troops, bombings, or bombardments. Rise, opposes gravity threshold. Any armed confrontation between states qualifies. Test, whether the victim state would be legally entitled to respond with force. Small-scale incursions still violate Article 2(4). 6. The meaning of force. Prevailing view. Article 2.4 covers only armed force. Economic coercion was excluded in UN Charter drafting. Friendly Relations Resolution, UN. Prohibits economic, political, or other coercive measures to force state compliance. OISH Charter, 1948. Extends prohibition beyond armed force to economic, political, and cultural interference. U.S. bilateral agreements and economic pressure. Example: U.S. pressuring states to avoid surrendering its nationals to the ICC raises questions under the Friendly Relations Resolution. Next page. 4.6 Responsibility of states and international organizations. Principle: States and international organizations must accept responsibility for their actions under international law. State responsibility: failure to meet obligations results in liability. International organizations, increasingly held responsible due to their role in international law. Legal responsibility: consequences arise once a breach of international law is established. Key case: Spanish Zone of Morocco claims, responsibility follows from a right and results in a duty to make reparations. Underscore. 4.6.1 Responsibility of states. Obligations: states must respect international law and perform duties diligently. Wrongful acts, breaches of treaty law or customary international law result in state responsibility. Types of responsibility: direct, state organs or agents breach obligations. Indirect, breach injures foreign nationals or property. Scope, defined by primary rules, what constitutes a wrongful act, and secondary rules, consequences of a breach. Codification, developed by the ILC, culminating in the 2001 ILC Draft Articles on State Responsibility, DASR. Underscore. 4.6.1.1 Nature of Responsibility. DASR Article 1. Every internationally wrongful act of a state entails responsibility. Objective responsibility: no requirement for fault, negligence, or intent, mens rea. Established practice, followed by states, arbitral tribunals, and the ICJ. Legal consequences: breach of a primary rule automatically triggers secondary responsibility. Underscore. 4.6.1.2 Wrongfulness. Definition: determined by international law, regardless of internal state law. Acts and omissions: wrongfulness can arise from action or failure to act. Circumstances precluding wrongfulness, DASR exceptions. 1. Consent, art. 20. Valid consent by a state precludes wrongfulness. For example, armed activities case, Uganda's actions exceeded the DRC's consent. 2. Self-defense, art. 21. Lawful self-defense under the UN Charter precludes wrongfulness, covered in Chapter 5. 3. Countermeasures, art. 22. Acts responding to wrongful conduct are not wrongful, covered in Chapter 5. 4. Force majeure, art. 23. An irresistible force or unforeseen event making performance impossible precludes wrongfulness unless the state contributed to the situation. 5. Distress, art. 24. No wrongful act if undertaken to save lives, unless the state caused the situation or created greater peril. 6. Necessity, art. 25. May be invoked if the act was the only way to protect an essential interest from grave and imminent peril, without impairing another essential interest. Limitations, not applicable if the obligation excludes necessity or if the state contributed to the peril. ICJ and Gob Chikovo Najimaro's project case. Recognized necessity as part of customary international law. Requires strict conditions. The state invoking it cannot be the sole judge. Raises debate over whether humanitarian intervention could be justified under necessity. Next page. 4.6.1.2 Wrongfulness, continued, peremptory norms, jus cogens, and wrongfulness. If a state breaches a peremptory norm of international law, the wrongfulness cannot be precluded by invoking any of the exceptions: consent, self-defense, countermeasures, force majeure, distress, necessity. Jus cogens norms prevail over conflicting obligations. Underscore. 4.6.1.3 Attributability. Definition: the act or omission must be legally connected to the state to hold it responsible for a breach of international law. DASR Article 2 defines elements of an internationally wrongful act. 1. The conduct must be attributable to the state. 2. The conduct must constitute a breach of an international obligation. Conceptual issue in DASR. The wording in Article 2 suggests attributability is part of wrongfulness, though logically it should follow after wrongfulness is established. A clearer formulation could place breach determination before attributability. Circumstances of attributability. Various situations in which an act or omission is legally connected to a state will be discussed later in this chapter. Next. Page 4.6.1.4 Responsibility for the conduct of state organs. General Rule, DOSR Article 4.1. Acts of any state organ, legislative, executive, judicial, or other functions, are considered acts of the state under international law. This applies regardless of whether the organ belongs to the central government or a territorial unit. The rule is part of customary international law. Acts and omissions of state organs. A state can be responsible for wrongful actions by its organs, failures to act, omissions, where a duty exists. State responsibility despite ultra vires acts, DOSR Article 7. Even if a state organ or official exceeds authority or contravenes instructions, the state is still responsible if the act was performed in an official capacity. Humans claim, U.S. v. Mexico. Mexican soldiers, instead of dispersing a violent mob, opened fire on a house, killing U.S. nationals. Mexico argued the soldiers acted ultra vires. Claims Commission ruled that Mexico was responsible because the soldiers acted as state agents, even if they disobeyed orders. Distinguishing official versus private acts. State is liable if an official acts in an official capacity, even if wrongful. State is not liable if an official acts in a purely private capacity. Mullen Case, Mexico U.S. General Claims Commission. An off-duty policeman personally arrested, jailed, and fined a U.S. citizen. Not attributable to the state. Later, while on duty, he assaulted and jailed the same person. Attributable to the state. The distinction was based on whether the officer was acting as an official at the time. State responsibility for omissions. Corfu Channel Case, UK v Albania. Albania failed to warn ships of a known minefield, leading to damage to a British warship. ICJ ruled Albania responsible for the omission. Tehran hostages case, US v Iran. Iranian authorities failed to protect the U.S. embassy from militant attack. ICJ ruled Iran responsible for its inaction, which violated diplomatic protection obligations. Armed forces as state organs. Armed activities case, DRC v Uganda. Ugandan forces in the DRC supported rebels and committed human rights violations. ICJ ruled Uganda responsible for all acts committed by its military, including individual soldiers' violations. Even if military personnel exceeded orders, their actions were attributable to the state. Responsibility for state organs under foreign control. If a state organ is placed at the disposal of another state, the receiving state is responsible if the organ acts under its control and direction. Next. Page 4.6.1.5 Responsibility for the conduct of non-state entities exercising governmental authority. DOSR Article 5. Conduct of a non-state person or entity exercising elements of governmental authority is attributable to the state if it is empowered by domestic law to exercise such authority. It acts in that capacity in the specific instance. Justification, Crawford. Many governmental functions are now performed by parastatal entities or privatized corporations with public/regulatory functions. Test for attributability. Nature, content, and purpose of functions assigned by domestic law must indicate governmental authority. Underscore. 4.6.1.6 Responsibility for the conduct of private persons or groups. DOSR Article 8. Conduct of private persons or groups is attributable to the state if 1. They act on the state's instructions. 2. They act under the state's direction or control. Interpretation. Instructions, direction, and control are disjunctive. Proof of any one is sufficient. 1. Acts on state instructions. A state can be responsible if it uses private persons or entities to carry out its objectives, for example, private military/security companies in conflict zones. Bosnia genocide case, ICJ. The ICJ ruled that general instructions to a group are not enough for attribution. Specific instructions for each operation must be established. If violations were incidental to the mission, the state could be responsible. If the private entity ignored instructions or acted outside its mission, the state is not liable. Differs from ultra vires acts of state organs, which remain attributable to the state. 2. Acts under state direction or control. Nicaragua case, ICJ, 1986. The U.S. provided financial, logistical, intelligence, and military support to the Contras, Nicaraguan rebels. The ICJ ruled that this alone was insufficient to attribute the Contras' actions to the U.S. Effective control test. The U.S. would be responsible only if it fully controlled the Contras' strategy and tactics. The court found no such control. Tadic case, ICTY. The effective control test was rejected as too strict. The tribunal introduced the overall control test. If a state supports, coordinates, and directs a group's actions, attribution may occur even if the group acts independently in some situations. Lower standard than full operational control. Next page. 4.6.1.6 Responsibility for the conduct of private persons or groups, continued 3. The overall control test, Tadic case and subsequent jurisprudence, Tadic case, ICTY. Introduced the overall control test, requiring a state to participate in the general direction, coordination, and supervision of the group, provide financial, logistical, or operational support, does not require specific instructions for each wrongful act. Gotovina case, ICTY. Confirmed overall control is satisfied if the state organizes, coordinates, or plans military actions, finances, trains, equips, or supports the armed group. Armed activities, DRC v Uganda, case, ICJ. Relied on Nicaragua's effective control test instead of Tadic's overall control test. Bosnia genocide case, ICJ. Held that genocide is attributable to a state only if it was ordered or directed by the state. The state exercised effective control over the acts. Rejected the overall control test for state responsibility. Stated it broadens state responsibility too far. Held a state is only responsible for its own conduct or that of its agents. 4. Debate between effective control and overall control tests. ICJ's criticism of overall control, Bosnia genocide case. The overall control test stretches the link between state conduct and international responsibility too far. A state is responsible only if it directed or instructed the wrongful act. It had effective control over the conduct at the time. Cassasi's criticism of the effective control test. The ICJ failed to justify its use of effective control in Nicaragua. Effective control is meant for individuals acting on state orders, not organized armed groups. The overall control test is more appropriate for military/paramilitary groups. A state's systemic support and coordination of a group implies responsibility. No need for direct instructions for each act. 5. Relevance of overall control in modern conflicts. State support of armed groups and terrorists. Some states support armed groups and terrorist organizations in conflicts, for example, Middle East, Africa. The effective control test makes proving state responsibility difficult. Hard to prove specific instructions for each act. Many operations are clandestine and secretive. The overall control test makes attribution easier. A state is responsible if it arms, finances, and coordinates a group's activities. Alternative approach, state responsibility for terrorism. Some scholars argue modifying the effective control test is unnecessary. Primary norms of international law already impose state duties. States must prevent harm to other states and not allow their territory to be used for terrorism. State responsibility depends on whether the state knew or should have known of a threat, whether it had the capacity to stop it. States also have treaty obligations and must follow Security Council measures. 6. Responsibility of international organizations. UN and regional organizations using national troops, for example, peacekeeping forces. Issue: who is responsible for violations of international law? The international organization, for example, UN, AU, the state that contributed the troops. Complex legal issues arise, explored further in later sections. Next page. 4.6.1.7 Responsibility for the conduct of insurgents and insurrectional groups. 1. General rule: no state responsibility for insurgent groups. A state is generally not responsible for the actions of insurgent or rebel movements. Insurgent groups are assumed to have independent structures and organizations separate from the state. Solis case, U.S. v. Mexico. The U.S. sought compensation for cattle taken by Mexican soldiers. Mexico denied liability, arguing the soldiers were from an insurgent group, De la Huerta, and not federal troops. Ruling: Mexico was not responsible for the insurgents' actions. 2. Exception: insurgents who become the government. Article 10(1) DOSR, when an insurgent movement overthrows the government and becomes the new state authority. The state is responsible for the prior conduct of the insurgent group. Legal basis: Article 10, one of the draft articles on state responsibility, DASR. The conduct of an insurrectional movement which becomes the new government of a state shall be considered an act of that state under international law. Rationale. There is continuity between the insurgent group and the new government. The state remains the same legal entity, despite the change in leadership. 3. Exception. Insurgents who form a new state. Article 10(2) DASR. If an insurgent movement successfully secedes and forms a new state, the new state is responsible for the actions of the insurgent group. Legal basis. Article 10(2) DASR. The conduct of a movement, insurrectional or other, which succeeds in establishing a new state in part of the territory of a pre-existing state or in a territory under its administration shall be considered an act of the new state under international law. Example. A secessionist movement in an existing state gains independence and forms a new state. The newly created state is responsible for the movement's actions before independence. Next page. Attribution based on subsequent acceptance or approval of a wrongful act. Article 11 of the draft Articles on Responsibility of States for Internationally Wrongful Acts, DASR, addresses scenarios where a state may be held responsible for actions it did not initially authorize or control. Conduct which is not attributable to a state under the preceding articles shall nevertheless be considered an act of that state under international law if and to the extent that the state acknowledges and adopts the conduct in question as its own. This provision implies that even if an act was carried out by private individuals or entities without direct state involvement, the state can incur responsibility if it subsequently acknowledges and adopts the conduct as its own. Such acknowledgement must go beyond mere expressions of support or endorsement. It requires a clear and unequivocal acceptance of the conduct as that of the state. A notable example is the Tehran hostages case, United States Diplomatic and Consular Staff in Tehran, ICJ, 1980. Initially, Iranian militants, acting as private citizens, seized the U.S. Embassy in Tehran and took hostages. While their actions were not directly attributable to the Iranian state at the outset, the situation changed when Ayatollah Khomeini, Iran's head of state, issued a decree endorsing the militants' actions and declaring that the hostages would remain captive until certain demands were met. The International Court of Justice, ICJ, determined that this official endorsement transformed the militants' actions into acts of the Iranian state, thereby making Iran internationally responsible for the wrongful acts. Legal consequences of an internationally wrongful act. When a state commits an internationally wrongful act, several legal consequences ensue, as outlined in Part 2 of the DASR. 1. Continued duty of performance. The state remains obligated to perform the international obligation it has breached. The breach does not terminate or suspend the obligation. The state must continue to fulfill its duties under international law. 2. Cessation and non-repetition. The responsible state is required to cease the wrongful conduct if it is ongoing and provide assurances that such conduct will not recur. This ensures that the breach does not continue and that similar violations are prevented in the future. 3. Reparation. The state must make full reparation for the injury caused by the wrongful act. Reparation can take several forms. Restitution, restoring the situation to what it was before the wrongful act occurred, provided it is materially possible and does not impose a disproportionate burden on the responsible state. Compensation, when restitution is not possible, the state must compensate for the damage caused, covering any financially accessible damage, including loss of profits. Satisfaction, for non-material damage or injuries that cannot be remedied through restitution or compensation, the state may provide satisfaction. This can include formal apologies, acknowledgments of the breach, or other appropriate measures that are proportional to the injury and do not humiliate the responsible state. These principles underscore the importance of holding states accountable for internationally wrongful acts and ensuring that affected parties receive appropriate remedies. Sources. Next page. The passage you've provided delves into the intricacies of state responsibility under international law, particularly focusing on the consequences of internationally wrongful acts and the mechanisms available for enforcement. Here's a breakdown of the key points. 1. Contributory conduct and reparation. When determining reparation for an injury, the injured state's own willful or negligent actions contributing to the harm are considered. This principle ensures that reparation reflects the actual extent of responsibility, taking into account any contributory fault by the injured party. 2. Serious breaches of peremptory norms. Jus cogens, a serious breach of an obligation arising from a peremptory norm of general international law, such as prohibitions against aggression, genocide, slavery, and racial discrimination, triggers specific legal consequences. These norms, known as Zhukogens, are fundamental principles that are universally binding. In cases of serious breaches, characterized by gross or systematic failure to fulfill such obligations, all states are obligated to end the breach, employ lawful means to bring the breach to an end. Non-recognition, refrain from recognizing situations created by these breaches as lawful. Non-assistance, avoid aiding or assisting in maintaining the situations resulting from these breaches. This framework underscores the collective responsibility of the international community to uphold fundamental norms and prevent violations. 3. Erga omnes obligations. These are obligations owed to the international community as a whole, not just to individual states. The International Court of Justice, ICJ, in the Barcelona traction case, highlighted that certain obligations, such as those prohibiting acts like aggression, genocide, slavery, and racial discrimination, are erga omnes. This means all states have a legal interest in their protection, reinforcing the collective responsibility to uphold these fundamental norms. 4. Enforcing state responsibility. When an internationally wrongful act occurs, the mechanisms for enforcement depend on the nature of the obligation breached and the states involved. Injured states, primarily, the state directly affected by the breach, the injured state, has the right to invoke the responsibility of the offending state. This is outlined in Article 42 of the Draft Articles on Responsibility of States for Internationally Wrongful Acts, DASR, which specifies that an injured state can invoke responsibility if the breached obligation is owed to it individually or as part of the group, provided certain conditions are met. Non-injured states, under Article 48 of the DASR, states that have not suffered direct injury can still invoke responsibility if the breached obligation is owed to a group of states, including the invoking state, or to the international community as a whole. This provision acknowledges that some obligations are so fundamental that their breach affects the collective interests of the international community, allowing any state to take action to uphold these norms. 5. Invocation of responsibility. Both injured and non-injured states must notify the responsible state of their claims, specifying the conduct expected to cease the wrongful act in the form of reparations sought. The right to invoke responsibility can be lost if the injured state waives its claim or acquiesces through its conduct. These principles collectively ensure that breaches of international law, especially those violating fundamental norms, are addressed through a combination of state responsibility, collective enforcement, and obligations erga omnes, thereby maintaining the integrity of the international legal order. Sources. Next page. In international law, standing refers to a state's capacity to bring a claim against another state before an international tribunal. This capacity is typically linked to the state's legal interest in any injury resulting from the alleged wrongful act. A state must demonstrate a sufficient legal interest in the dispute, akin to the requirement for litigants in domestic courts. The concept of legal interest is closely intertwined with the nature of obligations breached and the injury suffered. Generally, states that are not beneficiaries of specific international obligations cannot claim the right to enforce them. This principle was notably examined in the Southwest Africa cases before the International Court of Justice, ICJ, in the 1960s. In 1960, Ethiopia and Liberia, both former members of the League of Nations, petitioned the ICJ for a binding judgment on South Africa's administration of Southwest Africa, now Namibia, alleging failures to uphold obligations under the mandate system, including the practice of apartheid. South Africa contested their standing, arguing that neither country had a material interest in the matter. In 1962, the ICJ ruled that Ethiopia and Liberia, as former League members, had the legal right to institute proceedings. However, in a controversial 1966 judgment, the ICJ found that while Ethiopia and Liberia had standing to initiate the case, they lacked a sufficient legal interest in Southwest Africa to warrant a judgment on the merits, effectively dismissing their claims. Wikipedia. The ICJ has traditionally adopted a conservative approach to standing, requiring states seeking to intervene to identify a legal interest that may be affected by the court's decision. However, this narrow perspective has evolved, particularly concerning obligations erga omnes, duties owed to the international community as a whole. A significant development occurred in the case of Belgium v. Senegal concerning the prosecution of Hissène Habré, the former president of Chad, accused of crimes against humanity. Belgium sought Haber's extradition or prosecution under the 1984 Convention Against Torture, despite having no direct national interest, as no Belgian nationals were among the victims. The ICJ recognized that under the Torture Convention, every state party has a common interest in ensuring that acts of torture are prevented and that perpetrators do not enjoy impunity. This acknowledgement of a collective interest allowed Belgium to have standing, even without a direct injury, marking a shift towards recognizing community interests in international law. Wikipedia. These developments indicate a broader interpretation of standing in international law, accommodating the enforcement of obligations that protect collective interests of the international community, even when the claimant state has not suffered a direct injury. Next page. 4.6.1.12 Standing. Definition and importance. Standing refers to a state's right to bring a claim against another in an international tribunal. It ensures legitimacy and legality in international legal proceedings. Standing is linked to legal interest, which depends on the nature of breached obligations and injury suffered. A state that is not a beneficiary of an international obligation generally cannot enforce it. Southwest Africa cases, 1962 and 1966, ICJ, 1962, Ethiopia and Liberia, former League of Nations members, petition ICJ to declare South Africa's misadministration of Southwest Africa/Namibia. South Africa's argument: the applicants lacked standing as they had no material interest. ICJ ruling, 1962, the League members had a legal interest in ensuring compliance with mandates. 1966 reversal, the ICJ, by the President's casting vote, ruled that League members had no individual right to enforce mandates, as only the League Council had supervisory authority. ICJ's conservative approach to standing. A state must identify a legal interest that may be affected by a decision. The ICJ determines whether intervention is permissible. If a third state's interest is a necessary element in the case, it must be joined as a full party. Evolution towards community interests and erga omnes obligations. Traditional standing rules are evolving to include community-oriented interests. Belgium v. Senegal. Hissène Habré case, issue: Senegal failed to prosecute or extradite Habré for torture under the 1984 Torture Convention. Standing challenge: Belgium had no direct national interest, no Belgian victims. ICJ ruling. The Torture Convention establishes a common interest among all state parties in preventing torture. Obligations under the convention are erga omnes, owed to the international community. Any state party can demand compliance, regardless of direct injury. Implications and unresolved questions. The ICJ's reasoning suggests that peremptory human rights obligations, jus cogens, might provide sufficient legal interest. However, the ruling was based only on treaty obligations, leaving open whether customary international law alone could establish standing. The ICJ still operates within the state consent framework, limiting the role of broader international community interests. Countermeasures based on erga omnes obligations are also relevant, discussed in Chapter 5. 4.6.1.13 Claims on behalf of nationals and legal entities. Indirect responsibility and diplomatic protection. A state can bring a claim on behalf of its nationals when a foreign state violates minimum international treatment standards. Diplomatic protection is the process of a state invoking responsibility for an injury to its nationals. Legal basis and key rules. Draft Articles on Diplomatic Protection, DADP, 2006, Article 1. Diplomatic protection involves a state invoking another state's responsibility for injuring its national. Article 2. A state has the right, not duty, to exercise diplomatic protection. Article 3.1. The state of nationality has the right to protect its nationals. Exhaustion of local remedies rule. Before international claims, the injured person must exhaust effective domestic legal remedies. Exceptions. Article 14.1, DADP. Remedies are unavailable or ineffective. Undue delay in proceedings. No connection between the injured person and the responsible state at the time of injury. The injured person is precluded from pursuing remedies. The responsible state has waived the local remedies requirement. ICJ in the Diallo case. The applicant state must prove that local remedies were exhausted or that exceptions apply. The respondent state must show that effective remedies were available but not used. Additional issues in diplomatic protection. Effective nationality requirement, to be addressed in detail. Whether states are obligated to exercise diplomatic protection. Protection of legal entities, companies and corporations. Next page. 4.6.1.13.1 Nationality requirement. Article 4 of the DADP does not require a genuine or effective link for diplomatic protection. Nottebohm case, ICJ 1955. Nottebohm, a German national, acquired Liechtenstein nationality in 1939 but had strong ties to Guatemala. Guatemala rejected his Liechtenstein nationality and expelled him as a German citizen. ICJ ruling: nationality must be a real and effective link for diplomatic protection to be exercised. Conclusion: Liechtenstein could not claim diplomatic protection for Nottebohm due to his lack of a genuine link. ILC commentary on Article 4. The genuine link requirement is not a general rule but case-specific, depending on ties with the claimant and respondent state. Applying this requirement strictly would exclude many people due to modern migration and globalization. Article 6 of the DADP allows any state of nationality to exercise diplomatic protection without a genuine link requirement. Article 7 of the DADP: if an injured person holds nationality of both the applicant and respondent states, diplomatic protection is allowed only if the applicant state's nationality is predominant. Burden of proof: the applicant state must prove predominance at the time of injury and proceedings. Article 8 of the DADP allows diplomatic protection for stateless persons and refugees based on lawful and habitual residence at the time of injury and claim submission. Exception: the state of residence cannot claim protection if the refugee's own state committed the wrongful act. 4.6.1.13.2 Duty to exercise diplomatic protection. Article 2 of the DADP: a state has the right to exercise diplomatic protection, but no obligation under international law. Article 19 of the DADP suggests a possible duty in certain cases. States should consider exercising diplomatic protection when significant injury occurs. They should consider the views of the injured person. Compensation obtained must be transferred to the injured person, subject to reasonable deductions. Growing support for a duty to intervene in human rights violations. Dugard. Case law on reviewability of diplomatic protection decisions. Abbasi v. Secretary of State for Foreign and Commonwealth Affairs, UK. British citizen detained at Guantanamo Bay sought UK intervention. Court found no obligation but stated refusal to even consider protection could be reviewable. Kaunda v. President of South Africa. South African nationals detained in Zimbabwe faced inhumane treatment and risk of execution in Equatorial Guinea. Majority view: the right to diplomatic protection is discretionary. Next page. 4.6.1.13.1 Nationality requirement. Article 4 of the DADP, Draft Articles on Diplomatic Protection, establishes nationality as the key requirement for diplomatic protection, does not require a genuine link between the individual and the state. Nottebohm case, ICJ, 1955. Facts: Nottebohm, a German national, obtained Liechtenstein nationality in 1939. He had lived in Guatemala for decades and was expelled due to his German origins during World War II. Liechtenstein claimed diplomatic protection for Nottebohm against Guatemala. Ruling: the ICJ held that nationality must reflect a real and effective link between the individual and the state. Since Nottebohm's ties to Liechtenstein were weak, Guatemala was not obligated to recognize his nationality. Impact on the DADP. The ILC, International Law Commission, interpreted the Nottebohm case as context-specific, not a universal rule. Article 6 of the DADP allows diplomatic protection for individuals with multiple nationalities without requiring a genuine link. Article 7 of the DADP: if the injured person has the nationality of both the claimant and respondent states, the claimant state must prove that its nationality is predominant at the time of injury and proceedings. Progressive developments. Article 8 of the DADP allows diplomatic protection for stateless persons and refugees if they have lawful and habitual residence in the claimant state. Exception: the state of residence cannot act if the injury was caused by the refugee's state of nationality. Underscore. 4.6.1.13.2 Duty to exercise diplomatic protection. Article 2 of the DADP. States have the right, not a duty, to exercise diplomatic protection. Article 19 of the DADP suggests states should consider diplomatic protection, particularly in cases of significant injury. States should consider exercising diplomatic protection, take into account the injured person's views, transfer compensation to the injured person, subject to deductions, growing legal support for a duty to protect. Some argue that in cases of serious human rights violations, states may have a duty to protect their nationals. Key case law. 1. Abbasi v. Secretary of State for Foreign and Commonwealth Affairs, UK, 2002. Facts: Abbasi, a British national, was detained in Guantanamo Bay without trial or legal access. Ruling. The UK government had no legal obligation to intervene. However, in extreme cases, courts could review government decisions and compel proper consideration of diplomatic protection. 2. Kaunda v. President of South Africa, Constitutional Court, 2004, Facts. South African nationals arrested in Zimbabwe faced mistreatment and potential execution in Equatorial Guinea. Majority ruling. The state has discretion in exercising diplomatic protection but may have a duty to act in cases of gross human rights violations. A refusal to consider a request or an irrational decision could be subject to judicial review. Concurring opinion, Nkobo J. The South African government has a constitutional obligation to consider requests for diplomatic protection. Dissenting opinion, Oregon J. Diplomatic protection is an enforceable constitutional right. 3. Van Abo v. Government of South Africa, High Court and Supreme Court of Appeal, 2009 to 2011, Facts. A South African national's farmland in Zimbabwe was expropriated without compensation. The South African government refused to intervene. High Court ruling. The government had a constitutional duty to consider the request in good faith. Ordered the government to take steps within 60 days and report on its actions. Supreme Court of Appeal ruling, overturned High Court decision. South Africa cannot be held liable for damages caused by Zimbabwe. The government only had a duty to consider diplomatic protection, not guarantee a specific result. The High Court overstepped its powers by dictating diplomatic action. General principles from case law. Governments have discretion in diplomatic protection but must consider requests rationally and in good faith. Courts can review government decisions if they are irrational or amount to bad faith. No obligation to achieve a specific outcome, as diplomatic efforts depend on foreign state cooperation. Next. Page 4.6.1.13.3 Legal entities. Legal entities, like individuals, can be harmed by states where they operate and may receive diplomatic protection from their state of nationality. Determining corporate nationality. A company is generally considered a national of the state where it is incorporated. Complications arise when the place of incorporation differs from the place of business or when shareholders have different nationalities. Barcelona Traction Case, ICJ. Barcelona Traction Limited was incorporated in Canada, supplied electricity to Spain, and had Belgian shareholders. Spain declared the company bankrupt, and Belgium sought diplomatic protection for its shareholders. ICJ held that Canada, as the country of incorporation, had the right to exercise diplomatic protection. A close and permanent connection existed with Canada due to incorporation, board meetings, financial records, and tax registration. Shareholders only suffer indirect injury when a company is harmed, so their home state cannot claim diplomatic protection unless the company ceases to exist legally, preventing shareholders from seeking remedies. The injury directly infringes shareholders' rights rather than the company's rights. DAT provisions on corporate nationality. Article 9. A company's nationality is based on incorporation but can be redefined if it has no substantial business activities in the state of incorporation. It is controlled by nationals of another state, and its management and financial control are in that state. Article 11. Shareholders' home state cannot exercise diplomatic protection unless the corporation ceases to exist for reasons unrelated to the injury. The company had the nationality of the state responsible for the injury, and incorporation in that state was a business requirement. Article 12. A state can exercise diplomatic protection for its nationals if the injury directly affects their rights rather than the company's rights. Underscore 4.6.2 Responsibility of international organizations. International organizations play a significant role in international law, but their legal status remains unclear. Their competence is limited to powers granted by their founding instruments. Nuclear Weapons Case, ICJ, established that international organizations are subjects of international law but lack general competence. Operate under the principle of speciality, meaning their powers are limited to the functions states have entrusted to them. Evolution of international responsibility. 1956 ILC report recognized the need to adapt state responsibility principles to accommodate the role of international organizations. 2001 UN General Assembly request led to the drafting of the 2011 ILC draft articles on the responsibility of international organizations, DARIO. DARIO and DASR comparison. DARIO is modeled after the draft articles on state responsibility, DASR, equates states and international organizations in terms of responsibility to prevent legal fragmentation. Underscore 4.6.2.1 Legal personality of international organizations. Legal personality enables international organizations to operate in the international legal system, enter into legal agreements, enjoy privileges such as immunity from national jurisdiction, be held liable for wrongful acts, bring claims for damages suffered. Definition in Dario. Article 2A of Dario defines an international organization as one established by a treaty or other legal instrument and possessing international legal personality. Acquiring legal personality. 1. Constituent documents. Legal personality may be explicitly granted in the organization's founding treaty. 2. Implied powers doctrine. Legal personality may be inferred from the organization's functions. Reparations case, ICJ. ICJ was asked whether the UN could claim reparations against a state for harm suffered. ICJ's ruling. The UN had implied legal personality necessary to fulfill its obligations. It could claim reparations even without explicit legal personality in its founding documents. Next page. 4.6.1.13.3 Legal entities. Legal entities, like individuals, can suffer injuries in foreign states and receive diplomatic protection from their state of nationality. Nationality of corporate entities. Generally determined by the place of incorporation or registration. Complications arise when incorporation and business operations are in different states. Shareholders of different nationalities suffer injury. Barcelona Traction case. Incorporated in Canada, operated in Spain, and had Belgian shareholders. Spain declared it bankrupt. Belgium sought diplomatic protection for shareholders. ICJ ruling. Canada, not Belgium, had the right to diplomatic protection. Distinguished between direct injury to the company and indirect injury to shareholders. Shareholders only have diplomatic protection if the company ceases to exist. Their rights are directly infringed, separate from company rights. Draft Articles on Diplomatic Protection, DADP. Article 9. If a company lacks substantial business in its state of incorporation and is controlled elsewhere, nationality is based on management and financial control. Article 12. If shareholders suffer direct injury, their state can exercise diplomatic protection. Article 11. Shareholders' state cannot exercise diplomatic protection unless the company ceases to exist for unrelated reasons. The company had the nationality of the injuring state due to incorporation requirements. Underscore. 4.6.2 Responsibility of international organizations. International organizations, IOs, are major actors in international law, though their legal standing has been debated. ICJ in the nuclear weapons case. IOs have legal personality but only the powers granted by their constituent instruments. They function under the principle of speciality, limited powers based on the common interests of member states. Development of responsibility rules. 2001. UN General Assembly requested the International Law Commission, ILC, to address IO responsibility. 2011 ILC Draft Articles on the Responsibility of International Organizations, Dario. Based on the 2001 Draft Articles on State Responsibility, DASR, ensures similar rules apply to states and IOs, preventing fragmentation in international law. Underscore. 4.6.2.1 Legal personality of international organizations. Definition, Dario, Article 2A. An organization with its own international legal personality, established by a treaty or similar legal instrument. Ways IOs acquire legal personality. Constituent documents. Doctrine of implied powers, powers inferred from their functions. Reparations case. Reparations case, ICJ, 1949. UN had international legal personality to effectively discharge its mandate. Could bring claims and be held liable for wrongful acts. Objective legal personality. Recognized for organizations like the UN. Allows independent action without member state control. Derived from customary international law. Rights of IOs, CUSAISI. Enter international agreements. Enjoy jurisdictional immunity. Protect their agents. Bring international claims. Underscore. 4.6.2.2 The principle of attribution. Dario, Article 4, an IO commits an internationally wrongful act if the conduct is attributable to it under international law. Attributable conduct, Dario, Chapter 2. Article 6, conduct of IO organs or agents. Article 7, conduct of agents of a state or organs placed at the disposal of an IO. Article 8, acts exceeding authority or violating instructions, ultra vires acts. Article 9, Acts adopted or acknowledged by IO. Key cases. Certain expenses case, ICJ held that acts of incorrect UN organs were still attributable to the UN. Prosecutor v. Dragan Nikolic, SFOR was held responsible for the actions of those who arrested Nikolic, as they had effectively adopted the act. Effective control test, Article 7. IO is responsible if it has effective control over state organs or agents placed at its disposal. Peacekeeping forces issue. Peacekeepers are under UN Security Council mandate. Member states retain some control, complicating attribution. Case study, Bahrami and Saramati cases. Bahrami case. NATO bomb remnants killed a child in Kosovo, French-controlled sector. Father sued France for violating Article 2 of the European Convention on Human Rights, ECHR. Saramati case. Arrested by UNMIK police, later detained by KFOR. Sued France, Germany, and Norway for violating Article 5, Right to Liberty. Grand Chamber findings. UNMIK's actions, attributable to the UN as it was a subsidiary organ under Chapter 7 of the UN Charter. KFOR's actions, despite NATO's operational control, the UN retained ultimate authority, making actions attributable to the UN. Legal approach. Instead of applying the effective control test, the court followed internal UN law, prioritizing Security Council authority over operational matters. Next page. Legal personality and responsibility of international organizations. 4.6.2.1 Legal personality of international organizations. International organizations possess legal personality, enabling them to function independently on the international stage. The ICJ in the reparations case, 1949, affirmed the United Nations, UN, objective legal personality, meaning it operates independently of its member states. Objective legal personality is underpinned by customary international law and the constituent instruments of the organization. Legal personality grants organizations the right to enter into international agreements. Privileges and immunities, for example, immunity from state jurisdiction, inviolability of premises, protection of agents, the right to bring international claims. Immunities and privileges stem from constituent instruments, customary international law, bilateral agreements. 4.6.2.2 Principle of attribution, Dario. Attribution of wrongful conduct to an international organization is governed by Article 4 of the Draft Articles on the Responsibility of International Organizations, Dario. An internationally wrongful act occurs when conduct, action or omission is attributable to an international organization under international law. General Rules of Attribution of Conduct, Dario, Chapter 2. Article 6, Conduct of an agent of the organization. Article 7, Conduct of an agent of a state or another organization placed at its disposal. Article 8, Conduct in excess of authority or contravention of instructions, ultra vires. Article 9, Conduct acknowledged and adopted by the organization. ICJ in certain expenses case, actions by the wrong UN organs were still attributable to the UN. Ikhtian prosecutor v. Dragan Nikolic, SFOR was responsible for Nikolic's arrest due to acknowledgement and adoption of the act. Effective control test. If an agent or organ is placed at the disposal of another entity, responsibility depends on effective control over their conduct. Article 7 of Dario applies the effective control test for determining attribution. Key cases applying the test. Bahrami and Bahrami v. France, Saramati v. France, Germany, and Norway, ECHR, 2007, UNMIK, UN mission in Kosovo, and KFOR, NATO-led force, acted under Chapter 7 of the UN Charter. The European Court of Human Rights, ECHR, ruled that actions were attributable to the UN, not member states. Al Jadavi, Secretary of State for Defence, UK House of Lords, 2007, the UK exercised effective control over its forces in Iraq. The House of Lords rejected the argument that the UN was responsible. The ECHR later endorsed this ruling, confirming the effective control test. Responsibility for peacekeeping forces. Debate on whether UN peacekeepers are agents/organs of the UN. UN Security Council authorizes peacekeeping operations, often under Chapter 7. Member states contribute troops but retain some control. Bahrami case, ECHR ruled KFOR's actions were attributable to the UN. Al Jeddah case, ECHR ruled British forces were under UK control, not UN control. 4.6.2.3 Dual attribution and state responsibility. Dutch cases on Srebrenica genocide, 1995, UN declared Srebrenica a safe area under Chapter 7. Dutch BAT, Dutch battalion under UN command, failed to prevent atrocities. Mothers of Srebrenica v. the Netherlands and UN, District Court of The Hague, 2007, UN held absolute immunity, but Dutch responsibility was still in question. Nieuwenhoek and Mustafaj cases, Netherlands Supreme Court, 2013, applied effective control test under Article 7 of DARIO. Dutch BAT's actions were attributable to the Netherlands due to factual control. Mothers of Srebrenica v. the Netherlands, 2014, distinguished periods of control. Before Srebrenica's fall, UN had full operational control. After Srebrenica's fall, Dutch BAT acted under Dutch control. Confirmed dual attribution, both UN and the Netherlands could be responsible. Conclusion. International organizations have legal personality, enabling them to exercise rights and responsibilities independently. Attribution of wrongful conduct depends on effective control over an agent or organ. Whether the act was acknowledged and adopted. Dual attribution allows responsibility to be shared between organizations and states. Dutch case law on Srebrenica confirmed that states can be held responsible for wrongful acts of their peacekeeping forces. Next page. These sources were referenced by the court in its assessment of legal personality, attribution, and responsibility of international organizations. They cover fundamental principles of the United Nations, UN, legal framework, constitutionalization of international law, and state-international organization relationships. Key themes from referenced sources. 1. UN legal personality and purposes. D'Argent and Susani, 2012, Max Planck Encyclopedia of Public International Law. Explores UN's purposes and principles under the UN Charter, discusses the UN's legal personality and institutional functions in international law. 2. Constitutionalization of international law and global governance. Dunoff and Trachtman, 2009, Ruling the World. Examines the constitutionalization of international law. Analyzes the role of international organizations in global governance. Fassbender, 2009, The UN Charter as Constitution of the International Community. Argues that the UN Charter serves as a global constitution. Discusses how state sovereignty interacts with UN authority. Peters, Elfstein and Klaubers, 2009, The Constitutionalization of International Law. Examines the constitutional structure of international law. Explores how treaties, institutions, and norms function as a global legal order. 3. Evolution of international law and UN responsibility. Friedman, 1964. The Changing Structure of International Law. Analyzes shifts from state-centered international law to institutional international law. Discusses the rise of international organizations' legal autonomy. Kolb, 2010, An Introduction to the Law of the United Nations. Provides a comprehensive introduction to UN law. Addresses issues of responsibility, immunity, and legal personality. Lowe and Warbrick, 1994, The United Nations and the Principles of International Law. Essays on how the UN influences state obligations and international legal principles. Relevance to attribution and responsibility of international organizations. These works support the effective control test under DARIO Article 7. They examine UN accountability in peacekeeping and governance. They highlight the constitutional and governance structure that informs UN decision-making and legal obligations. Next. Correction needed. Page. Here's a corrected and refined summary of the referenced sources. Key themes from referenced sources. 1. UN legal personality and principles. D'Argent and Susani, 2012, Max Planck Encyclopedia of Public International Law. Examines the UN's legal personality, purposes, and principles under the UN Charter. Discusses the extent of UN authority in international law. 2. Constitutionalization of international law and global governance. Dunoff and Trachtman, 2009, Ruling the World? Constitutionalism, International Law, and Global Governance. Explores the constitutionalization of international law and the role of international organizations in global governance. Analyzes how states and organizations interact within the framework of international constitutionalism. Fassbender, 2009, The UN Charter as Constitution of the International Community. Argues that the UN Charter functions as a constitutional document for the international community. Examines how state sovereignty is balanced with UN authority. Peters, Elfstein and Klaubers, 2009, The Constitutionalization of International Law. Discusses the structural evolution of international law toward a constitutional framework. Examines how international treaties, norms, and institutions contribute to a global legal order. 3. Evolution of international law and UN responsibility. Friedman, 1964, The Changing Structure of International Law. Analyzes the shift from state-centric international law to a system where international organizations play a key role. Discusses the emergence of institutional international law and the UN's evolving legal status. Kolb, 2010, An Introduction to the Law of the United Nations. Provides an overview of UN law, including its legal personality and functions. Examines issues of responsibility, immunity, and the UN's role in international disputes. Lowe and Warbrick, 1994. The United Nations and the Principles of International Law. Collection of essays analyzing UN influence on international law. Explores the legal principles guiding UN actions and state obligations. Relevance to attribution and responsibility of international organizations. These sources support the effective control test under Article 7 of the DARIO, 2011 ILC Draft Articles on Responsibility of International Organizations. They analyze UN accountability, responsibility, and the interaction between states and international organizations. They provide context for dual attribution, where responsibility may be shared between a state and an international organization based on control and authority. This version provides a clearer and more structured explanation of the relevance of the sources. Let me know if you need further refinements. Next page. Assessment of state responsibility in the Mothers of Srebrenica case. 1. Effective control and attribution of Dutchbat's conduct. After the fall of Srebrenica, high-level discussions between the UN and government representatives led to an agreement that Dutchbat would shift focus to humanitarian tasks and its own evacuation. The Netherlands assumed effective control over Dutchbat's actions during this transition period, making its conduct attributable to the state. The effective control test for attributability may not have been necessary since Dutchbat functioned as a state organ during the transition. If Dutchbat acted solely as a state organ, responsibility would arise from Article 4 of the DAS rather than Article 7 of the DARIO, contradicting the court's reliance on DARIO provisions. The Nuhanovic and Mustafic cases referenced Article 4 and Article 8 of the DAS, but the court ultimately focused on Articles 6, 7, and 48 of the DARIO due to Dutchbat's role in a UN peacekeeping mission. Before Srebrenica's fall, Dutchbat was under UN command. Afterward, the Netherlands and Dutchbat exercised effective control over evacuation efforts. The court questioned whether Dutchbat was still at the UN's disposal under Article 7 of the DARIO or if state control superseded UN authority. 2. Wrongfulness and human rights violations. The district court found that wrongfulness stemmed from violations of the right to life under Article 6 ICPR, 1966, and Article 2 ECHR, 1950. Failure to prevent genocide, an obligation under international law. The extraterritorial application of human rights treaties remains debated. The court applied the Al-Sqaini judgment, ICTHR, ruling that after Srebrenica's fall, the Netherlands, through Dutchbat, exercised effective control over the compound. Dutchbat had exclusive authority within the compound, with no UN intervention. The Bosnian Serb army respected the compound, reinforcing state responsibility. The court relied on Nuhanovic and Mustafic, holding that the Netherlands exercised legal power, rechtsmacht, under Article 1 ECHR and Article 2 ICPR, creating a duty to secure human rights for refugees within the compound. 3. Causality and state responsibility. Causation requirement. Dutchbat's conduct must be linked to the deaths of refugees. The district court ruled that, had Dutchbat not participated in deportations, the victims' lives would likely have been saved. Refugees inside the compound would have been evacuated alongside Dutchbat. The Bosnian Serb army had not used force against the compound or Dutchbat. 4. Key legal instruments cited. Articles 4 and 8 of the DASR, 2001, Attribution of Conduct to the State. Articles 6, 7, and 48 of the DARIO, 2011, Responsibility of International Organizations. Article 6 ICPR, 1966, and Article 2 ECHR, 1950, Right to Life Obligations. Article 1 ECHR and Article 2 ICPR, Jurisdiction and State Responsibility for Human Rights. Suggested further reading. S. Chesterman, T. M. Frank and D. M. Malone, Law and Practice of the United Nations, 2008, Ida Wett, The International Constitutional Order, 2006, Pete Argent and N. Susani, United Nations, Purposes and Principles, 2012, J. Dunoff and J. P. Trachtman, eds., Ruling the World? Constitutionalism, International Law and Global Governance, 2009, B. Fassbender, The UN Charter as Constitution of the International Community, 2009, W. Friedman, The Changing Structure of International Law, 1964, R. Kolb, An Introduction to the Law of the United Nations, 2010, V. Low and C. Warbrick, eds., The United Nations and the Principles of International Law, 1994, A. Peters, G. Elfstein and J. Klobbers, The Constitutionalization of International Law, 2009. This summary refines the discussion on attribution, wrongfulness, and causality in the Mothers of Srebrenica case while maintaining the legal focus. Let me know if you need further adjustments. Next page. Maintaining international peace and security, the enforcement of international law. Henny Stradham and Lawrence Juma. _ 5.1 Introduction. States are both the creators and enforcers of international law, acting as sovereign equals in the international legal order. International law derives from treaties and customary international law, with no central enforcement authority. Disputes and breaches of international law must be settled or remedied to prevent anarchy. The UN Charter prioritizes peaceful measures over force, restricting armed enforcement to strict conditions. Interpretational disputes on Charter provisions make the use of force a controversial issue, especially post-Cold War. Enforcement mechanisms follow a conventional order. Peaceful settlement of disputes, diplomatic and judicial means. Non-forcible measures, countermeasures and sanctions. Use of force, under limited conditions. _ 5.2 Peaceful settlement of disputes. 5.2.1 Negotiation. Direct discussions between disputing states to reach a resolution. Most common and flexible method but relies on good faith from both parties. 5.2.2 Mediation. A third party facilitates negotiation and proposes solutions. The mediator has no binding power over the parties. 5.2.3 Conciliation. A third party conducts an investigation and proposes a non-binding recommendation. 5.2.4 Inquiry. A fact-finding method used to clarify disputed issues between states. Often used in disputes where factual disagreements prevent negotiation. 5.2.5 Arbitration. Disputing parties submit their case to an arbitral tribunal for a binding decision. Considered a quasi-judicial method with more flexibility than court adjudication. 5.2.6 Judicial settlement by the International Court of Justice, ICJ. 5.2.6.1 The UN Charter and the ICJ. The ICJ is the principal judicial organ of the UN, established under Chapter 14 of the UN Charter, resolves state disputes based on international law. 5.2.6.2 Composition of the ICJ and election of judges. 15 judges, elected by the UN General Assembly and Security Council for 9-year terms. 5.2.6.3 Competence of the ICJ. Jurisdiction over legal disputes between states that accept its jurisdiction. Provides advisory opinions on legal questions at the request of UN organs. 5.2.6.4 Preliminary requirements. 5.2.6.4.1 Access. Only states can be parties in contentious cases before the ICJ. 5.2.6.4.2 Admissibility. Cases must meet procedural and substantive conditions before being heard. 5.2.6.4.3 Jurisdiction. 5.2.6.4.3.1 Consent based on Article 36(1). Jurisdiction is based on a special agreement or treaty clause accepting ICJ authority. 5.2.6.4.3.2 Consent based on Article 36(2). Compulsory jurisdiction applies if both states recognize it through declarations. 5.2.6.5 Non-appearance. A party may refuse to appear, but the ICJ can still proceed with the case. 5.2.6.6 Hearing and judgment. Oral hearings followed by deliberation and judgment, which is binding on the parties. _ 5.3 Non-forcible measures. 5.3.1 Countermeasures. Unilateral measures taken by a state in response to another state's wrongful act must be proportional and aimed at inducing compliance with international law. 5.3.2 Sanctions. Coercive measures imposed to ensure compliance. 5.3.2.1 The case for targeted sanctions and better enforcement. Targeted sanctions, for example, asset freezes, travel bans, aim to minimize humanitarian impact. 5.3.2.2 Counterterrorism measures and human rights considerations. Post 9/11 counterterrorism sanctions have raised concerns over due process and human rights. 5.3.2.3 Unilateral and regional sanctions. Imposed by individual states or regional bodies, for example, EU, AU, without UN authorization. _ 5.4 Use of force. 5.4.1 The collective security option. UN Security Council, UNSC, authorizes force under Chapter 7 of the UN Charter, used in cases of threats to peace, breaches of peace, or acts of aggression. 5.4.2 The role of regional arrangements and agencies. Regional organizations, for example, NATO, AU, may take enforcement actions, subject to UN approval. 5.4.3 Self-defense. Article 51 of the UN Charter allows self-defense against armed attacks, includes individual and collective self-defense measures. 5.4.4 Sources of controversy. 5.4.4.1 Rescue of own nationals. Justification for military intervention to protect citizens abroad remains debated. 5.4.4.2 Humanitarian intervention. Unilateral humanitarian intervention is controversial due to the UN Charter's prohibition on force. 5.4.4.2.1 Charter prohibition may be unworkable and unacceptable. Critics argue that strict adherence to Article 2.4 of the UN Charter may prevent necessary interventions. 5.4.4.2.2 Do instances of unilateral humanitarian intervention constitute state practice? The Kosovo intervention, 1999, is often cited as state practice, but its legality remains disputed. 5.4.4.3 The responsibility to protect, R2P, emerging doctrine asserting a state's duty to prevent atrocities and allowing international intervention if it fails. 5.4.4.4 The war on terror and the use of force against non-state actors. Post 9/11 actions, for example, U.S. intervention in Afghanistan, expanded interpretations of self-defense against terror groups. 5.4.4.5 Cyber warfare. Debate over whether cyber attacks amount to armed attacks justifying self-defense under Article 51. 5.4.4.6 The blurring of peacekeeping and enforcement action. Modern peacekeeping missions increasingly involve combat roles, raising legal concerns over the use of force. _ This summary captures the key points from the chapter on international law enforcement. Let me know if you need further refinements. Next page. 5.2 Peaceful settlement of disputes. Principle of peaceful settlement. Since World War I, international law has prioritized peaceful dispute resolution over the use of force. UN Charter Article 2.3 obligates member states to settle disputes peacefully to maintain international peace, security, and justice. UN Charter Article 2.4 prohibits the use of force, reinforcing the importance of alternative dispute resolution to prevent war. UN Charter Article 33 requires states to first seek peaceful solutions to disputes likely to endanger peace and security. 1982 Manila Declaration emphasizes settling all disputes peacefully and avoiding military action. Reaffirms principles from the 1970 Friendly Relations Resolution. State obligations. States must act in good faith and cooperate in resolving disputes. The choice of dispute resolution method is flexible and discretionary. The UN Security Council can direct states to use specific methods. Treaty obligations may prescribe a specific dispute resolution mechanism. Definition of a dispute. Not every disagreement qualifies as a dispute. Mavra Mattis Palestine Concessions Case, PCIJ. A dispute is a conflict of legal views or interests between two parties. Disputes must be resolved in line with UN Charter principles. _ 5.2.1 Negotiation. Most common and frequently the first method used. Advantages. Parties retain full control over the process. Flexible, with no rigid procedural rules. Can be used alongside other dispute resolution methods. Legal requirements. ICJ in Georgia v. Russia, 2011. Negotiations differ from mere protests or disputes. Must be a genuine attempt at resolving the dispute. Good faith obligation. Parties must negotiate with the intent to reach an agreement. However, there is no obligation to achieve a settlement. Railway Traffic Advisory Opinion. Negotiation and other methods. Negotiations do not prevent ICJ jurisdiction. A GNC Continental Shelf case can occur alongside judicial processes. Israel Wald case. _ 5.2.2 Mediation. Used when direct negotiations fail due to hostile relations between parties. Third-party mediator facilitates discussions and proposes solutions. Success depends on mediator's ability to craft a solution acceptable to both parties. Willingness of parties to accept mediation efforts. Mediation versus good offices. Mediation. Third party takes an active role in resolving the dispute. Good offices. A neutral party facilitates communication between disputing states but does not propose solutions. Examples of mediation. 1982 Falklands War. Good offices of the UN Secretary-General. Mediation by the United States. 1899 Convention for the Pacific Settlement of Disputes. Article 2. Before resorting to war, states should use good offices or mediation. Article 3. Neutral states can offer mediation voluntarily. Article 4. Mediators cannot impose solutions, only facilitate reconciliation. _ This summary provides a detailed breakdown of peaceful dispute settlement methods, emphasizing negotiation and mediation with key case law and legal principles. Let me know if you need further refinements. Next. Page 5.2.3 Conciliation. Definition and function. Involves an institution, a commission, assisting parties in resolving disputes. More structured than mediation, involving fact-finding and settlement proposals. Regulations on the procedure of international conciliation. Defines conciliation as a method where a commission examines disputes impartially and suggests a resolution. A conciliation commission can be a multi-member institution or a single individual appointed by the parties. Example, East African Community, 1977, breakup. Dr. Victor Umbrecht, Swiss national, was appointed to assist Kenya, Uganda, and Tanzania in asset distribution. Legal basis. Institutionalized in bilateral treaties, for example, 1920 Sweden-Chile Treaty. League of Nations, 1922, and General Act of Arbitration, 1928, promoted conciliation. Over 200 conciliation agreements signed by 1940. Key features. 1. Defined role. Example, 1925 Italy-Switzerland Treaty, where the Commission had to impartially examine facts and propose a settlement. 2. No obligation to apply legal rules. Iceland-Norway Conciliation Commission, Greenland and Jan Mayen case. Stated it was not a court and aimed only to make recommendations for an equitable solution. 3. Non-binding nature. Similar to mediation, as parties are not legally bound by the Commission's recommendations. _ 5.2.4 Inquiry. Definition and purpose. Used when disputes involve factual disagreements or require clarification of violations of treaties or international commitments. Fact-finding process that helps determine the truth behind disputes. Legal basis. First codified in the 1899 and 1907 Hague Conventions. Article 9 of the 1907 Convention. Inquiry should be conducted when disputes involve points of fact, not national honor or essential interests. Article 34 of the UN Charter. UN Security Council can investigate disputes likely to endanger international peace and security. Usage in international law. Western nations adopted inquiry and arbitration procedures, for example, Joint High Commission of Inquiry and treaties by the US, France, and Britain. Included in multilateral and bilateral treaties. UN and regional bodies frequently use inquiry. Types of inquiry processes. 1. Commission of Inquiry. Traces back to the Hague Conventions, 1899 and 1907. Exploratory in nature, used to uncover facts rather than applying legal rules. 2. Fact-finding missions. Widely used by the UN and international organizations. UN General Assembly Resolution. Stated that impartial fact-finding contributes to peaceful dispute settlement. Examples of inquiry usage. Geneva Conventions, 1949. Allow inquiry into alleged violations of humanitarian law. UN fact-finding missions. 2009, investigated Israel-Hamas conflict in Palestine. 2005, UN Security Council investigated human rights violations in Darfur. Findings led to criminal charges at the ICC. 2008, ILO Commission of Inquiry investigated Zimbabwe's labor rights violations. 2011, 2 international commissions investigated Libya, violations of international law. Syria, human rights violations since March 2011. _ This summary covers conciliation and inquiry as methods of peaceful dispute resolution, emphasizing key legal instruments, case studies, and their roles in international law. Let me know if you need any further refinements. Next. Page 5.2.3 Conciliation. Definition and purpose. A commission assists parties in resolving disputes by investigating causes, facilitating communication, and proposing solutions. More formalized than mediation. Defined in Article 1 of the Regulations on the Procedure of International Conciliation as impartial examination and settlement facilitation. Forms of conciliation. Institutional conciliation. A commission with multiple members or a single appointed individual. State-appointed conciliation. Example, Dr. Victor Umbricht assisted Kenya, Uganda, and Tanzania in asset distribution after the East African Community breakup, 1977. Historical and treaty-based conciliation. First treaty institutionalizing conciliation, 1920 agreement between Sweden and Chile. Included in Covenant of the League of Nations, 1922, and General Act of Arbitration, 1928. By 1940, over 200 conciliation agreements were concluded. Treaties specify the role of commissions, for example, 1925 Italy-Switzerland Treaty, impartial fact examination and settlement proposals. Characteristics of conciliation. Not obligated to apply legal rules but can. Non-binding, similar to mediation, recommendations are susceptible of acceptance by parties. Example, Conciliation Commission on the Continental Shelf, Iceland and Norway, clarified that its role was advisory, not judicial. _ 5.2.4 Inquiry. Definition and purpose. Investigates disputed facts to facilitate resolution. Used to determine treaty violations and suggest remedies. Based on the principle that exposing facts may lead to settlement. Legal basis and evolution. First codified in the 1899 and 1907 Hague Conventions. Article 9 of the 1907 Hague Convention. Inquiry commissions assist diplomacy by clarifying facts. Adopted in various treaties, for example, U.S.-France-Britain Joint High Commission of Inquiry. Role in international dispute resolution. Included in UN Charter, Article 34 Security Council investigates disputes endangering peace. Used by international organizations for state disputes. Internal conflicts, for example, rebel groups versus governments, investigating organizations themselves. Forms of inquiry. Commission of Inquiry, originated in the Hague Conventions, mainly fact-finding. Fact-finding missions, common in UN practice, for example, UNGA Resolution on Fact-Finding. Key examples. Geneva Conventions, 1949. Provide for inquiries into violations. 2009 UN Human Rights Council Fact-Finding Mission, Israel-Palestine Conflict. 2005 UN Security Council Inquiry on Darfur, led to ICC prosecutions. 2008 ILO Commission of Inquiry on Zimbabwe, investigated labor rights violations. 2011 Libya and Syria International Commissions of Inquiry, investigated human rights violations. _ 5.2.5 Arbitration. Definition and characteristics. Legal dispute resolution method where arbitral awards are binding. Common in boundary and territorial disputes. Historical development. Earliest treaty, Jay Treaty, 1794. US-UK resolved boundary issues via arbitration. Alabama Claims, 1871, US-UK, tribunal settled neutrality violations during the U.S. Civil War. Institutionalization of arbitration. Hague Conventions, 1899 and 1907, recognized arbitration as an effective legal solution. Permanent Court of Arbitration, PCA, established, Hague, 1899. For arbitration accessibility. Compromise, agreement by parties outlining dispute details, arbitrator appointments, and procedural rules. Procedure. Written pleadings and oral arguments under arbitrator's control. Public hearings if agreed upon by arbitrators and parties. Competition with ICJ. Since 1921, PCA has competed with the PSIJ, now ICJ, for dispute resolution. PCA adapted by allowing arbitration for disputes involving non-state entities, 1962, 1993, 2012 reforms. _ 5.2.6 Judicial settlement by the International Court of Justice, ICJ, distinction from arbitration. ICJ, permanent judicial body with permanent judges. Arbitration, ad hoc tribunals with party-appointed arbitrators. 5.2.6.1 The UN Charter and the ICJ, legal basis. Chapter 14 of UN Charter, establishes the ICJ as the principal judicial organ. Article 92, ICJ functions under its statute, annexed to the Charter. UN members automatically part of ICJ statute, non-members require UNGA approval. Jurisdiction issues. Case of Yugoslavia, 1993 to 2000. Dispute over successor state status for UN membership. ICJ declined jurisdiction in some cases due to lack of UN membership. Resolved when Serbia-Montenegro was admitted to the UN, 2000. Binding nature of ICJ judgments. Article 59 of ICJ statute. Decisions are binding only between parties and not precedent-setting. Article 94 of UN Charter. UN members must comply with ICJ rulings. Security Council can enforce judgments through recommendations or measures. Next. Page 5.2.5 Arbitration. Definition and nature. Arbitration is a legal method of dispute resolution between states, with binding awards. Common in boundary and territorial disputes. Historical development. Jay Treaty, 1794, U.S. and Great Britain, first known treaty providing for arbitration. Alabama Claims, 1871, U.S. v. Great Britain, diplomatic dispute over neutrality duties resolved through arbitration. Institutionalization of arbitration. Hague Conventions, 1899, 1907, established arbitration as an effective dispute resolution mechanism. Permanent Court of Arbitration, PCA, created for continuous arbitration availability. Compromise, a document parties sign to determine dispute scope, arbitrators, and procedures. Arbitration procedure includes written pleadings, oral discussions, and public hearings, if agreed. PCA decisions have shaped international case law. Competition with judicial settlement. PCA faced competition from the Permanent Court of International Justice, PCIJ, 1921, and later the International Court of Justice, ICJ. PCA adapted by introducing rules for disputes involving non-state entities, 1962, 1993, 2012. _ 5.2.6 Judicial settlement by the ICJ, distinction from arbitration. An international court, ICJ, has permanent judges and continuous adjudicatory functions. CIJ, 1921, established under the League of Nations. ICJ, 1946, replaced CIJ under the UN Charter. 5.2.6.1 The UN Charter and the ICJ, legal framework. Article 92, UN Charter. ICJ is the principal judicial organ of the UN. ICJ statute is annexed to the UN Charter. Membership and jurisdiction. All UN member states are automatically members of the ICJ statute. Non-UN members may join per General Assembly and Security Council approval. Federal Republic of Yugoslavia cases, 1993 and beyond, disputed UN membership impacted ICJ jurisdiction. Binding nature of ICJ judgments. Article 94(1), UN Charter. UN members must comply with ICJ judgments. Article 59, ICJ statute. Judgments only bind the parties involved. Enforcement of ICJ judgments. Article 94(2), UN Charter. If a party fails to comply, the UN Security Council can intervene. Security Council decisions on enforcement may be subject to veto. Article 27, UN Charter. Procedural versus substantive Security Council actions. Article 27(3), UN Charter. A party to a dispute must abstain from voting in Chapter 6 cases. Debate exists on whether Article 94(2) action falls within Chapter 6 or provides additional competence to the Council. Alternative dispute settlement. Article 36, UN Charter. Security Council can recommend ICJ referral. Article 95, UN Charter. States may use other tribunals for dispute resolution. _ 5.2.6.2 Composition of the ICJ and election of judges. Structure. 15 judges, no two from the same state. Based in The Hague. Eligibility criteria. Judges must be independent, of high moral character, and qualified for highest judicial office. Nomination and election. National groups and Permanent Court of Arbitration, PCA, nominate candidates. Judges elected by UN General Assembly and Security Council, requiring an absolute majority in both. Challenges in election process. National groups' selection process lacks transparency. Debate exists over whether direct government nominations would be more effective. Judicial independence. Judges serve in personal capacity, not as state representatives. Prohibited from political or professional activities. Tenure and rotation. Judges serve for 9 years, with elections staggered every 3 years. First expiration cycle was determined by UN Secretary-General DRA. Ad hoc judges. If a state lacks a judge of its nationality in a case, it may appoint an ad hoc judge. Next page. 5.2.6.2 Composition of the ICJ and election of judges. Composition. The ICJ is seated in The Hague and comprises 15 judges. No two judges can be nationals of the same state. Judges must be independent, of high moral character, and meet the qualifications for appointment to the highest judicial office in their respective countries. Nomination and election. Candidates are nominated by national groups from the list of potential arbitrators in the PCA. Permanent Court of Arbitration. National groups have up to 4 persons per PCA member state, but their selection methods are not clearly defined in ICJ statutes. Article 6 of the ICJ statute suggests consultation with courts, law faculties, and academies. Debate over nomination system. Supporters argue it reduces direct political influence. Opponents prefer direct government nominations for efficiency. Election process. Judges are elected by both the General Assembly and the Security Council, acting independently. Candidates must secure an absolute majority in both bodies. Judges serve in their personal capacity, not as state representatives. Judges take a solemn declaration to act impartially and conscientiously. Restrictions on judges. Judges cannot hold political or administrative positions. Judges cannot act as agents, counsel, or advocates in ICJ cases. Judges cannot rule on cases in which they previously participated. Term and continuity. 9-year term, staggered elections every 3 years, 5 judges at a time. First expiry of terms was determined by lot, drawn by the UN Secretary-General. Ad hoc judges. If a case does not include a judge from a disputing party's nationality, that party may appoint an ad hoc judge. Underscore. 5.2.6.3 Competence of the ICJ. 1. Contentious cases, disputes between states. The ICJ resolves legal disputes between states where a disagreement exists on law or fact. Southwest Africa cases defined a legal dispute as a disagreement on a point of law or fact, a conflict of legal views or interests. The ICJ determines whether a legal dispute exists. Mere assertion is insufficient. ICJ decisions must be based on international law. 2. Advisory opinions. ICJ provides advisory opinions on legal questions upon request. These opinions are non-binding but carry significant weight. Certain expenses case. ICJ ruled that a request remains legal even if politically significant. Request requirements. Must be submitted in writing with clear legal questions and supporting documents. Who may request? The General Assembly and Security Council, on any legal question. Other UN organs and specialized agencies, only with General Assembly approval. Effective advisory opinions. While not binding, an ICJ opinion strengthens legal positions and influences state behavior. 3. Provisional measures. ICJ can issue interim measures to prevent harm or safeguard rights pending a final ruling. Article 41 of the ICJ statute grants this power, though early interpretations were unclear. Law Grant Case, 2001, clarified that provisional measures are binding. Conditions for provisional measures. ICJ must have prima facie jurisdiction. The applicant must show some likelihood of success on merits. What if ICJ later rules it lacks jurisdiction? Unclear. The comparison with ITLO's, International Tribunal for the Law of the Sea, suggests interim measures are binding even if final jurisdiction is denied. Comparison with ITLO's provisional measures. Article 292 UNCLOS ensures prompt release of detained vessels, binding on states. Article 290 UNCLOS grants provisional measures pending final judgment. MV Saiga case, ITLOS. Differentiated between interim measures under Article 292, independent of main case, and Article 290, linked to case merits. Next. Article 290 of UNCLOS is, therefore, the equivalent of Article 41 of the Statute of the ICJ. In the MV Saiga case, the jurisdiction of the ITLOS was also contested and it did not prevent it from indicating provisional measures, the release of the vessel, with binding effect. Page. Comparison, ICJ and ITLOS provisional measures. Article 41 of the ICJ statute and Article 290 of UNCLOS are equivalent in their function of granting provisional measures. MV Saiga case, ITLOS. ITLOS jurisdiction was contested, but it still ordered provisional measures, release of the vessel. The decision had binding effect, reinforcing that provisional measures remain enforceable even if jurisdiction is later challenged. This aligns with the Lagrange case, ICJ, 2001, which confirmed that ICJ provisional measures are binding. Next. Page 5.2.6.4 Preliminary Requirements. Overview. Before a case can be brought before the ICJ, certain technical requirements must be met, including access, admissibility, and jurisdiction. Underscore 5.2.6.4.1 Access. Only states can access the ICJ. Article 34(1) of the ICJ statute. Non-state entities, individuals, NGOs, intergovernmental organizations, cannot bring cases. The UN itself cannot bring a case but may request advisory opinions. Categories of states with access. 1. States parties to the ICJ statute, includes all UN members. 2. Other states under Security Council conditions, provided they deposit a declaration accepting the ICJ's jurisdiction. They commit to complying with ICJ decisions and obligations under Article 94 of the UN Charter. Types of declarations accepting jurisdiction. Particular, accepts jurisdiction only for specific disputes. General, accepts jurisdiction for all disputes, past and future. Right to intervene in proceedings. 1. Legal interest in a dispute. Article 62 of the ICJ statute. A non-party state may intervene if it demonstrates a legal interest that could be affected. ICJ in the territorial and maritime dispute, Nicaragua v. Colombia. A legal interest must be a real and concrete claim, not just political, economic, or strategic concerns. 2. Construction of a convention's provisions. Article 63 of the ICJ statute. A state that is not a party to the case but party to the convention at issue may intervene. If it intervenes, the ICJ's interpretation of the convention is binding on it. Article 82 of the ICJ Rules of Procedure. The intervening state must specify the provisions of the convention at issue, its own interpretation of those provisions. Underscore 5.2.6.4.2 Admissibility. Admissibility relates to whether the case meets procedural requirements. Common admissibility issues. 1. Diplomatic protection cases, state bringing a case on behalf of an individual. The injured person must be a national of the applicant state from injury date to claim submission. The injury must result from the wrongful conduct of the respondent state. Domestic remedies in the respondent state must have been exhausted. Exceptions, if remedies are ineffective, predetermined, or lack due process. 2. ICJ and Diallo case. The applicant must prove exhaustion of local remedies or establish exceptional circumstances. The respondent state must prove that effective remedies were available but not exhausted. Legal interest requirement. A case may be deemed inadmissible if the applicant lacks a legal interest. The claim must be a real and concrete legal issue that could be affected by the ICJ's ruling. Northern Cameroon's case, separate opinions. Judge Fitzmaurice. The existence of an actual legal dispute is an admissibility issue and must be determined before jurisdiction. Judge Morelli, the ICJ can only rule on the merits if a real dispute exists. Next. Page 5.2.6.4.3 Jurisdiction. Overview. Jurisdictional objections must be resolved first before the ICJ can rule on the merits. If a case is inadmissible or the ICJ lacks jurisdiction, no decision on the merits will be made. Jurisdiction is based on state consent, which can take various forms, including conditional or reserved consent. Underscore 5.2.6.4.3.1 Consent based on Article 36(1) of the ICJ statute. Article 36(1), ICJ jurisdiction covers 1. Cases referred by parties by mutual consent, compromise agreement. 2. Matters provided for in the UN Charter, treaties, or conventions. Compromise, special agreement. Specifies the dispute's scope, applicable law and procedure, and relief sought. Confers jurisdiction on the ICJ through mutual consent. Jurisdiction via treaties and conventions. States may consent to ICJ jurisdiction in advance through compromissory clauses. Example, Article 9 of the Genocide Convention, 1948, makes ICJ jurisdiction compulsory for disputes related to the convention. Article 37 of the ICJ statute, cases referred to League of Nations tribunals or the Permanent Court of International Justice now go to the ICJ. Relevance of Article 36(3) of the UN Charter. Security Council may recommend legal disputes be referred to the ICJ. such recommendations are not binding, states must still give mutual consent. Corfu Channel case. UK argued that Article 36(3) of the UN Charter allowed the Security Council to compel ICJ jurisdiction. The ICJ rejected this, ruling that Security Council recommendations do not create compulsory jurisdiction. Forum prorogatum and Article 38(5) of the ICJ rules. Jurisdiction may be implied from state conduct. Forum prorogatum. Article 38(5) of the ICJ rules. When an applicant anticipates consent from the respondent, the case is filed but not entered into the ICJ's general list. No action is taken until the respondent consents. Djibouti case. The ICJ confirmed that forum prorogatum allows a state to file a case and invite another state to consent without prejudicing legal fairness. The respondent's acceptance must be unequivocal and voluntary. Corfu Channel case, UK v. Albania. UK unilaterally submitted the case following a Security Council recommendation. Albania protested but also stated it was prepared to appear before the court. The ICJ interpreted this as voluntary and indisputable acceptance of jurisdiction. Key principle. A state's mere participation in proceedings does not automatically imply acceptance of ICJ jurisdiction. Next page. 5.2.6.4.3.2 Consent based on Article 36(2) of the ICJ statute. Overview. Article 36(2) allows states to unilaterally accept the ICJ's compulsory jurisdiction over disputes concerning 1. Interpretation of treaties. 2. Questions of international law. 3. Existence of facts constituting breaches of international obligations. 4. Nature or extent of reparations for such breaches. Known as the optional clause, this provision allows states to establish reciprocal jurisdictional links with other states that have also accepted it. Key features of Article 36(2) declarations. Unilateral but reciprocal. Jurisdiction applies only between states that have accepted the same obligation. As of 2019, only 73 out of 193 UN member states had such declarations. Among permanent UN Security Council members, only the United Kingdom is currently bound by Article 36(2). Modifications and reservations. Article 36(3). Declarations can be conditional, time-limited, or reciprocal. States may exclude domestic jurisdiction matters from ICJ authority. Examples. Botswana and South Africa excluded domestic matters in past declarations. U.S. Connolly Reservation, 1946, reserved the right to self-determine which disputes fell under domestic jurisdiction. ICJ's authority under Article 36(6). The ICJ determines its own jurisdiction in cases of dispute. The shrinking scope of domestic jurisdiction in international law has weakened state-based exceptions. Case law on Article 36(2) reservations. Nicaragua case, jurisdiction and admissibility. The ICJ affirmed that states can limit their declarations with conditions or reservations. Norwegian loans case, France v. Norway. France's reservation, similar to the U.S. Connolly Reservation, allowed self-determination of domestic jurisdiction. Norway invoked reciprocity, meaning France's own reservation blocked its claim against Norway. Some judges ruled that such self-interpretation reservations were invalid under the ICJ statute. Interhandle case, Switzerland v. U.S. The U.S. reservation was challenged as incompatible with the ICJ statute. Some judges held that such reservations invalidated the state's acceptance of ICJ jurisdiction. Procedural aspects of Article 36(2) declarations. Depositing requirement. Declarations and amendments must be deposited with the UN Secretary-General. Jurisdiction is effective from the moment of deposit. From that date, the state can file cases against other states and be targeted in applications. Next page. 5.2.6.5 Non-appearance. Consequences of non-appearance. If a party fails to appear or defend its case, the other party may request the court to decide in its favor. Before granting such a request, the ICJ must confirm 1. Jurisdiction, Articles 36 and 37. 2. Claim is well-founded in fact and law. The absent party remains bound by the court's decision. No automatic ruling for the appearing party. The court must examine jurisdiction, admissibility, and merits. Court's obligation to satisfy itself. Article 53(2) of the ICJ statute mentions only jurisdiction, but the court must also verify admissibility and excess. Nicaragua case standard. The ICJ must ensure the same degree of certainty as in contested cases. The court is not fully reliant on party arguments. Juria novit curia. The court knows the law. The court can examine facts beyond party submissions, but an absent party forfeits the chance to counter allegations. The ICJ cannot independently investigate all factual gaps caused by the absent party. Underscore 5.2.6.6 Hearing and Judgment. Two phases of proceedings. 1. Written phase. Involves memorials, counter-memorials, replies, and documentary evidence conducted privately. 2. Oral phase. Public hearings, unless confidentiality is required. Judges deliberate in private, deliberations remain secret. The judgment is read in open court and must include reasons for the decision. Underscore. Decision-making process. Decisions are made by majority vote of the judges. If there is a tie, the president of the ICJ casts the deciding vote. For example, nuclear weapons case. Judges may submit dissenting or separate opinions. Underscore. Finality and revision of judgments. ICJ judgments are final and not subject to appeal. Revision of judgment is possible if a decisive new fact is discovered. The fact was unknown to both the court and the requesting party during the original case. The revision application is made within 6 months of discovering the fact. The court may require compliance with the original judgment before allowing revision proceedings. Next. Page 5.3 Non-forcible measures. Post-UN Charter, 1945. Individual states' ability to enforce international law unilaterally is limited. Article 2.4 of the UN Charter prohibits the use of force. Enforcement is now collective, under the UN framework. Survival of some unilateral actions. Injured states may take non-forcible countermeasures against breaching states. International/regional organizations may impose sanctions collectively. Underscore 5.3.1 Countermeasures. Definition and legality. Air Services Agreement case. Countermeasures allow an injured state to affirm its rights against a breaching state. Must comply with general international law on armed force. Conditions for lawful countermeasures. 1. Must not involve force, except in self-defense. 2. Must be proportional to the injury and terminated when the breach is rectified. 3. Can only be taken by the injured state to induce compliance. 4. Must be temporary and allow for resumption of obligations. 5. Must not violate certain obligations. Article 51 of ILC draft articles, including prohibition of force, UN Charter, human rights protections, humanitarian law, for example, reprisals, peremptory norms, jus cogens. 6. Must comply with dispute settlement agreements between states. Underscore. Countermeasures and dispute settlement. Air Services Agreement case. Before a dispute enters formal settlement, countermeasures are allowed. Once the dispute resolution process begins, countermeasures must cease. Article 52(3)(b) of ILC draft articles confirms this rule. If the responsible state fails to comply with the settlement, countermeasures may resume. Underscore. Procedural requirements for countermeasures. 1. The injured state must request compliance from the responsible state. 2. If ignored or inadequate, the injured state must give notice before initiating countermeasures. 3. Urgent countermeasures may be taken if necessary to preserve rights. Underscore. Role of non-injured states, Articles 48 and 54 of ILC draft articles. Article 48. Non-injured states can invoke responsibility for breaches affecting a group of states or the international community. Erga omnes obligations allows claims for cessation of wrongful acts, non-repetition assurances, reparation in the interest of affected parties. Article 54. Non-injured states can take lawful measures to ensure compliance. Unclear if they can take countermeasures similar to those in Articles 49 and 52, which are limited to injured states. Underscore. Unresolved issues and countermeasures by non-injured states. ICJ case law. Unclear on enforcement of erga omnes obligations by non-injured states. ICJ decisions have not provided a definitive stance. ILC analysis of state practice. Some states have imposed sanctions on breach of erga omnes obligations. However, ILC finds state practice limited, undeveloped, and inconsistent. Next. Page 5.3 Non-forcible measures, continued. Underscore. 5.3.1 Countermeasures by non-injured states. Uncertainty in international law. No clear recognition of non-injured states' right to take countermeasures under Article 48 of the ILC draft articles. Some states have rejected the restrictive view and taken countermeasures without claiming direct injury, erga omnes obligations. 2005 Krakow Resolution, Institute of International Law, Article 5, if a grave breach of an erga omnes obligation occurs, all affected states may take non-forcible countermeasures. Must follow conditions similar to those applicable to injured states. _ 5.3.2 Sanctions. Definition and legal basis. Sanctions equals economic and other non-forcible measures to stop a wrongful act. UN Charter, Article 41. Security Council can impose measures not involving force to ensure compliance. Includes economic embargoes, cutting off communications, rail, sea, air, postal, radio, telegraphic. Diplomatic isolation. Measures are binding on UN members under Chapter 7. UN Security Council's role. Must determine a threat to peace, Article 39, before imposing sanctions. Exclusive power to impose binding sanctions on UN members. First use, 1966, Rhodesia, Zimbabwe, embargo. Expanded use, 1977, South Africa arms embargo. Post-Cold War, sanctions became a common enforcement tool. _ 5.3.2.1 Targeted sanctions and better enforcement. Problems with comprehensive sanctions. Unintended humanitarian consequences. Affected civilians rather than governing elites. Example, Iraq, 1990s, 500,000 child deaths due to malnutrition and blocked vaccines. Ethical concerns. Boutros Ghali. Sanctions are a blunt instrument. Questionable whether civilians should suffer for elite political actions. Shift to smart sanctions. Designed to target political elites, not civilians. Forms of smart sanctions. 1. Selective embargoes, for example, military equipment. 2. Asset freezes. 3. International travel bans. 4. Blocking financial transactions of political figures. Next page. 5.3.1 Countermeasures in the collective interest. International law on countermeasures in the general or collective interest remains uncertain. Article 48 of the ILC Articles on State Responsibility, no clear entitlement for non-injured states to take countermeasures in the collective interest. Some states have rejected this restrictive approach, taking countermeasures without individual injury for breaches of erga omnes obligations. Institute of International Law, 2005 Krakow session. Recognized non-injured states' entitlement to adopt non-forcible countermeasures in response to grave breaches of erga omnes obligations. Article 5 of the resolution. If a widely acknowledged grave breach occurs, all states to whom the obligation is owed are entitled to take non-forcible countermeasures under conditions similar to those for an injured state. 5.3.2 Sanctions. Definition: measures, often economic, taken against a state breaching an international obligation. Sanctions include economic measures, trade restrictions, asset freezes, diplomatic measures, severance of relations, other coercive measures, travel bans, communication disruptions. Article 41 of the UN Charter. Security Council's authority can impose non-forcible measures to enforce decisions. Measures include economic interruptions and diplomatic severance. Open-ended provision allows additional measures beyond those listed. Binding nature. Chapter 7 decisions are binding on all UN members and override conflicting international agreements. Reserved for cases of threats to peace, breaches of peace, or acts of aggression. Article 39 determination required. Historical use. First used in 1966, mandatory embargo against Rhodesia. 1977, mandatory arms embargo against South Africa. Since the Cold War, sanctions have become a common peace enforcement tool. 5.3.2.1 Targeted sanctions and better enforcement. Issues with comprehensive sanctions can cause unintended humanitarian consequences, for example, Iraq in the 1990s, where 500,000 children reportedly died due to sanctions. Ethical concerns, civilian suffering versus targeting governing elites. Shift to smart/targeted sanctions. Aimed at political elites rather than civilians. Forms: military embargoes, asset freezes, travel bans, financial transaction restrictions. Challenges in enforcement. Political will. State capacity. Economic impact on enforcing states. Article 50 of the UN Charter allows states suffering economic hardship due to enforcing sanctions to seek relief from the Security Council. Invoked examples: Rhodesia, Zambia, Mozambique, Botswana, led to calls for international aid. 1990 Kuwait crisis, 20 states sought assistance due to Iraq sanctions. Yugoslavia, 1990s, 8 countries requested aid. Monitoring and enforcement improvements. 2000 UN Working Group examines sanction enforcement issues. Sanctions committees monitor and guide implementation. Calls for clearer objectives, better enforcement mechanisms, early identification of loopholes. 5.3.2.2 Counterterrorism measures and human rights considerations. Post 9/11 measures. Counterterrorism Committee, CTC, Security Council body, established. Counterterrorism Executive Directorate, CTED, since 2005, assists in compliance monitoring. Human rights concerns. Security Council urges compliance with due process, refugee law, and fair extradition procedures. 2005 World Summit Outcome Document. States must ensure fair procedures for listing/delisting individuals and counterterrorism sanctions. CADI cases, ECJ jurisprudence on sanctions and human rights, CADI, European Court of Justice, ECJ. Applicant, suspected Al-Qaeda affiliate, challenged EU regulations implementing UN sanctions. Court of First Instance, CFI, ruling. Security Council resolutions under Chapter 7 are binding. National and EU courts cannot review such resolutions. Indirect review allowed via Jules Coggins Human Rights Principles. No fundamental rights violation found in this case. Grand Chamber's ruling on appeal. UN resolutions do not automatically override EU legal order. EU courts must ensure compliance with fundamental rights. EU authorities must provide affected individuals with reasons for listing and allow contestation. CADI 2. Grand Chamber's ruling on further review. Following CADI, the Sanctions Committee issued a narrative summary explaining CADI's listing. Applicant challenged the summary as insufficient, as the underlying evidence was not disclosed. Court of First Instance, CFI, ruling. EU violated effective judicial review rights by failing to disclose evidence or allow CADI to contest the listing. Grand Chamber's ruling on appeal. Effective judicial review requires disclosure of at least the summary of reasons. If listing is contested, competent authorities must examine the evidence carefully. If evidence is not provided, courts must rule based on available material only. Courts should annul listings based on unsubstantiated evidence. Key takeaways. Countermeasures in the collective interest remain unsettled in international law, though some bodies have supported them for erga omnes breaches. Sanctions, Article 41 UN Charter, are widely used but must be carefully enforced. Designed to minimize unintended humanitarian consequences. Article 50 UN Charter provides relief for states economically harmed by sanctions enforcement. Counterterrorism sanctions must comply with human rights obligations. ECJ rulings, CADI I and II, affirm the requirement for effective judicial review and transparency in sanction listings. Next page. 5.3.2.3 Unilateral and regional sanctions. 1. UN Charter and unilateral sanctions. Under Article 41 of the UN Charter, the imposition of sanctions is an exclusive power of the UN Security Council. Despite this, individual states frequently impose economic sanctions unilaterally for perceived violations of international law. 2. Examples of unilateral and regional sanctions. United States, economic sanctions against North Korea, nuclear threat, and Iran, prevent nuclear development. European Union, sanctions on Russia for annexing Crimea, 2014, and destabilizing Ukraine. ECOWAS, sanctions against Togo, 2005, to counter unconstitutional government takeovers. 3. Legal issues with unilateral sanctions. I. Are unilateral sanctions lawful? Argument against legality. The UN Charter does not explicitly authorize unilateral sanctions. Violates principles of international law, including state sovereignty, territorial integrity, non-intervention, and peaceful dispute resolution. Counterargument. The absence of express authorization does not mean unilateral sanctions are prohibited under international law. There is no binding international rule banning unilateral sanctions per se. 2. Do unilateral sanctions qualify as countermeasures? International Law Commissions, ILC, draft articles on state responsibility, DASR. Only an injured state may take countermeasures against a responsible state. Many unilateral sanctions are imposed without direct injury, making them difficult to justify under the law of countermeasures. Exception: Article 48 DASR allows non-injured states to invoke responsibility if an obligation is owed to a group of states or the international community, erga omnes obligations. 4. Human rights limitations on unilateral sanctions. Committee on Economic, Social and Cultural Rights, 1997. Sanctions must comply with the International Covenant on Economic, Social and Cultural Rights, 1966. Sanctions should not violate fundamental human rights. UN Human Rights Council, 2019. Strongly condemns unilateral coercive measures that coerce a state into surrendering its sovereign rights. Asserts that unilateral sanctions contradict international law and humanitarian principles. However, this broad prohibition lacks legal justification under international law. Targeted sanctions, against individuals or entities, may not violate international law due to the absence of a clear prohibition. Next. 5.3.2.3 Unilateral and Regional Sanctions. Article 41 of the UN Charter grants the Security Council exclusive authority to impose sanctions. Unilateral sanctions. States sometimes impose economic sanctions independently for perceived breaches of international law, for example, U.S. sanctions on North Korea and Iran. Regional sanctions. Regional organizations, for example, EU, ECOWAS, impose sanctions for political or security reasons. Legal issues with unilateral sanctions. Lawfulness debate. Some argue unilateral sanctions are unlawful since the UN Charter only recognizes collective sanctions. Countermeasures. Unilateral sanctions may not qualify as lawful countermeasures under ILC draft articles on state responsibility, DASR, unless justified under Article 48, erga omnes obligations. Human rights limitations. Economic sanctions must comply with International Covenant on Economic, Social and Cultural Rights, ICCR. UN Human Rights Council, 2019 resolution. Condemned unilateral coercive measures as violating state sovereignty and international law. Differentiation, traditional indiscriminate sanctions versus targeted sanctions against individuals/entities. Underscore. 5.4 Use of force. Article 2.4 of the UN Charter prohibits the use of force, Zhukogan's norm. Exceptions under the UN Charter. 1. Security Council Authorization, Chapter 7, Article 42, for collective security measures. 2. Self-defense, Article 51, when a state suffers an armed attack. Underscore. 5.4.1 The collective security option. Security Council's primary role, maintaining international peace and security under Article 24. Article 42, allows military enforcement when Article 41, non-military measures, is inadequate. Preconditions for force under Article 42. 1. Article 39 Determination, identifying a threat to peace, breach of peace, or act of aggression. 2. Necessity assessment, confirming Article 41 measures are insufficient. Threats to international peace and security, Security Council discretion. Armed conflicts. Human rights violations. Terrorism. Health crises, for example, Ebola outbreak, breach of the peace. Objectively determinable, for example, military invasion like Iraq's 1990 invasion of Kuwait. Act of aggression, UNGA 1974 definition. Article 1, use of armed force violating sovereignty, territorial integrity, or political independence. Article 2, first use of force is prima facie evidence of aggression. Article 3, aggression includes direct and indirect actions, for example, sending armed groups, mercenaries. Nicaragua case, ICJ, assistance to rebel groups does not necessarily amount to use of force. Crime of aggression, Rome Statute, Article 8 bis. Individual criminal liability for those directing aggression requires a manifest violation of the UN Charter. Next. Page. 5.4.2 Challenges in the use of force for international peace and security. 1. Veto power of the Permanent 5, P5, Security Council decisions under Chapter 7 are subject to the veto power of the 5 permanent members, China, France, Russia, the UK, and the US. If a veto is exercised, no enforcement action can be authorized, preventing UN member states from acting under Security Council authority. Example, deadlock in the Security Council due to vetoes on Syria-related resolutions. 2. Ambiguous and open-ended mandates. Broad mandates in Security Council resolutions lack clear limitations and can lead to misuse of force. Example, Security Council Resolution 678, 1990, during the Gulf War, which authorized force to restore peace but lacked specific operational limits. Some states continued military actions against Iraq long after the conflict ended. 3. Absence of binding Article 43 agreements. Article 43(1) of the UN Charter requires UN member states to provide military forces to the Security Council under special agreements. Problem: these agreements were never concluded, making UN enforcement action dependent on voluntary state contributions. Article 45, intended to establish immediately available national Air Force contingents for urgent military measures, but never implemented. Consequence: no UN standing military force. Ad hoc troop contributions required for every military operation. Reliance on voluntary cooperation limits the UN's ability to act swiftly. 4. Reliance on ad hoc troop contributions. Without a permanent UN military force, the organization must negotiate contributions from member states for each mission. Challenges: delays in deployment due to political and logistical negotiations. Uneven troop contributions, leading to under-resourced operations. State reluctance to provide troops for controversial interventions. Next page. 5.4.2 The role of regional arrangements and agencies. 1. Legal basis for regional arrangements. Chapter 8 of the UN Charter provides for regional organizations to assist in maintaining international peace and security. Article 52(1) allows for the existence of regional arrangements or agencies if they align with UN purposes and principles. 2. Relationship between regional organizations and the Security Council. Article 53. The Security Council may utilize regional organizations for enforcement action. No enforcement action can be taken without Security Council authorization. Regional organizations must keep the Security Council fully informed of their actions. 3. Interpretation of regional and arrangement/agency. Regional does not necessarily mean geographical proximity but rather close and reliable ties among member states. Arrangement versus agency. The distinction is not significant. The terms regional and sub-regional organizations are often used instead. A Chapter 8 entity must have some permanence rather than being an ad hoc coalition. Example, the ICJ ruled in the Nicaragua case that the Contadora Group, Colombia, Mexico, Panama, and Venezuela, was not a regional arrangement under Chapter 8. 4. Recognized Chapter 8 organizations. Organizations with Chapter 8 status include Organization of American States, OAS, League of Arab States, LAS, African Union, AU, Organization for Security and Cooperation in Europe, OSCE, European Union, EU, North Atlantic Treaty Organization, NATO, Economic Community of West African States, ECOWAS, Association of Southeast Asian Nations, ASEAN. 5. Requirement for Security Council authorization. Article 53 requires prior Security Council authorization for enforcement actions. Debate exists on whether ex post facto authorization is valid. The dominant view: prior authorization is necessary to prevent regional organizations from initiating force in hopes of later approval. If authorization is post facto, the Security Council loses control over the scope and purpose of the action. Actions may exceed UN Charter limits on the use of force. 6. Example, ECOWAS in Liberia, 1990, ECOWAS deployed ECOMOG to end the Liberian Civil War, 1989-2003. Issue: ECOWAS acted without prior Security Council authorization, raising questions about compliance with Article 53. Next page. 5.4.2 The role of regional arrangements and agencies, continued. 7. Ex post facto authorization, ECOWAS and Sierra Leone. ECOWAS intervention in Liberia, 1990, occurred without prior Security Council authorization. Later, Security Council statements, 1991, 1992, recognized ECOMOG's actions, followed by a resolution commending ECOWAS. Scholarly debate. The vague language does not clearly indicate ex post facto authorization. Lack of explicit rejection by the Security Council suggests implicit approval. ECOWAS enforcement in Sierra Leone, 1997. Security Council explicitly authorized ECOWAS to enforce an arms and petroleum embargo under Chapter 8. Clear limitations: the embargo would end once the democratic government was restored. Issue: ECOMOG continued operations beyond the embargo period, until 2000. Security Council commended ECOMOG's actions but did not reference Chapter 8, leaving the legal status uncertain. 8. The debate on Security Council authorization. Two competing views on authorization under Article 53. 1. Explicit authorization is required. Prevents legal uncertainty and maintains Security Council control over regional enforcement. Avoids potential abuse by regional organizations. 2. Implicit authorization may be sufficient. Security Council practice suggests tacit approval is sometimes used for political and diplomatic reasons. In cases of tacit approval, resolutions should contain language implying authorization and be supported by all 5 permanent members. 9. NATO air campaign in Kosovo, 1999. Crisis in Kosovo escalated. NATO considered airstrikes against Yugoslavia. Russia and China threatened to veto any Security Council resolution authorizing force. NATO proceeded without Security Council authorization, conducting bombing campaigns, March to May 1999. Legal controversy. Some states justified the intervention on humanitarian grounds. However, there was general agreement that it was illegal under international law. An independent commission ruled. Illegal but legitimate, no Security Council approval, but justified due to exhausted diplomacy and the humanitarian crisis. 10. African Union, AU, and humanitarian intervention. Article 4H of the AU Constitutive Act, 2000. AU has the right to intervene in member states in cases of war crimes, genocide, and crimes against humanity. Other AU instruments reinforcing this right. Article 4K of the 2002 Astronomical Units Peace and Security Council Protocol. Article 8 of the 2009 Kampala Convention on Internally Displaced Persons. No explicit reference to Article 53 of the UN Charter, which requires Security Council authorization. 11. AU intervention and UN Charter compliance. Intervention with the state's consent. No need for Security Council authorization if the host government invites the intervention. Limitation: the government must be legally recognized and its consent must be clear. Intervention against a government, for example, in response to state-led atrocities. Article 103 of the UN Charter prevails over AU commitments. AU must comply with Article 53 unless Security Council authorization is impossible due to political deadlock, for example, a veto. 12. The challenge of Security Council deadlock. Urgent situations may require immediate action before the Security Council can authorize force. Problem of the veto. If a veto blocks Security Council action, should a regional organization stand by and allow atrocities to continue? UN Secretary-General's report on threats, challenges, and change examines this dilemma, acknowledging the need for solutions to prevent inaction in humanitarian crises. Next. Page 5.4.3 Self-defense. Legal basis of self-defense. The right to self-defense is the primary exception to the prohibition on the use of force. Article 51 of the UN Charter recognizes the inherent right of individual or collective self-defense if an armed attack occurs. Requires immediate reporting of self-defense actions to the Security Council, SC. Self-defense measures must cease once the SC takes necessary measures. Customary law on self-defense. Rooted in the Caroline incident, which established necessity, must be instant, overwhelming, leaving no choice of means, and no moment for deliberation. Proportionality, force must be comparable to the attack. ICJ Nicaragua case, 1986. Armed attack is a prerequisite for self-defense. A mere threat does not justify the use of force. Sending armed groups, for example, irregular forces, mercenaries, can constitute an armed attack if it meets a certain threshold. Conditions for collective self-defense. 1. An armed attack must occur. 2. The victim state must declare it has been attacked. 3. The victim state must request assistance. Failure to report self-defense actions does not automatically render them unlawful but can weaken the claim of self-defense. Nicaragua case. Necessity and proportionality. Necessity, use of force is a last resort when diplomatic or peaceful means are unavailable. Proportionality, response must be comparable in gravity and aimed at repelling the attack. Anticipatory and preemptive self-defense. Controversial, Some argue Article 51 incorporates the customary law position allowing preemptive action. Caroline incident established the principle that self-defense could be anticipatory. Restrictive interpretation. Article 51 requires an actual armed attack before self-defense is lawful. This view aligns with the UN Charter's restrictive approach to the use of force. ICJ and anticipatory self-defense. Nicaragua case, ICJ avoided ruling on imminent attacks. Armed activities case, DRC v Uganda. Article 51 justifies force only within its strict confines. States must use other means, such as appealing to the Security Council. 2004 UN High-Level Panel Report. Self-defense under Article 51 applies only if an attack is imminent, no other means exist, and the response is proportionate. Conclusion. Strict interpretation of Article 51 remains dominant in international law. Anticipatory self-defense is highly disputed and generally not accepted under the UN Charter. Next page. Flexible interpretation of Article 51. Arguments for a broader interpretation. Restrictive approach is unrealistic due to modern weapons, their destructive potential and speed of deployment. Technological developments may require a broader definition of an armed attack. Distinction between preemptive self-defense, action against an imminent or proximate threat. Anticipatory self-defense, preventive action against a non-imminent threat. High-level panel reports position. Preemptive self-defense, against imminent threats, may be justifiable, considering timing of response is critical due to weapon capabilities. Waiting for an actual attack may leave a state unable to defend itself. Anticipatory, preventive, self-defense requires Security Council authorization. If no decision is made, alternative strategies should be pursued first, for example, diplomacy, deterrence, containment. Next page. 5.4.4 Sources of controversy. The use of force in international law is considered a measure of last resort, often leading to controversy, especially when it falls outside Article 51 of the UN Charter. 6 key situations have frequently challenged legal interpretations of the acceptability and legality of force. 5.4.4.1 Rescue of own nationals. Use of force to rescue nationals abroad is controversial. Not justified under Article 51 of the UN Charter, may not qualify under customary international law on self-defense. Uncontroversial if host state consents, but problematic without consent. Key incidents. 1976 Entebbe incident, Israel in Uganda. Hijacking of an Air France plane by German and Arab terrorists. Uganda accused of aiding hijackers, denied by Uganda. Israel conducted a military rescue operation, killing hijackers and causing destruction. Legal reactions. Uganda called it an act of aggression. Israel justified under self-defense and failure of Uganda to protect hostages. Cameroon argued it violated territorial integrity. United States supported Israel, citing a limited right to protect nationals in an unwilling or unable state. Other cases. U.S. interventions. Dominican Republic, 1965, Grenada, 1983, Panama, 1989. UK intervention, Suez, 1956. Russia-Georgia conflict, 2008. Russia intervened in South Ossetia, citing the protection of Russian passport holders. Western states rejected this as a pretext for territorial expansion. 5.4.4.2 Humanitarian intervention. Use of force to prevent human rights violations or humanitarian catastrophes. One of the most controversial exceptions to the prohibition of force under Article 2.4 of the UN Charter. Key cases. Kosovo, 1999. NATO bombed Yugoslavia without Security Council approval. UK justified the action as a necessary humanitarian intervention. Opposition. Critics argued only the Security Council could authorize force under Chapter 7 of the UN Charter. Russia and China threatened veto, blocking formal approval. Libya, 2011. Popular uprising against Muammar Gaddafi. UN Security Council condemned human rights violations. Resolution under Chapter 7 authorized force to protect civilians and enforce a no-fly zone. Invoked responsibility to protect, R2P, reminding Libya of its duty to protect its population. Legal and moral debate. Arguments for humanitarian intervention. Morally required in cases of oppressive regimes. UN Charter values, human rights and fundamental freedoms, support intervention. Increasing recognition of human rights in international law. ICJ ruling, Nicaragua case. Use of force cannot be justified for human rights protection. Military actions, for example, mining ports, arming rebels, contradict humanitarian objectives. Next page. 5.4.4.2.1 Charter Prohibition on Use of Force, Challenges and Controversies. Legal and moral tensions in Article 2.4 of the UN Charter. ICJ ruling on Nicaragua case, U.S. argument on human rights preservation rejected as justification for intervention, conflicting with the right to collective self-defense. Strict versus broad interpretation of Article 2.4. Strict interpretation limits use of force to self-defense and Security Council authorization. Broad interpretation considers human rights, morality, and global public order. Concern: a strict prohibition could leave communities vulnerable to oppressive regimes. Counter-argument: expanding justifications for intervention risks abuse by states under the guise of protecting higher values. Humanitarian intervention and its legal challenges. Extreme cases for military intervention. Some argue intervention is necessary when human rights violations pose an immediate threat to mass civilian lives. Opposition to humanitarian intervention. Risk of misuse for political or economic motives. History of ineffective interventions. Potential erosion of Article 2.4 principles. Case studies on humanitarian intervention. Kosovo, 1999, preceding events. Reports of mass human rights violations in 1997 to 1998. UN Security Council resolutions called for action but lacked enforcement. Yugoslav government refused international peace efforts. NATO bombing campaign. Lasted 78 days, aiming to stop Serbian war crimes. Controversial due to lack of Security Council authorization. Potential Article 53 violation. Russia and China likely to veto any authorization. Legal debate. Justified response to humanitarian crisis versus illegal use of force. Effectiveness and criticism. Failed to fully protect Kosovo Albanians. Disproportionate damage question intervention strategy. Rwanda, 1994, humanitarian catastrophe. 800,000 Tutsis killed in a genocide lasting 3 months. UN and African states failed to intervene. Refugee crisis further destabilized the region. Lessons from Rwanda. International community's inaction led to tragic consequences. Raises questions about the necessity of unilateral humanitarian intervention when global bodies fail. Libya, 2011, Security Council action. Resolution 1970, February 2011, recognized crimes against humanity, imposed arms embargo, travel bans, and ICC referral. Resolution 1973, March 2011, authorized all necessary measures to protect civilians. NATO intervention and regime change. NATO's airstrikes dismantled Gaddafi's military capabilities. Western leaders emphasized Gaddafi's removal. G8 summit declared Gaddafi's loss of legitimacy. Debate. Security Council authorization was for civilian protection, not regime change. Justification. Resolution 1973 allowed force against threats to civilians, arguably including the Gaddafi regime. Key legal and policy considerations. Security Council authorization and regime change. Broad interpretations of resolutions risk legitimizing forced political change. However, where regime actions directly threaten civilians, removal may align with intervention mandates. The risk of legalistic approaches. Falk argues strict adherence to Charter rules without considering political and humanitarian realities undermines international law. Calls for nuanced attention to context in legal decision-making. Conclusion: the ongoing dilemma. Legal versus practical considerations. Strict application of Article 2.4 may lead to inaction in crises like Rwanda. Expanding intervention rights risks misuse and erosion of state sovereignty. Future of international law. Need for clearer criteria on humanitarian intervention. Security Council authorization should be explicit and prevent broad reinterpretation. Balance between protecting human rights and maintaining international legal order. Next page. 5.4.4.2.2 Do instances of unilateral humanitarian intervention constitute state practice? The question concerns whether unilateral humanitarian interventions since 1945 constitute state practice for forming customary international law. State practice must show claims that actions are lawful based on a new customary law exception to the Charter prohibitions. No instances exist where intervening states explicitly claimed a customary law basis for humanitarian intervention. Even when interventions were justified on humanitarian grounds, they were never the sole reason, but mixed with other justifications. Conclusion: States are unwilling to discard the UN Charter's prohibition on force and collective security in favor of unilateral humanitarian intervention. In extreme humanitarian crises where UN action is blocked, states may accept humanitarian considerations as a mitigating factor in violations of the prohibition on force. 5.4.4.3 The responsibility to protect, R2P. R2P has replaced humanitarian intervention as the primary framework for international intervention in mass atrocity crimes. Developed in response to failures to prevent genocides and mass atrocities, for example, Rwanda 1994, Srebrenica 1995, NATO in Serbia 1999. 2001, International Commission on Intervention and State Sovereignty, ISIS, published the Responsibility to Protect report. Key principles of R2P. Sovereignty reconceptualized, states have the primary responsibility to protect their populations from atrocities. Residual international responsibility, if a state fails, the international community must act. Legal foundations. Concept of sovereignty. UN Security Council's responsibility for peace and security. Human rights obligations. State practice. 3 elements of R2P. Responsibility to prevent humanitarian crises. Responsibility to react to mass atrocities. Responsibility to rebuild post-intervention. UN recognition and development. 2004 UN High-Level Panel report recognized R2P as an emerging norm, shifting the focus from the right to intervene to the responsibility to protect. 2005 World Summit Outcome Document. UN members accepted R2P and committed to preventing genocide, war crimes, ethnic cleansing, and crimes against humanity. The international community, through the UN, must assist states in fulfilling their obligations. Security Council has the authority to take collective action under Chapter 7 of the UN Charter if states fail. Commitment to early warning systems and capacity building. Security Council endorsement. 2006. Resolution reaffirmed R2P in the context of civilian protection. Resolution on Sudan, UNMISS, recalled previous commitments to R2P. 2011, Resolution 1973 on Libya reaffirmed Libya's responsibility to protect civilians and authorized all necessary measures for protection. 2009, UN Secretary-General's report outlined a 3-pillar approach. 1. Prevention, state responsibility for early prevention of humanitarian crises. 2. Capacity building, international support for state compliance with obligations. 3. Decisive response, Security Council intervention when states fail to protect. R2P applies only to 4 crimes: genocide, war crimes, crimes against humanity, and ethnic cleansing. Military intervention under R2P requires Security Council authorization. Implementation and challenges. Post-2005 developments. Reports emphasized early warning systems, regional cooperation, and coordinated responses. Strengthening collaboration between national, regional, and international institutions remains crucial. Challenges in implementation. Libya, 2011, military success under R2P, but post-conflict failures led to instability, terrorism, and human rights abuses. Syria, 2011-present. Massive humanitarian crisis with 13 million in need of aid. Security Council unable to act due to Russia and China's veto, fearing regime change, as in Libya. Even without vetoes, military action unlikely due to Assad's strong military support. Highlights the balance of consequences. If intervention causes more harm than inaction, states hesitate to act. R2P and customary international law. No widely supported multilateral treaty on R2P. For R2P to become customary international law, it requires consistent state practice, widespread acceptance. Current state practice is limited, and actual implementation remains inconsistent. Next. It is evident immediately, first, that state practice in conformity with the doctrine is nascent and that, secondly, following the Security Council disagreements concerning the Libyan and Syrian cases such practice as there is neither recurrent nor widely observed. 370. Page. State practice supporting R2P is still in its early stages, nascent. Security Council disagreements over Libya and Syria have hindered the development of consistent state practice. Existing practice is neither recurrent nor widely observed, limiting R2P's evolution into a binding norm of customary international law. Next. Page. 5.4.4.4 The War on Terror and the Use of Force Against Non-State Actors. Impact of 9/11 on Self-Defense Interpretation. The 9/11 attacks reopened debates on anticipatory and preemptive self-defense. U.S. response included Operation Enduring Freedom, military intervention in Afghanistan to disrupt terrorist activities. 2002 National Security Strategy, aimed at preventing rogue states, Iran, Iraq, North Korea, and global terrorists from acquiring WMDs. U.S. justified action under Article 51 UN Charter, self-defense, raising questions about its applicability to non-state actors. Legal debates on self-defense against non-state actors. Article 51 is silent on whether an armed attack includes acts by non-state actors. Initial global support for U.S. response as self-defense, confirmed in UNSC Resolutions 1373, 2001, and 1368, 2001, reaffirmed self-defense against terrorism. However, subsequent cases suggest legal uncertainty. ICJ in Israel Wall Case, 2004, self-defense applies to state versus state conflicts, implying exclusion of non-state actors. ICJ in Armed Activities Case, avoided deciding on non-state actors' role in self-defense. Post 9/11, some states have asserted a broader right to self-defense against terrorist groups under Article 51. Challenges in attribution of terrorist acts to states. Debate shifted from the legality of self-defense against non-state actors to questions of necessity and proportionality. Counterview: Security Council/state practice cannot amend the UN Charter to permit self-defense against non-state actors. Issue of state involvement. If a state actively assists terrorist groups, self-defense may be justified against the state under international law. Nicaragua Case, 1986, held that indirect support does not necessarily constitute an armed attack under Article 51. U.S. justification for military action against the Taliban. Debate over whether the Taliban's support of al-Qaeda justified U.S. self-defense. No conclusive evidence of Taliban directing or controlling the 9/11 attacks. Post's argument: Taliban's provision of safe havens, funding, and knowledge of al-Qaeda's activities did not meet the Nicaragua test for effective control. UN Security Council resolutions, post 9/11. Resolution 1373 reaffirmed self-defense against terrorists but did not authorize force against states harboring them. Resolution condemning the Taliban, later, criticized its protection of al-Qaeda but did not authorize military force against it. Modern practice and evolving legal standards. Some states justify cross-border anti-terror operations by claiming the host state is unwilling or unable to prevent terrorist activities. Failed states cannot control their territories, leading to security threats. Example: U.S.-led Operation Inherent Resolve, 2014. Iraq requested U.S.-led intervention against ISIL. U.S. extended operations into Syria without Syrian government consent, citing self-defense under Article 51. Proposed legal shifts. Some suggest a looser standard for attributing terrorist actions to host states. A complicity threshold, below Nicaragua's effective control, could justify self-defense measures. Comparison to aiding and abetting liability in international law. Tensions with sovereignty in Article 24 UN Charter. Self-defense claims versus territorial integrity. Article 24 prohibits force against another state's sovereignty. Cross-border anti-terror operations risk violating this principle. Trend of increasing military action against terrorists in foreign states without explicit UNSC authorization. Key legal takeaways. No clear consensus on self-defense against non-state actors under Article 51. Attribution threshold remains debated, whether indirect state support justifies force. UNSC resolutions have condemned terrorist threats but generally stop short of authorizing force against host states. Growing state practice supports self-defense against terrorists in foreign states, but legality under international law remains contested. Next page. Self-defense and the use of force in failed states. 1. Failed states and the principle of sovereignty. Government institutions in failed states become too weak to maintain control, leading to anarchy, violence, and crime. Despite internal collapse, failed states retain sovereignty under international law. Example: Somalia's sovereignty upheld by the UN Security Council despite being under warlord control for over 20 years. The principle of non-intervention and prohibition on the use of force, Article 24 of the UN Charter, still applies. 2. Self-defense against non-state actors in failed states. Key issue: whether self-defense is justified when a failed state cannot control non-state actors operating from its territory. Judge Cummins' separate opinion, Armed Activities Case, DRC v. Uganda. Armed attacks by irregular groups still qualify as armed attacks under Article 51 of the UN Charter, even if not attributed to the territorial state. The right to self-defense exists even in the absence of a formal attacker state. 3. Restrictive versus permissive interpretations of self-defense. Restrictive view, Tlaidy. Article 51 is an exception to the prohibition of force under Article 24 and should be interpreted narrowly. The right to self-defense applies only to interstate conflicts. Individual self-defense is temporary and must cease once the UN Security Council intervenes. Use of force against non-state actors in another state requires that states consent. Permissive view, Rise. If a state is manifestly and persistently unwilling or unable to prevent non-state actor attacks, the victim state may use self-defense. If the territorial state actively supports non-state actors or loses control over its territory, self-defense may be justified. However, the territorial state should be given an opportunity to act before force is used. 4. Policy developments on self-defense against non-state actors. Chatham House Principles on the Use of Force in Self-Defense, 2004-2005. Self-defense under Article 51 applies to non-state actors. Conditions for self-defense. 1. The attack must be large-scale. 2. Force can only be used if the territorial state is unable or unwilling to stop the attack. 3. Force against the territorial state is justified only if necessary to stop the attack. Leiden Policy Recommendations on Counterterrorism, 2010. Endorse the Chatham House Principles. Confirm that non-state actors can be the target of self-defense actions. Bethlehem Principles on Self-Defense, 2012. States may act in self-defense against non-state actors in another state's territory without consent if 1. UN Security Council authorizes force under Chapter 7. 2. The territorial state colludes with non-state actors. 3. The territorial state is unable or unwilling to stop the threat. 5. State responsibility and attribution of non-state actor conduct. Nicaragua case, ICJ standard of attribution. A state is responsible if it directs or controls non-state actors. However, due to new security threats, there is debate on lowering the effective control standard. Draft Articles on State Responsibility, 2001, Article 9. If non-state actors take control of government institutions, their actions may be attributed to the state. In such cases, self-defense against the state may be justified. 6. Preemptive and anticipatory self-defense. The Bush Doctrine, 2002 U.S. National Security Strategy. Advocates preemptive self-defense against modern terrorism and WMD threats. Justify the 2001 U.S. military operations in Afghanistan and the 2003 Iraq invasion. Rejected by most states and scholars as inconsistent with international law. High-level panel report, UN interpretation of Article 51. Article 51 applies only to imminent threats. Preemptive strikes against non-imminent threats are not justified. States cannot expand self-defense beyond what is permitted under the UN Charter. Conclusion. The debate on self-defense against non-state actors in failed states continues. Some argue for broadening self-defense to cover non-state actors if the territorial state is unwilling or unable to act. Others advocate strict adherence to the state responsibility standard and Article 2 for restrictions. Preemptive self-defense remains highly controversial and is generally not accepted under international law. Next page. Self-defense and non-state actors in international law. 5.4.4.4 Failed states and self-defense. Government institutions in failed states collapse, leading to anarchy, violence, and the rise of terrorism, extremism, and organized crime. Despite loss of control, failed states retain sovereignty under Article 2.4 of the UN Charter. Armed activities, DRC v Uganda. Judge Cummins' separate opinion states that armed attacks by non-state actors still qualify as armed attacks even if they cannot be attributed to the territorial state. Interpretation of Article 51, UN Charter. Allows self-defense against non-state actors if their actions constitute an armed attack. Some scholars, for example, Tlaidy, argue that self-defense should apply only to interstate force. Counter-argument. If a state fails to prevent non-state actors' attacks, it could justify self-defense action against that state. Due diligence principle. States must take reasonable efforts to prevent harm but are not obligated to guarantee prevention. Self-defense is justified only if the state's failure is equivalent to active support or complete loss of control over non-state actors. State responsibility and attribution. Rise. If a state is persistently unwilling or unable to prevent attacks, Self-defense may be justified. Chatham House Principles, 2004-2005, self-defense against non-state actors is allowed if the attack is large-scale, the territorial state is unable or unwilling to address the threat. Use of force is necessary and proportionate. Leiden Policy Recommendations, 2010, reinforce Chatham House Principles. Bethlehem Principles, 2012, self-defense against non-state actors requires territorial state consent, unless Security Council authorizes force. The territorial state is colluding with non-state actors. The state is unwilling or unable to stop the threat. Nicaragua Case Standard, attribution requires proof that non-state actors were sent by or acted on behalf of the state. Some argue for a lowered attribution threshold if a state provides refuge or aid to non-state actors. Article 9, ILC Draft Articles on State Responsibility, 2001. If non-state actors exercise governmental authority due to state collapse, their conduct is considered state action, making them a valid target for self-defense. Preemptive and anticipatory self-defense. U.S. National Security Strategy, 2002, Bush Doctrine. Advocates preemptive self-defense against terrorist threats and WMD proliferation. Justifies U.S. military actions in Afghanistan, post-9/11, and Iraq, 2003. International law response largely rejects the Bush Doctrine. High-level panel report, UN, supports a restrictive interpretation of Article 51, allowing self-defense only for imminent threats. Preventive military action should be authorized by the Security Council rather than taken unilaterally. _ 5.4.4.5 Cyber warfare and self-defense. Increasing reliance on cyberspace has led to growing vulnerabilities to cyber attacks. UN bodies, Security Council, General Assembly, recognize cyber threats as a major security concern. World Summit on the Information Society, 2003 present. Focuses on cybersecurity and capacity building against cyber threats. Application of Article 51, UN Charter, to cyber attacks. The legality of self-defense depends on whether a cyber attack qualifies as an armed attack. Key factor: the attack must have physical consequences comparable to kinetic force. Attribution challenges. Cyber attacks often originate from private actors. Identifying the attacker is difficult, affecting the victim state's ability to respond. Future technology may improve attack attribution. _ 5.4.4.6 Peacekeeping versus enforcement action. Peacekeeping, a consent-based military action under the UN system, aims to maintain peace with minimal force. Not explicitly provided for in the UN Charter but derived from its functions. Historical evolution. Developed during the Cold War as a neutral alternative to enforcement action. Early peacekeeping missions. UNTSO, Palestine, 1949, UNEF, Egypt, 1956, ONUC, Congo, 1960, Basic Peacekeeping Principles. Requires host state consent. Must remain neutral, governed by UN resolutions and status of forces agreements, SOFA. Troop contributing countries place forces under UN command. Legal framework. UN forces enjoy immunities under 1946 Convention on Privileges and Immunities of the UN, 1994 Convention on Safety of UN Personnel, plus 2010 Optional Protocol. Post-Cold War challenges. Rise of intrastate conflicts, for example, armed militias using guerrilla tactics. Increased civilian casualties and state collapse. UN peacekeepers now handle complex operations beyond ceasefire monitoring. 1992 Security Council meeting. Requested the Secretary-General to propose improvements for UN peace and security efforts. _ These sections highlight the evolving interpretation of self-defense, including responses to failed states, non-state actors, cyber warfare, and the transformation of peacekeeping operations in international law. Next page. 5.4.4.5 Cyber warfare. Increasing global dependence on cyberspace has led to greater vulnerabilities. Cyber attacks can be conducted remotely by hackers, criminals, terrorists, and other actors. The UN Security Council, 2003, recognized terrorists' ability to exploit digital technologies. The UN General Assembly has expressed concerns about cybercrime and its impact on states. The World Summit on the Information Society, endorsed by the UNGA, monitors cyber threats and security trends. Legal perspective on cyber attacks. Whether a cyber attack qualifies as an armed attack under Article 51 of the UN Charter depends on its consequences. The type of weapon used is irrelevant, what matters is the scale and impact. If a cyber attack results in grave physical destruction, it could justify self-defense under Article 51. If a cyber attack is conducted by a private entity, issues of attribution arise. Challenges in identifying attackers make state responses difficult, though future technological advancements may improve attribution. _ 5.4.4.6 The blurring of peacekeeping and enforcement action. Peacekeeping. Military action used as a tool within the UN system. Consent-based, aimed at preserving peace with little to no use of force. Developed as an alternative to enforcement action, which imposes peace through force. Not explicitly provided for in the UN Charter but inferred from the General Assembly and Security Council's powers. Evolved due to the Cold War deadlock, which limited the Security Council's ability to take action. Early UN peacekeeping missions. UNTSO, 1949, Palestine, UNAJL, 1958, Lebanon, UNEF, 1956, Egypt-Israel conflict, ONUC, 1960, Congo crisis, current UN peacekeeping. Managed by the Department of Peacekeeping Operations, DPKO, 14 active peacekeeping operations, majority in Africa. Basic principles. Requires host state consent, differentiating it from enforcement. Neutrality. Peacekeepers cannot participate in conflicts. Mandate and Status of Forces Agreement, SOFA, regulate UN host state relations. UN agreements govern troop contributions and establish command structures. Legal framework. 1946 Convention on UN Privileges and Immunities. 1994 Convention on Safety of UN and Associated Personnel, plus 2010 Optional Protocol. Post-Cold War challenges. New conflicts involve interstate violence, militias, and guerrilla tactics. Civilians often become primary targets. State collapses lead to lawlessness, crime, and humanitarian crises. Modern peacekeeping mandates expanded beyond ceasefire monitoring. 1992, UN Secretary-General Boutros Ghali's Agenda for Peace. New activities defined. Preventive diplomacy. Peacemaking/peace enforcement. Peacekeeping. Post-conflict peacebuilding. Post-conflict peacebuilding includes disarmament, election monitoring, human rights protection, institutional reform. Peace enforcement proposal. More heavily armed units for certain situations. Operates under Article 40 of the UN Charter. Distinct from Article 43 forces, meant for aggression response. Poses challenges to traditional peacekeeping principles of consent and neutrality. Case studies. UNPROFOR, 1992, Yugoslav conflict. Initially had a broad mandate for peace and security. Expanded across 5 republics, each with unique challenges. Lacked resources and troop contributions. Restricted to self-defense, no enforcement authority. MONUSCO Intervention Brigade, 2013, DRC. Mandated under Chapter 7 of the UN Charter. Tasked with neutralizing armed groups and enhancing state authority. Included offensive military operations. Created as an exceptional case, not a new precedent. Supported by the African Union, AU, SADC, and the International Conference on the Great Lakes Region. MINUSMA, 2013, Mali. Established due to Mali's security crisis, Tuareg rebellion, terrorism, organized crime. Had a robust peacekeeping mandate allowing use of force beyond self-defense. Collaborated with French military, intervened at Mali's request. G5 Sahel Joint Force, Burkina Faso, Mali, Mauritania, Niger, Chad. G5 Force. Endorsed by AU. Peace and Security Council. Not established by the AU, questionable status under UN Charter Chapter 8. Functions as a coalition force against terrorism and crime. UN Security Council's flexible approach towards regional peace initiatives. Next page. Suggested further reading. Deep and Delilah, Arbitrators as Lawmakers, 2015, PhD thesis, University of Geneva. P.E. Dupont, Countermeasures in Collective Security, The Case of EU Sanctions Against Iran. 17 Journal of Conflict and Security Law, 2012, 301-336. Geoffroy Wine, United Nations in R. Wolfram, ed., Max Planck Encyclopedia of Public International Law, Volume 10, Oxford University Press, 2012, 195. R. Hatto, From Peacekeeping to Peacebuilding, The Evolution of the Role of the United Nations in Peace Operations. 95 International Review of the Red Cross, 2013, 495-515. Simaching, Emergence of New States in Africa and Territorial Dispute Resolution, The Role of the International Court of Justice. 13 Melbourne Journal of International Law, 2012, 462-504. Ekprukaki, The Problem of Enforcement in International Law, Countermeasures, The Non-Injured State and the Idea of International Community, London, Routledge, 2010. W. M. Reisman, The Diversity of Contemporary International Dispute Resolution. For Journal of International Dispute Resolution, 2013, 47-63. N. Casarias, The Tallinn Manual on the International Law Applicable to Cyber Warfare. 15 Yearbook of International Humanitarian Law, 2012, 19-43. M. Weller, ed., The Oxford Handbook of the Use of Force in International Law, Oxford University Press, 2015.